ಹೌದು, ಅದು ಆರ್ಡರ್ ಆಗಿದೆಯಂತೆ ಮೇಡಮ್, ಅದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ ಅವರು. ಅದು ಸೀನಿಯರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಏನೋ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಆಗಿದೆಯಂತೆ, ಅದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ. ಮೇಡಮ್ ನಿನ್ನೆ ಹೇಳಿದ್ರು, ನಿಮ್ದು ಬರ್ತಾರಾ? ಹೇಳಿದೀನಿ ನಾನು ನಿನ್ನೆ.
ಹಲೋ ಮೇಡಮ್, ಹಲೋ ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ.
ಆ ಲಿಸ್ಟ್ 2 ಅನ್ನ ಏನು ಮಾಡ್ತಾರೆ ತೆಕ್ಕೋತಾರ ಸಾಹೇಬ್ರು? ಅಲ್ಲ ಈಗಪ್ಪ
ಲಿಸ್ಟ್
2 ಅಲ್ಲಿ ನಾನು ಇದ್ದೀನಿ, ಒಂದು 14 ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಹೇಳ್ತೀನಿ ಸರ್, ಸಾಹೇಬ್ರು ಹೆಂಗ್ ಹೇಳ್ತಾರೋ ಹಂಗೆ.
ಸಾಮಾನ್ಯವ್ರು ತಗೊಳ್ಳಲ್ಲ ಕಾಣುತ್ತೆ, ಅದು ಹಿಯರಿಂಗು, ಫೈನಲ್ ಹಿಯರಿಂಗು. ಆಯ್ತು, ಬಂದಾಗ ನೋಡೋಣ. ಓಕೆ
ಹೇಳ್ತೀನಿ.
ಓಕೆ, ಐ ವಿಲ್ ವೇಟ್, ನೋಡೋಣ.
ಇಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲಪ್ಪ ಇಟ್ಟಿದ್ಯಾ ವೆಂಕಟೇಶ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಳ್ಕೊಡಿ, ಹೇಳಿದ್ದೀನಿ ಇಳ್ಕೊಡಿ. ಕೊಡಿ ಫೈಲ್. ಸ್ವಲ್ಪ ಫಸ್ಟ್ ಇದು ಕೊಡಿ. ಇದು ಬರೀ IFR ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಷ್ಟೇ, ಇದಾಗಿಲ್ಲ. ಆರ್ಡರ್ ಆಗ್ಬೇಕು. ನೀವು ಇಲ್ಲಿ ನಾನು ತಗೊಂತೀನಿ. ಏನೋ ರೀಕಾಲಿಂಗ ಇವೆಲ್ಲ ಮಾಡಲ್ಲ. ಸರ್ ಬಂದ್ಮೇಲೆ ಏನ್ ಬೇಕು ಹೇಳಿ. ಹೌದು, ಅದೆಲ್ಲಾನು ಕೋರ್ಟಲ್ಲಿ ಅವೆಂದೆ ಸರ್. ಬಂದ್ಮೇಲೆ ಕೇಳ್ತೀನಿ ಸರ್. ಸರ್ ಬಂದ್ಮೇಲೆ ಕೇಳ್ತೀನಿ ಸರ್, ನಂಗೂ ಗೊತ್ತಿಲ್ಲ ಸಾಹೇಬ್ರು ಹೆಂಗ್ ಹೇಳ್ತಾರೋ ಹಂಗೆ. ನೀವಾ ಅವ್ರ ಚೇಂಬರ್ ಕೊಟ್ರು. ಏನು ನಿಮ್ದು ಪೆನ್ಷನ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕರೆದಾಗ ನೀವು ಬನ್ನಿ. ಏನ್ ಪೆನ್ಷನ್ ಏನು? SRK ಶಾರುಖ್ ಖಾನ್. ನಾವೇ ಮಾಡ್ಬೇಕು, ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ, ಅವ್ರು ಮಾಡಲ್ಲ.
ಟೋಟಲ್ ನಂಬರ್ 11 ಏನು ಮೆಮೋ ಯಾಕೆ ನಮ್ ಕೋರ್ಟಲ್ಲಿ ಮೂವ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲೇ ಮೂವ್ ಮಾಡ್ಬೇಕು. ರೆಗ್ಯುಲರ್ ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್ ನಮ್ದು ಸರ್, ನಮ್ದು ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್. ಇನ್ಚಾರ್ಜ್ ನನಗೆ ಗೊತ್ತು. ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ? ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ, ಫ್ರೆಶ್ ಕೇಸ್ ಇದು. ಆಯ್ತು, ಮೆಮೋ ಎಲ್ಲ ಕೋರ್ಟಲ್ 11 ತಗೊಳ್ಳಿ. ಅವ್ರ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿ ಯಾವ್ದಾವ್ದು ಇದೆಯೋ ನೋಡಿ, ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಹಾಕಕ್ ಹೇಳಿ. FDP ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಏನು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಏನು FDP ನಲ್ಲಿ ಆರ್ಡರ್ ಕೊಡಲ್ಲ. 1 or 2 days ಏನು ನೋ ಪ್ರಾಬ್ಲಮ್. ಕೊಡಿ.
ಅವ್ರು ಕೊಡ್ತೀನಿ ಅದೊಂದ ಈಗ ಕೊಡ್ತೀನಿ ನಮ್ ಕೊಡ್ತೀನಿ.
ಹ್ಮ್
This ಕೊಡ್ತೀನಿ.
ಹ್ಮ್ ಹ್ಮ್ ಹಾ ಯಾವಾಗ ಹಾ ಏಟ್ ಇದೆ
ಡೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ ಇವ್ರು. ಸರಿ
8ನೇ ತಾರೀಕಿನ ಇರೋದೇ 3 ದಿವಸ ಅಲ್ಲ.
10.
ಹ್ಮ್ ಆಯ್ತ್ರಿ, ಇವತ್ತಾಗ್ಲೇ 6th, ನಾಳೆ 7th. ಹಾ ನಾಡಿದ್ದೇ ಐತಿದು. ಮತ್ತೆ ಯಾವಾಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಇರೋದು? ಮಂಡೇ ಆಗ್ಬೋದು. 8ನೇ ತಾರೀಕು ಕನ್ಸಿಡರ್ ಮಾಡೋದ್ ಬಿಡಿ. 8th ಫ್ರೈಡೆ. ಲೆಟ್ ಇಟ್ ಕಮ್ ಆನ್ ಫ್ರೈಡೆ. 6/5. ಹಾ ಹಾ ಸರಿ, ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ? ಏನ್ ಮಾಡಿದ್ರಿ? ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ? ಹಾ
ನಾಳೆಗ್ ಬೇಕು ಅಂತ.
ಅರ್ಜೆನ್ಸಿ ಏನೊಂದೆ ಫೆನ್ಸಿಂಗ್ ಹಾಕಿರಿ ಇನ್ನೂ ಒಳ್ಳೇದಲ್ಲ. ನಿಮ್ದೇ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಆದ್ರೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಫೆನ್ಸಿಂಗ್ ಯು ವುಡ್ ಗೆಟ್. ಹಾ ಅದನ್ನೇ ಹೇಳಿ. ಹಾ ಆಯ್ತು ನೋಡ್ರಿ, ನಾಡಿದ್ದ ಹಾಕ್ಸ್.
ಯಾವ್ದು ನಂಬರ್?
ನಂಬರ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
6581 ಅಂತ.
ಅಡ್ಮಿಷನ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ ನಾಳೆ?
ನಾಳೆಗ್ ಹಾಕ್ಬಿಡಿ ಇದ್ರಲ್ಲಿ.
ಹಾ
6581.
ಹಾ ಡೂಯಿಂಗ್ ಶೆಡ್ ಕಟ್ತಾ ಇದಾರೆ. ಆಯ್ತು ತೊಗೊಳ್ಳೇದು ನೋಡಿ, ಹಾಕ್ಸ್ರಿ. ನಾಡಿದ್ದ ಹಾಕ್ಸ್.
ಡೇಟ್ ಯಾವ್ದು? ನಾಳೆ-
RFA
ಇದೊಂದು
2008. ಹಾ ಹಾಕಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಎಲ್ಲ ಬರ್ತದೆ. ಹಾ ಆಯ್ತು ತೊಗೊಳ್ಳಿ, ಒಂದು ಡೇಟ್ ಹಾಕಿ ಮೇಡಮ್. ಫ್ರೈಡೆಗೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ.
ಆಯ್ತು. ಫ್ರೈಡೆ 8ನೇ ತಾರೀಕು.
ಹ್ಮ್
WP ನಮಗ್ ಬರಲ್ಲ.
WP ನಮ್ ಕೋಟಿಗಿಲ್ಲ. ಹ್ಮ್
WP ಬರಲ್ಲ.
36
ಹ್ಮ್
ಒಂದು ಅಕಾಮಿಡೇಷನ್.
ಒಂದ್ ನಿಮಿಷ, ಪೇಜ್ ವೈಸ್ ಕರ್ಸ್ತೀವಿ.
ಆ.
ಪೆನ್ಷನ್ ಮಾಡಿರುತ್ತೆ. ಹಾ ಅಷ್ಟೇ. ನಮ್ಮ ಮೆಮೋಸ್ ಎಲ್ಲ ಆಯ್ತಾ?
14%.
14% ಹೇಳಿ ಏನು? 14% ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದೀರಲ್ವಾ? ಮೊನ್ನೆ ಕೇಳಿದ್ನಲ್ಲ ನಮ್ಗೆ. ಅವತ್ತೆ ಹಾ ಕ್ಲಾರಿಫೈ ಮಾಡಿದೀರಾ? ಆಯ್ತು, ನಾಡಿದ್ದು ಹಾಕ್ಸಿ ನೋಡ್.
8ನೇ ತಾರೀಕು. 8ನೇ ತಾರೀಕು ಹಾಕ್ಸ್.
8ನೇ ತಾರೀಕು ನಿಮ್ಗಿರೋದು ಮಂಡೇ ಕೇಸು. 8ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಆಯ್ತು ಫ್ರೈಡೆ ಅಷ್ಟೇನಾ? ಹಾ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರಲಿ. ಹೇಳಿ ಈಗ ಯಾವ ಲಿಸ್ಟ್? ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನಮ್ದು ಕರೀರಿ, ಆಮೇಲೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇದ್ರೆ ಅದ್ರಲ್ಲಿ ತಗೊಳ್ಳಿ. ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ ಅವ್ರದ್ದು? ಟೋಟಲ್ ನಂಬರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲ ರೀ, 2 ಲಿಸ್ಟ್ ಇದೆ ಅಲ್ವಾ? ಕೊಡ್ತು ನಮ್ದು. ನಮ್ ಕೊಡ್ದ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕರೀರಿ ಫಸ್ಟ್.
ಲಿಸ್ಟ್ 1
29 and 30 ನಮ್ ಕೊಡ್ತಿದ್ಯಾ?
page 12 29 30 31 to 36.
31 to 36. ಯಾರು 36 ಯಾರೇ ನಮ್ಮ ಮೆನ್ಷನ್ ಮಾಡಿರಲ್ರಿ?
36.
ಹಾ
36.
36. ಹಾ ಹೇಳಿ, ಯಾರಿಗೆ ನೀವು?
ನಾನು respondent.
ಬರಲ್ಲ.
Kindly have it on
10.
Friday.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇದಾರಾ? ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ? ಹಾ ಯಾವ ಫ್ರೈಡೆ? ಈ ಫ್ರೈಡೆನಾ? ಈ ವಾರ ಇವತ್ತು ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ. ಇಫ್ ಬೋತ್ ಅಸಿಸ್ಟ್ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್, ಆರ್ ಅದರ್ವೈಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಂಡ್.
Next week.
ಹಾ ರೆಡಿ? ಹಾ ಆಯ್ತು, ರೆಡಿ ಆದ್ರೆ ಮಾಡಿ.
Serial
number
number
1 allowed and defendant number 6 to 11 are restrained from alienating the property.
House.
That is the order.
Number 35, my lords.
ಅವರು ರೆಡಿ ಅಂತೆ.
Serial number 35. my lords.
Engage the senior counsel.
ಆಯ್ತು, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಯಾರು ಮೆನ್ಷನ್ ಮಾಡಿರಲ್ಲ ಅವರೇನಾ? ಆಯ್ತು ಬರ್ಲಿ.
8ನೇ ತಾರೀಕು.
8ನೇ ತಾರೀಕು ಇಲ್ಲ ರೀ, ನಾನು ಆಲ್ರೆಡಿ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿರ್ತೀನಿ. ಮತ್ತೆ ರೀಚ್ ಆಗಲ್ಲ ಅವತ್ತು, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಒಂದು ಡೇಟ್ ಹೋದ್ರೆ
Next Tuesday.
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಆಗ್ಬೋದಾ? ಮಂಡೇ ಜಾಸ್ತಿ ಇದೆ ರೀ. ತೊಗೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time and counsel for the appellant is present. List is not on Tuesday. ಎಷ್ಟು ಮೇಡಮ್? 13th ಅಲ್ಲ? 13th ತುಂಬಾ ಇದೆ ನೋಡ್.
12.
12 11.
Serial number 35, my lords.
35 ಹೇಳಿ ಏನು?
I appear for the
dismissed. Disturbing the construction, So appellant counsel seeks time and counsel submits that already intimated counsel for caveat or counsel. List this matter on the other date kodi madam. Next week
14.
full ಜಾಸ್ತಿ ಇದೆನಾ ಆಯ್ತು ಹಾಕಿರಿ
14/11.
14/11
That's serial number 34, my lords. I apply for the appellant. I pray for
Serial
a
number?
week. Serial number 34.
34 ಹೇಳಿ ಏನು
I apply for the appellant.
ಎಲ್ಲಾರು ಟೈಮ್ ಕೇಳ್ರಿ ಏನ್ರಿ ಇದು
My lords, the counsel and record is diagnosed with herpes, my lords.
ಹಾ
As I advised 2 weeks rest, my lords.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ
We have informed, my lords.
ರಘುಪ್ರಸಾದ್ಗೆ
Yes, my lords.
ತೊಗೊಳ್ಳಿ appellant counsel seeks time on the ground that counsel on record is suffering from herpes and also intimated the counsel for R123 and hence list this matter on ಯಾವಾಗ ಬೇಕು ಹೇಳಿ
My lords, after a week, my lords. He's advised 2 weeks bed rest, my lords.
ವೀಕ್ ಅಂದ್ರೆ ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆದ್ಮೇಲೆ 21st
First.
21/11
Grateful, my lords.
37 and 38. 39 to 42.
41, my lords.
ಹ್ಮ್
I am for respond number 1, my lords.
ಹ್ಮ್
Senior ಅವ್ರದ್ದು ತಂದೆದು ಡೆತ್ ಸೆರೆಮನಿ ಇದೆ ಸ್ವಾಮಿ, ಮಂಗಳೂರು ಹೋಗಿದ್ದಾರೆ.
ಹ್ಮ್.
I already informed the other side. Next week.
2012
Is
MFA
one chance.
12 ವರ್ಷ ಆಯ್ತು ಇನ್ನು MFA ನಲ್ಲಿ ಟೈಮ್ ಕೇಳ್ತೀರಿ ನೀವೇ ಅಸಿಸ್ಟ್ ಮಾಡಿ
Sorry, ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವೇ ಅಸಿಸ್ಟ್ ಮಾಡಿ
ಅಲ್ಲ, ನನಗೆ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
Only appellant.
ನನ್ನ ಹತ್ರ ನನಗೆ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಗೊತ್ತಿಲ್ಲ
ಹಾ?
ಸ್ವಾಮಿ. ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಓದಿರ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಗೊತ್ತಾಗ್ತದೆ ಅದೇ ಆಫೀಸ್ ಬೇರೆ ಆಫೀಸ್
ಫೈಲ್ ಬೇರೆ
ಯು ಆರ್ ಫ್ರಮ್ ಸೇಮ್ ಆಫೀಸ್
ನೋ
ಹಾ?
ಬೇರೆ
ಸೀನಿಯರ್ ಇಲ್ಲ ಅಂತೀರಿ ಈಗ ನೋಡ್ರಿ ನಾನ್ ಬೇರೆ ಆಫೀಸ್
ಅವ್ರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರು.
ಹಾ?
ಅವ್ರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರು.
ಯು ಆರ್ ಲೈಯಿಂಗ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್
My lords.
ಸಾರಿ ಮೇಡಮ್.
ಹಾ?
ಐ ಅಪೋಲೈಸ್ ಮೇಡಮ್.
ಮಪಲಾಜಿ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿ ನೀವು ಈಗ ಹೇಳಿರಿ ಸೀನಿಯರ್ ಹುಷಾರ್ ಏನೋ ಸೀನಿಯರ್ಗೆ ಏನೋ
ಅವ್ರ ತಂದೆ
ಇದೆ
test ಮಾಡಿ.
ಮನೇಲಿ ಏನೋ ಕಾರ್ಯ ಇದೆ ಅಂದ್ರಿ ನಿಮ್ಗೇನಾಗಿತ್ತು ಓದ್ಕೊಳಕ್ಕೆ ನೋಡ್ serial number 41 appellant counsel seeks time and also submits that already intimated ಒಂಥರ ಹೆಂಗೆ ಅಂದ್ರೆ
Respond
ಇಬ್ರು ಲಾಯರ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಬಿಡೋದು ಒಂದ್ ಡೇಟ್ ಕೇಳೋದು
ಇಲ್ಲ
ಅಲ್ಲ ರೀ ಇದು 2012 ಮ್ಯಾಟ್ರ್ ರೀ ಅದು MFA ಮಿಸ್ಲೇನಿಯಸ್ ಅಪೀಲ್
ಹೌದು, ಒಂದ್ ಚಾನ್ಸ್. 14th or 15th.
intimated the counsel for R1 list this matter after December ಇದು ಜನವರಿಗೆ ಹಾಕಿ if they are not interested let it posted matter in the month of January
I am for respond number 1, my lord.
ನಾವೇನ್ ಮಾಡೋಣ ಅದಕ್ಕೆ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ
Please.
ಟೈಮ್ ಕೇಳ್ತಾ ಇರೋದು ಯಾರು ಮತ್ತೆ
Respond number 1, my lords.
ಈಗ ಯಾರು ಇವ್ರಿಗೆ ಪುಂಡಿಕಾ ಈಶ್ವರ್
ಅವ್ರು
ಭಟ್
ಈಶ್ವರ
ನೀವು
ಭಟ್
ಹೇಳಿದಿರಾ
inform ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಆಗ ನೋಡ್ರಿ ಮೇಡಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಿಕ್ಸ್ ಟೈಮ್ ಅಂತ ಹೇಳಿ ಯಾವ ಮಂತ್ ಎಂಟಲ್ಲಿ ಕೊಡಿ 27
27/11.
27 11
43 to 45.
ಆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡೋದು ನೀವುಗಳು ಬಂದು ಟೈಮ್ ಕೇಳೋದು
46 to 48. 49 to 54.
ಹೇಳಿ ಹೇಳಿ ಏನೋ ಬಾಬು ಫಾರ್ R1 and R2 ಅಂತಿದೆ ಅಲ್ಲ ಅವ್ರು ತೀರ್ಕೊಂಡು ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತ್ರಿ ಯಾವಾಗ ತೀರ್ಕೊಂಡಿದ್ದು ಶಿವಣ್ಣ ಅವರು ಮತ್ತೆ ಫೈಲ್ ಏನ್ ಅವರೇ ತಗೊಂಡೋಗ್ಬಿಟ್ರ ಜೊತೆಯ ನೋಡೇಟ್ ದಟ್ ಕೆನಾಟ್ ಬಿ ಎ ಗ್ರೌಂಡ್ ಮತ್ತೆ ನೋಡ್ ಗ್ರೌಂಡ್ 2008 16 ವರ್ಷ ಆಗಿದೆ ನೋ ಹಂಬಲ್ court is also humbly requesting you to argue the matter. This is the matter of the year 2008 ಹೇಳಿ 51 ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀರಿ ಹೇಳಿ ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಜೂನಿಯರ್ ಒಳ್ಳೆ ಅವಕಾಶ ಓದ್ಕೊ ಬರ್ಬೇಕು ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಕೋರ್ಟಿಗೆ ಆಯ್ತಾ ಹೇಳಿ ಓದ್ಕೊಳ್ಳಿ ಸಂಜೆ ಮಧ್ಯಾಹ್ನದವ್ರಿಗೆ ರೀಚ್ ಆಗೋದು ಮೋಸ್ಟ್ಲಿ 3 ಮೇಲೆ
My lord, serial.
Respondent counsel seeks time and counsel also submits that he has already intimated counsel for appellant. Is this matter
Serial number 50.
2013 ಅಲ್ಲ ಮೇಡಮ್ ಹಾಕಿ ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಿ ಹಾಕಿ
28/11.
28/11
Serial number 54, my lords.
ಹಾ ಹೇಳಿ
I appear for appellants, my lords.
Ah.
Pray for a week's time, my lords. There's
Why?
death in senior's family, my lords.
Huh?
There's a death in senior's family, my lords. That's why, my lords.
So appellant counsel seeks time on the ground that there is a bereavement in the family of the senior counsel. ಇವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ
ಮಾಡಿದೀನಿ, my lords.
and also intimated counsel for R1 ಚಿಕ್ಕನ್ ಕೊಡ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ
I have intimated.
hence is this matter on ಯಾವಾಗ ಬೇಕು
Any date, my lords.
ಅದು ಹಾಕಿ 28/11
Date for my lords.
2013 matter
Bill number 53, my lords. I am for
ಹೇಳಿ.
the appellant.
ಹಾ
Today I am filing an application for additional document, my lords. There are two documents I am
Other
filing.
side ಗೆ intimate
This
ಮಾಡಿದೀರಾ?
I have informed.
Appellant counsel, ನೀವು appellant counsel ಅಲ್ಲ?
This
Appellant counsel seeks time on the ground that he is going to file an application for
additional document, my lords.
additional documents and also intimated the counsel for respondent. And hence list this matter on ಯಾವಾಗ ಹಾಕ್ತೀರಿ application?
Today I'll file it.
ಕೂಡ ಆಯ್ತು. List this matter on 14/11.
Please. Oblige.
Your lordship, kindly, my lord.
55. ಒಂದೇ ಇರೋದು, ಮಿಕ್ಕಿದೆಲ್ಲ
55.
230.
Huh?
ಮಿಕ್ಕಿದೆಲ್ಲ 230.
55 remaining at 230.
List 2 call ಮಾಡಿ.
List
2 call ಮಾಡಿ.
ಕೊಡಿ.
List number 2.
ಇದಾರ ಅವ್ರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದಾರ?
ಇದಾರೆ.
ಕೊಡಿ.
Hearing on IA serial number 1. Halesh Arji.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದಾರೆ, ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
Responding based on.
ಹಾ. Serial number 1
Appear for the appellant.
appellant ಏನೋ early hearing ಇದೆ.
File
No,
ಮಾಡಿ.
so we have filed senior mother has been expired.
ಅರ್ಜೆಂಟ್ ಯಾವ್ದಾದ್ರು ಇದ್ರೆ ಯಾವ್ದಾದ್ರು ಎಂಟ್ರಿ ಮಾಡ್ರು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡೋಂಥದ್ದು ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲವರೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ. ನೋಡಿ ಮೇಡಮ್, ಏನಾದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದ್ರೆ ಆ ಪ್ರಕಾರ ಡೇಟ್ ಕೊಡಿ. ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಇದೆ?
16.
16 ಇದೆ. ಹಾ. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ IA 1/23 RSA ಅಲೋ ಮಾಡ್ಬೋದಲ್ಲ?
Hello, madam.
Huh?
Date one fix ಮಾಡಲ್ಲ.
ಹಾ. Heard the appellant counsel and also the counsel for respondent on IA number 1/23 and appeal of the year 2014 and almost a decade has been elapsed for consideration of first appeal and for the reasons stated in the accompanying application of probate IA is allowed.
Second list.
List the matter for final hearing. ಯಾವಾಗ? ಇಬ್ರು ಹೇಳ್ಬಿಡಿ, ನಿಮ್ ಡೇಟೇ ಹೋಗಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಆವತ್ತಿನ ದಿವಸ.
After 2 weeks, madam.
Huh?
After 2 weeks, any day.
28/11. ಹಾ.
Serial number 2.
ಅನಂತ ಕೃಷ್ಣಮೂರ್ತಿ. ಎಲ್ಲ ಏನೋ ಸ್ಟೆಪ್ಸ್ ಇದ್ದಂಗಿದೆ.
ಸರ್ ಇದು
ಯಾವ-
ಪೇಪರ್
ಯಾವ-
ಪಬ್ಲಿಕೇಶನ್
ಹಾ?
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದೀರಾ?
ಹಾ, ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ ಬ್ಯಾಂಗ್ಳೂರ್ ಎಡಿಷನ್.
Heard on IA 1/24 where prayer is sought to take out the notice in the paper publication by way of substituted service against the respondents as mentioned in the application and for the reasons stated in the accompanying application IA is allowed.
For taking
For
paper
take,
publication 25/11.
to take out the paper publication in a paper,
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ
Samyukta Karnataka,
ಬ್ಯಾಂಗ್ಳೂರ್ ಎಡಿಷನ್
Bangalore edition on or before
22/11.
22/11 and date is fixed for the appearance of the respondent
19th December.
19th December. ಇಲ್ಲೇನ ಬೇರೆಯವ್ರಿಗೆ
ಕೆಲವ್ರಿಗೆ-
ಏನೈತಿ ಹೇಳಿ,
ಕೆಲವ್ರಿಗೆ
ನಾನ್ ಟೇಕಿಂಗ್
ತಗೊಂಡಿಲ್ಲ sir
ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್
ಅವ್ರು.
ಸರ್ವಿಸ್ ಅಂತ
8 to 14 ತಗೊಂಡಿಲ್ಲ.
8 to 14 ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
ಆಮೇಲೆ
ಅಲ್ಲ ರೀ, ಈಗ್ಲೇ ಈಗ ಈ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳೋದ್ರಿಂದ ಈಗ 1.5 ತಿಂಗಳು ಹೋಗುತ್ತೆ. ಮತ್ತ ಅವ್ರಿಗೆ ಇನ್ನೊಂದ್ಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಯಾಕೆ 8 to 14? ಅವ್ರಿಗೂ ತಗೋಬೇಕಲ್ವಾ? ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಒಟ್ಟಿಗೆ ಆಗುತ್ತಲ್ಲ, 2 ಖರ್ಚು ಯಾಕೆ? ಅದು ಕೂಡ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸೇ ಇದೆ.
R7 to R14 ಇದೆ.
8 to 14. ಹಾ, ಅವ್ರಿಗೂ ತಗೋಬೇಕಲ್ಲ, ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಫಾರ್ ಕನ್ಸಿಡರಿಂಗ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ R8 to R14 ಆಲ್ಸೋ ಫಾರ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್.
ಅವ್ರಿಗೂ ತಗೋಬೇಕು. R1 and 48 ಡಿಸೀಸ್ಡ್ ಅಂತ ಬಂದಿದೆ, ಅವ್ರಿಗೂನು
And so also to take steps against R1 and R48 for bringing LRs.
ಪೇಪರ್ ಬುಕ್ ಹಾಕಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಅದ್ರೇನ್ ಆಗಿದೆ, ರಿಟರ್ನ್ ವಿತ್ ಪೋಸ್ಟಲ್ ಶರ
ಡಿಸೀಸ್ಡ್ ಅಂತ ಬಂದಿದೆ.
ಡಿಸೀಸ್ಡ್ ಅಂತ ಅವ್ರ ಮೇಲೆ ತಗೋಬೇಕು ಸ್ಟೆಪ್ಸ್. ಹಾ, ಡೇಟ್ ಕೊಡಿ. 8/11 ಕೊಡಿ. 8/11.
3.
ರಿಕಾಲಿಂಗ್ ದಿ ಆರ್ಡರ್ ಎಲ್ಲ ಅವರೇ ನೋಡ್ಲಿ.
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ಮೂರನೇದು ಡೇಟ್ ಕೊಡಿ.
ಕೊಡ್ಲಾ?
23 ಅದಲ್ಲ,
ಹಾ.
28/11. ನೆಕ್ಸ್ಟ್ RFA 78/24. ಇದು ಅಷ್ಟೇ ಸ್ಟೆಪ್ಸ್
ಎಲ್ಲಿ
ತಗೊಳ್ಬೇಕು. ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ. ಎಲ್ಲ ಹೊಸ RFAಗಳು ಒಂದ್ ವಾರ ಕೊಡಿ.
13/11.
13/11. 4
5.
5
PN ನಂಜಾರೆಡ್ಡಿ.
ಅಡ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ಬೇಡ ಮೇಡಮ್.
ಹಾ ಸರ್.
6 5 ಏನಾರು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದು. 5 5 ನೇ ಕರೀರಿ, ಯಾವಾಗ ಬೇಕು ಡೇಟ್ ಕೊಡಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11/11 ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 6
ಮಾಡ್ರಿ.
I'm appealing for the appellant.
ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಏನಾರು ಇದೆಯಾ ಅದರಲ್ಲಿ?
ಇದೆ ಸ್ವಾಮಿ, ನಾವು ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಹಾಕಿದ್ರಿ. ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. RFA 183 serial number 6.
Appeal for the appellant, my lord, extended the interim order.
ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಇದೆಯಾ?
Yes,
ಎಂಟ್ರಿ
ma'am.
ಮಾರ್ಡರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ಲಿಸ್ಟ್ ದಿಸ್, ನೀವು ಇದೀರಾ?
For disposal, it was kept today. Any
ಆಯ್ತು
start
ಇವತ್ತು
date?
ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11/11.
7,
7 to 13.
Ganesh Prasad.
You'll 7, I'm
ಹಾ.
appellate, respondent is present.
I pay for the respondent.
12/11 ಗೆ ಬೇರೆ matters ಇದೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಬೇಕು ಹೇಳ್ರಿ?
12th of November.
12th November.
12th ಬೇಕಾ?
Please.
Both council submits that matter will be listed on 12/11.
Nine.
This matter on 12/11.
Hearing.
Eight, Nayak Ramachandra Rama.
Respondent, my lord, 1 and 2.
Entry matter ಏನಾರು ಇದೆಯಾ? Entry matter granted earlier is extended till next date of hearing. List this matter on 14/11.
9,
You'll have to up-
Nine,
apply
Ganesh
for the
Prasad.
update. Yes, you'll have-
9 to 13, sir.
It
9
was
to
the
13.
same data?
ಹೌದು,
12/11.
12/11.
Please, 9 to 13. 13
9
ವರ್ಗೂ
to
ಇದೆ, sir.
13 ಎಲ್ಲ ಸೇಮ್?
Same, please, please.
9 to 13 entry matters ಏನಾರು ಇದೆಯಾ? ಇಲ್ಲ. ಆಯ್ತು.
Point.
13 ವರೆಗೂ ಸೇಮ್.
14,
Much okay.
14
14, I appeal for the appellant, my lord. 14.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ 2014. ಯಾವಾಗ ಬೇಕು? ಇಬ್ರು ಇದ್ದೀರಾ?
I am for the appellant.
ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವಾಗ್ಲ 2014. ಅವ್ರು ಮೋಸ್ಟ್ಲಿ ಅವ್ರಿಗೆ RFA ಕಮೆಂಟ್ಸ್ ಆಗೋದೇ 2014 ಇರ್ಬೇಕು. ಓಲ್ಡೆಸ್ಟ್ ಅಲ್ಲ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ಕೊಡಿ.
14, 11,
14/11.
16, 15,
15 minutes. I beg to appear for the
15
appellant.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
Any date, madam. Next
15/11.
15/11. Please, ma'am.
16,
Hearing,
16 Manasa
respondent-
B. Rao.
Respondent, 1.
ಹಾ 2016. ಯಾವಾಗ ಹಾಕ್ತೀರಾ ಮೇಡಮ್? 19/11. ಆಯ್ತು ಫಸ್ಟ್ ಲಿಸ್ಟ್.
ಅದ್ ಹಿಂದೆ.
ಮೊನ್ನೆ ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ ಮತ್ತೆ ಡಿಲೀಟ್ ಮಾಡಕ್ಕಲ್ಲ ಮೇಡಮ್ ಆ ಫೋಟೋನ. ಅವರಿಗೆ ನಾನೇ ಹೇಳಿದೀನಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಮೂವ್ ಯುವರ್ ಫೋಟೋ ಅಂತ. ಪ್ರಮೀಳಾ ನೇಸರ್ಗಿ ಅವರಿಗೆ ಹೇಳಿದೀನಿ ಲಾಸ್ಟ್ ಟೈಮ್. ವೈ ಪೀಪಲ್ have posted they post their photos in the ಇನ್ನೊಂದೇನಿದೆ ಅವ್ರು ಕೊಡ್ದ ಮಧ್ಯಾಹ್ನ 2:30 ನೋಡು. ಟೈಮಿಂಗ್ಸ್ ಇರುತ್ತಲ್ಲ ಅವ್ರು ಬರೋದು ಆವಾಗ್ಲೇ. ನಾನೇ ಮೊನ್ನೆ ಅಪಿಯರ್ ಆದಾಗ ಅವರಿಗೆ ಹೇಳಿದ್ದೀನಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಿಮಗೆ ರಿಮೂವ್ ಮಾಡಕ್ಕಾದ್ರೆ ರಿಮೂವ್ ಮಾಡ್ಬಿಡಿ.
Photo
ಹಾಗಲ್ವಾ? ನಿಮ್ಮ ಇವ್ರು ಕರೀರಿ ಅವ್ರನ್ನ.
List 1, non-compliance for first time, serial number 1, Kashinath JD.
ಕಂಪ್ಯೂಟರ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಕರ್ಸಿ.
Kindly, my lord. This, my lord, the
ಹೇಳ್ರಿ ಏನು?
minor office objection, my lord. During the course of the day, I'll comply it, my lord.
ಹಾ
Maybe, my lord, done Friday. The urgency is, my lord, the standing trees, my lord, their attempt to cut it. That's why, my lord.
ಏನ್ ಯಾರು ಮೆಮೋ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಟ್ರೀ ಅದಕ್ಕೆ ಮೆಮೋಗ್ ಅಲೋ ಮಾಡಿದ್ವಲ್ಲ.
ಹೌದು.
ಹಾ.
ಏನಾಗಿದೆ, the office objection is, my lord.
The council submits that is going to comply the office objection during the course of the day. List this matter on 8/11.
Kindly, my lord, along with, my lord, MFA number 4066 and 4039 of 2020.
Along with MFA list ಕೊಡಿ ಅವರಿಗೆ.
4066
4066
and 4039 of
Sir, barcode
2024.
39 ಆಯ್ತು ಬಿಡಿ 39 of
2024.
24 ಆಯ್ತು.
Second time non-compliance, serial number 2,
Nagesh
Yes.
S.
Week time, your lordship, pray for.
Council 6 weeks time and hence weeks time granted for compliance.
3,
J.K. Shetty. Letter for extension of time ಕೊಡಿ MFA. Sorry, I have perused the letter of PO. And it is noticed that earlier 9 months was granted to dispose of the suit in OS number 53 of 2015. And PO in the letter has stated that already 18 witnesses were examined and yet to complete the evidence of defendants by recording other witnesses. and seeks 6 months' time, and having taken note of number of witnesses are examined before the trial court, it is appropriate to grant another 4 months' time from today, since the suit is of the year 2015. Already 9 years has been elapsed, and no further time will be granted. The registry is directed to communicate this order to the PO forthwith. ಅಲ್ಲ ರೀ ಏನ್ರಿ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ 18 ವಿಟ್ನೆಸಸ್ ನೀವ್ಯಾರಿಗಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅಲ್ಲಿ ನಾವು
ಡಿಫೆಂಡೆಂಟ್ ಗೆ ವೈ ಯು ನಾಟ್ ಕಂಪ್ಲೀಟೆಡ್ ಯುವರ್ ಎವಿಡೆನ್ಸ್. ನೀವೆಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ? ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಎಂತ ರೀ 18 ಜನ ವಿಟ್ನೆಸಸ್? ಆಯ್ತು, 4 ತಿಂಗಳಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಹೋಗಿ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. The respective counsels are directed to assist the trial court in disposal of the matter in a time bound period of 4 months extended by this court.
4. Sharath
My
is
lord,
covered.
my lord, I appear for the respondent, my lord. My lord,
filing
yesterday I
of-
filed the wakalat. Would your lordships grant me 2 weeks' time? I have to file a statement of objection in this, my lord.
Plaintiff's appeal, my lord. My lords, they are misusing the court's process, my lords. The previous bench had taken a view. Therefore, to get the bench disabled, they got.
Earlier order
I am sorry, my lord, counsel is unwell. Therefore, he has given a no objection, my lord. He was virtually bedridden, my lord.
Harish Kumar MS for retirement is accepted since counsel Sri Anand H has filed NOC wakalat for respondent number 1 to 13. Registry is directed to delete the name, and counsel for respondents is absent, and objections also not filed by respondent number 1 to 3. In spite of time granted on 5/11/2020.
Yes, yes, my lord. I agree. Yesterday I have seen, my lord.
Respondent doesn't appear on the next date of hearing, the matter will be heard in his absence. Heli.
Please, my lord. My lord, what has happened yesterday has given a no objection to me. I will file a statement of objection. MFA itself is not maintainable because the gift deed which has been given to the, my lord, the appellant.
Whatever
That
it
has
may be,
been-
counsel, you file statement of objections.
Please,
You
my
have
lord,
to
please, my
take
lord,
an order on merits. Why
Please,
you
my
have not filed the objections from 2020?
ಅಲ್ಲ ನಿನ್ನೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ ವಿತ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್.
Last time
ಹೌದು, ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರು ಅವ್ರಿಗೆ.
29 ಇದೆಯಲ್ರಿ?
ಅಲ್ಲ, ಕೌನ್ಸಿಲ್ ಅವರು ಆನಂದ್ ಅವ್ರಿಗೆ ಬೆಡ್ ರಿಟರ್ನ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆನಂದ್
ನಿನ್ನೆ
has filed
ಕೊಟ್ಟಿದ್ರು ನನಗೆ.
ಮತ್ ನೀವ್ ಹಾಕಿದಿರಿ ಈಗ?
ನಾನು ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಅವ್ರಕ್ಕಿಂತ ಮುಂಚೆ ಮಣಿಯನ್ ಅವರು ಇದ್ರು. someone else was there and to get the bench
ಪ್ರತಿ hearing date ಅಲ್ಲಿ change
to
ಮಾಡ್ತಾರಲ್ಲ?
get the bench disabled because a contrary view was expressed. Judgment ಇದೆ covered. Justice Krishna Kumar Sabrad.
See, Jagdish submits that he has filed wakalat. Wakalat ಹಾಕಿದಿರಾ ಇಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. yesterday I have filed
He
it.
has filed the wakalat yesterday, and hence registry is directed to put up the wakalat and show the name of the counsel. List this matter on 13/11.
Obligement.
5.
Respondent 2 and 3.
Sayyid Kamaruddin.
For the petitioner, my lord, respondent number 4 is a tenant in the scheduled
Right,
property.
Memo is filed to dispense the notice against R4, and hence notice is dispensed against R4 at the risk of the appellant. Next
My lord, date may be fixed for the hearing on IA.
admission.
No, my lord, hearing on
Next week it could be disposed.
Admission.
This the matter on 14/11.
Serial number 6. Yeah, Anand.
For the appellant.
Non-compliance of office objection raised on IA 1/24. Held.
The original sale deed,
Sale deed
this is
copy
a sale deed
dated
is already in
31,
the
not
LCR.
forthcoming.
Original sale deed is already with the file of this honorable, but in the LCR ಅಲ್ಲಿ ಇದೆ.
LCR ಅಲ್ಲಿ ಇದೆಯಾ?
ಅದು ಇದೆ sir. I have mentioned in my para.
Original sale deed.
Para 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, page number 98. of
Already available in the
LCR in page number
LC.
98.
TCR. LCR ಅನ್ನಂಗಿಲ್ಲ.
Sorry, my lord. TCR in page number.
ಅದೊಂದೇ office objection.
ಅದೊಂದೇ
And hence office objection is overruled by accepting the submission of counsel. List the matter for consideration of IA 1/24. ಏನದ IA 1/24?
Production of documents.
Production of
ಅಲ್ಲಿ
documents.
trial court ಅಲ್ಲಿ we have produced the document. but
RFA 2010 ನಾನು ಎಷ್ಟು week ಅಲ್ಲಿ ಕೊಡಿ?
14.
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. ಅಂದ್ರೆ
ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಫೈಲ್ನ? ಹಾ?
Recently she has been expelled.
ಆಯ್ತು. ಆಯ್ತು. The appellant counsel files memo stating that respond number 2 is the legal heir of respond number 1 and no other legal heirs. Howda?
Please.
And hence memo is accepted. The appellant counsel is directed to amend the cast title in terms of the memo and file amended cast title within 1 week. And list this matter for admission ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
Has to be
List
listed
this
for
matter for final hearing on 28/11. ಒಂದು ವಾರದಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿ ಅಮೆಂಡೆಡ್ ಹಾಕಿ.
Please.
Eight.
Acceptance of findings recorded by the trial court additional.
And for the respondent number 1, 10 my lord.
Documents.
This matter.
Hmm.
My lord, sir, the report is submitted on 17/9/2024 recently. I have applied for certified copy in the trial court. They said file has been transmitted to this court. On 26/9, I have applied for certified copy. Kottila copy inna. I have to see the report.
Counsel appearing for the appellant would submit that he had applied for certified copy of findings of the trial court. And yet to receive the same. ಅದೇ report of finding.
Report on findings.
Findings recorded by the findings.
Findings.
And hence list this matter. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ತಗೊಳ್ತೀರಾ?
2 weeks, your lordship. 1 week or 2 weeks, whatever it is.
28/11.
Please, ma'am.
28/11.
ಆಯ್ತು.
28/11. ನಿಮಗೆ ಸಿಕ್ಕಿದೆಯಾ ಕಾಪಿ?
ನಮಗೂ ಸಿಕ್ಕಿಲ್ಲ.
ನೀವು ಅಪ್ಲೈ ಮಾಡಿದಿರಾ? ಆಯ್ತು. ಯಾವಾಗ ಅಪ್ಲೈ ಮಾಡಿದ್ ನೀವು?
26/9 ಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ.
26/9 ಅಲ್ಲಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇದುವರೆಗೂ ಕೊಟ್ಟಿಲ್ವಾ? ನವೆಂಬರ್ ವರ್ಗು?
ಇಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಏನಾಯ್ತು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಇಲ್ಲೇನೆ ಕಾಪಿ ಕೊಡಕ್ಕೆ 2 ತಿಂಗಳು ಬೇಕಾ? ಆಯ್ತು ನೋಡಿ, 28/11 ಅಷ್ಟ್ರೊಳಗೆ ಕೊಡಕ್ಕೆ ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಏನಾದ್ರು ಮತ್ತೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ಐ ವಿಲ್ ಇನಿಶಿಯೇಟ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್.
Serial number 9.
Grateful.
Steps to be taken in respect of deceased R1 and R3 since unserved cover returned as deceased.
ಹೌದು sir.
ಯಾವಾಗದು ರಿಟರ್ನ್ ಆಗಿರೋದು ನೋಡಿ? ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆಯಾ? ಫಸ್ಟ್ ಟೈಮ್ ಇರ್ಬೇಕು ನೋಡಿ ಇದ್ರಲ್ಲಿ, ಯಾಕೆಂದ್ರೆ ರಿಟರ್ನ್ ಅಂತಿದೆ. ಅಥವಾ ಹಿಂದೆ ಏನಾದ್ರು ಕೊಟ್ಟಿದೀವ ಡೇಟ್?
ಇಲ್ಲ ಸರ್, ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಅವ್ರಿಗೆ ಬರ್ತಾ ಇರೋದು.
ಅವ್ರಿಗೆ ಬರ್ತಾ ಇರೋದು. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ
ಬೇರೆಯವ್ರದಲ್ಲಿ 1 to 5 and 7 is no more ಅಂತ ಲಾಸ್ಟ್ ಬಂದಿದೆ.
ಅವರು ತೀರ್ಕೊಂಡಿದಾರ?
ಹೌದು ಸರ್.
ಹಾ,
ಅದಕ್ಕೆ ನೋಟ್
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಬಂದ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ. ಅದೇನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೋ ಮಾಡಿ. 9.
Serial number 10.
M. Shivaprakash accept
For respondent number 1, my lord.
first additional civil suit Bangalore Federal 23/6.
My lord, appearing for appellant.
Respondent number 1, the legal heirs of R1 has filed a writ petition in 19/7/25/23 challenging the report given by the trial court. The reason is, my lord, there were 2 branches approached this honorable court claiming legal heirs of R1, deceased R1. ಇಲ್ಲಿ the court,
ಇದೇನು ಲೀಗಲ್ ಹೇರ್ ಬಗ್ಗೆ
ಯಾರು ಅಂತ ಹೇಳಿ
ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಯಾರ ಬಗ್ಗೆ ಫೈಂಡಿಂಗ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ?
ಹೌದು ಸ್ವಾಮಿ. ಅಲ್ಲಿ
ಏನಾಯ್ತು?
ಅದು ರಿಪೋರ್ಟ್ ಇಬ್ರು ಲೀಗಲ್ ಏರ್ಸ್ ಅಂತ ಹೇಳಿ ರಿಪೋರ್ಟ್ ಕಳ್ಸಿಬಿಟ್ಟು ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲಿ. ಇಬ್ರು 2 ಬ್ರಾಂಚ್ ಲೀಗಲ್ ಏರ್ಸ್
ಅಂತ ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ ರಿಪೋರ್ಟ್ ಬಂತು ಸ್ವಾಮಿ.
ಆಯ್ತು.
ನಾವು ಅಗ್ರೀಡ್ ಬೈ ದಟ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ರಿಟ್ ಪಿಟಿಷನ್ ಇನ್ 19/7/25/23 ಯಾಕಂದ್ರೆ ನಾನು ಒಬ್ಬನೇ ಲೀಗಲ್ ಏರ್ಸ್.
ಆಯ್ತು, ಈಗ ಏನಾಯ್ತು ಈಗ ಅದು?
ಈಗ ಅದನ್ನ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅದು ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ಕ್ಲಬ್ ದಟ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿಸ್ RFA. ಯಾಕಂದ್ರೆ ಆ ಸ್ಕ್ರೂಟಿನಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತಾ ಇದೆ ಹೇಗೆ ತಗೊಳ್ಳೋದು ಅಂತ. ಸೂಟ್ ಇಸ್ ನಾಟ್ ಪೆಂಡಿಂಗ್ ಇನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ದ ಮ್ಯಾಟರ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
ಅಲ್ಲ ರೀ, ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸೈಡೆಡ್ ಬೈ ದಿ ರಿಟ್ ಕೋರ್ಟ್ ಓನ್ಲಿ.
ರಿಟ್ ಕೋರ್ಟ್ ಆದ್ರೆ ಇಲ್ಲಿ ಸ್ವಾಮಿ ಮ್ಯಾಟರ್ ಇಸ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಸೊ 2 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇರೆ ವ್ಯೂ ತಗೊಳ್ಬಹುದು.
ಆಯ್ತು, ಅದನ್ನ ಇದ್ರ ಜೊತೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ
ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್. ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ದಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್. They said it has to be referred to chief judges for referring this.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್
R1 yes.
Respondent counsel submits that against the report of the trial court, WP is filed and he made an application for posting of the writ petition along with this RFA, and the same is pending for consideration, and hence list this matter on 28/11.
Writ petition 19/7/25 mentioned.
ಆಯ್ತು, WP number
19/7/25/23 GMCP
19/7/25 of
23
GM clarification. GM.
Hearing on again.
ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಅಷ್ಟರೊಳಗೆ ಇಲ್ಲಿಗೆ ತರ್ಸ್ಕೊತೀರಾ? ಇಲ್ಲಿ ಇದನ್ನ ಅಲ್ಲಿಗೆ ತಗೊಂಡೋಗ್ಬಿಡಿ ಬೆಟ್ರು.
let the chief justice
Hearing on again 11. Narayan Swamy DK.
3 of 18 for condemnation of delay na. Madam,
Sir, ಇದು ಫೈಲಿಂಗ್ ಸರ್. ಇದು
filing there is a delay. ಹೌದು. ಏನ್ ಫೈಲಿಂಗ್?
Actually,
ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ಸ ಅಥವಾ ರಿಕಾಲಿಂಗ್ ಏನು?
ಫೈಲಿಂಗ್ ಅವರು ಪಿಟಿಷನರ್
MFA ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 1717 ದಿವಸ ಡಿಲೇ ಇದೆಯಾ?
ಅದು ಫಸ್ಟ್ ಕೇಸ್.
ಹಾ?
ಫಸ್ಟ್ ಕೇಸ್ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಅವರೇ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ರು. ದಟ್ ಅಪೀಲ್ ಹ್ಯಾಸ್ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಕಂಪ್ಲೇನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಹಾ.
ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ರೀಕಾಲಿಂಗ್ ದಟ್.
ಹಾ.
ಅದನ್ನ ಬಿಟ್ಬಿಟ್ರು ಮತ್ತೆ ಇನ್ನೊಂದು ಅಪೀಲ್ ಹಾಕಿದ್ರು.
ಫ್ರೆಶ್ ಅಪೀಲ್ ಹಾಕಿ
ಮತ್ತೆ ಫ್ರೆಶ್ ಅಪೀಲ್ ಹಾಕಿ ಅದನ್ನ ರೀಕಾಲೇ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕ್ಲಿಯರ್ ಮಾಡಿದೆ ಫ್ರೆಶ್ ಅಪೀಲ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಪೋಸ್ಟ್ ಆಗಿದ್ದಾಗ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕ್ಯೂರ್ ಮಾಡಿದೆ ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವಾಗಿನ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ.
ಪ್ಲೀಸ್
ದೆನ್ ಹೌ ಕ್ಯಾನ್ ಯು ಫೈಲ್ ಒನ್ ಮೋರ್ ಅಪೀಲ್
ಅದು ಬೈ
ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ರಿವೈವಿಂಗ್ ದಟ್ ಆರ್ಡರ್?
ಅಲ್ಲ ಅದು ಗೊತ್ತಾಗಿದೆ. ದಟ್ ಇಸ್
ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. 1717 ದಿವಸ ಡಿಲೇ ಇದೆ. ಹಾ.
delay reason is that this appellant is not the owner.
Whatever
Liability
it may
fixed
be,
against
you
the
would
owner.
have- whatever it may be, you would have given the reasons in the very same appeal
ಹೌದು
for
ಅದರಲ್ಲಿ
recalling the order. You cannot file one more independent appeal. ಹಾ. ತಗೊಳ್ಳಿ.
I will pursue that appeal only.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ. ತಗೊಳ್ಳಿ.
ಅಲ್ಲ ಅದು ಪುಟ್ ಅಪ್ ಆಗಿದೆ.
Connected ಒಂದೇನೋ ಇದೆಯಲ್ಲ ಅದೇ
ಅದೇ ಪುಟ್ ಅಪ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ವೀಕ್ the my lord regular court
ರಿಕಾಲ್ ಆಗಬೇಕು.
matter has been heard by.
ಅದ್ರಲ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕವ್ರಾ?
ಹೌದು
ಹಾ.
ಹೌದು.
ಮತ್ತೊಂದು ಕ್ರಾಬ್ ಇದೆ.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ನಿಂದ ಬಂದಿತ್ತು ಲಾಸ್ಟ್ ವೀಕ್. ಅವರು ಹಿಯರ್ ಮಾಡಿದ ಮೇಲೆ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿತ್ತು.
ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಬಂದ್ ಮತ್ತೆ ಈಗ?
ಅದೇನೋ ಬೈ ಮಿಸ್ಟೇಕ್ ಬಂದಿತ್ತು. ರೀಕಾಲಿಂಗ್ ಇರೋದ್ರಿಂದ ಮತ್ತೆ ಬಂದಿದೆ.
ರಿಕಾಲಿಂಗು ನಮ್ಮ ಮುಂದೆ ಬರಲ್ಲ, ಅದೇ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗುತ್ತೆ.
ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಿತ್ತು.
ಇಲ್ಲಿ ಇದೆಯಲ್ರಿ ಏನೋ ಬಿಫೋರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಂತ ಇದೆಯಲ್ಲ, ಹ್ಯಾವಿಂಗ್ ರೋಸ್ಟರ್.
ಅದು ಮೊದಲೇ ಆಗಿತ್ತು.
ಬಿಫೋರ್ ಸೀನಿಯರ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಹ್ಯಾವಿಂಗ್ ರೋಸ್ಟರ್ ಅಂತ ಇದೆ.
ಅದಾದ್ಮೇಲೆನೆ ಬರ್ತಾ ಇತ್ತು ಅವ್ರ ಮುಂದೆ.
ನಮಗೆ ರೋಸ್ಟರ್ ಇಲ್ವಲ್ಲ.
ಇಲ್ಲ.
ಫಸ್ಟ್ ಒನ್ MFA 244 And ತಗೊಳ್ಳಿ ಏನಾಯ್ತು ಮೇಡಮ್?
19th or
We had
20th.
applied ಅಲ್ಲ.
Wait,
Yet to apply the certified copy and hence directed to obtain the certified copy and furnish the copy of IA number 1/22 and also the main appeal forthwith. List this
Main
matter
appeal, sir.
for consideration of IA on
Main
29/11.
appeal, sir.
29/11.
30. Yes, Prasad.
64 days in filing. 64 or 66? ಏನ್ರಿ ಏನಾದ್ರು ತಕರಾರು ಇದೆಯಾ?
No.
Heard on IA 1/23 and there is a delay of 64 days in filing the appeal. And for the reason stated in the accompanying application and also not seriously objected. Condonation of delay and hence IA is allowed and delay of 64 days is condoned. Post the matter for admission on 19/11. 19/11.
But
19/11.
my lords, 20, it may be 20th, my lords.
20th ಆಯ್ತು 20th 11.
14.
14.
Nagaya.
Delay of 340 set aside LRs ಇರ್ಬೇಕು ನೋಡಿ.
Yes, of R1. Sir, no.
Notice ಹೋಗಿದ್ಯಾ?
Notice ಹೋಗ್ಬೇಕಾ?
ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. ಮೊದ್ಲ
For respondent,
ನಾರಾಯಣ್ ಭಟ್ R1 ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಿ ನೀವು.
we are filing the affidavit, notice not required.
Huh?
We are filing the affidavit for
ನೀವು ಅವ್ರ ಪರವಾಗಿ ವಕಾಲತ್ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಹಾ
Please.
ತಗೊಳ್ಳಿ.
That's the delay may be cut
Counsel.
on.
Counsel Narayan Bhatt has filed wakalat for R1A to D voluntarily and submits that no objections to allow the IA and hence IA 1/24 is allowed by condoning the delay of 311 days and also abatement is set aside and permitted to bring the LRs of R1 on record by allowing IA number 3/24. The appellant counsel is directed to amend the cast title and file amended appeal memo within 2 weeks from today.
Granted, others 50% deposit is to be
ಹಾ.
deposited.
ಮಾಡಿದಾರ ಡೆಪಾಸಿಟ್?
ಇಲ್ಲ
ಮಾಡಿದಿರ?
ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್
We need that.
and counsel for the appellant submits that they have deposited already 50% of the amount in terms of the order passed by this court and hence directed to produce the acknowledgement before the court. List this matter on 29/11.
They may be extended.
Interim order is extended till next date of hearing subject to deposit.
Please.
ಹೇಳಿ ಏನು?
50. GP Shastri.
IA 2/24 for schedule attachment. IA 3
My lord, the
vacating
matter was
stay.
settled for a 3
Huh?
crore 40 lakh. Yesterday we have sent a 10 lakh to the appellant's account. Remaining amount today, 24 lakhs will be transferred. For the settlement, it may be posted for some date.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ. Because we are purchasing the appellant's entire property.
On 22/10, my learned friend had undertaken to pay 32 lakhs to me.
ಕೊಡಿ ಹಿಂದಿನ ಆರ್ಡರ್ ಡೇಟ್ ಕೊಡ್ರಿ ಮೇಡಮ್.
Yesterday, he has transferred 10 lakhs to my account.
22/10/24. Settled for an amount of rupees
3 crores
3
20
crore
lakhs.
20 lakhs.
In fact, 3 crore 40 lakhs.
Hands to
That
3
the
crores
same
40.
is not been settled for an amount of 3 crore 20 lakhs. However, the counsel appearing for the respondents would submit that they are going to pay 10% out of rupees 3 crore 20 lakhs. 10% ಎಷ್ಟಾಗುತ್ತ್ರಿ?
ಅಲ್ಲ, actually 3 crore 40 lakhs ಒಮ್ಮೆ ಸೆಟ್ಲ್ ಆಗಿರೋದು. 3 crore 40 lakhs ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಅದಕ್ಕೆ
3 crore 40 lakhs ಗೆ.
ಹಾ.
ನಿನ್ನೆ 10 ಲಕ್ಷ ಕಳಿಸಿದೀವಿ ಸ್ವಾಮಿ. Today we are going to send remaining 24 lakhs.
That my learned,
ಇವತ್ತಿಗೆ ನೀವು 10% ಈ 3,20,00,000 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ, 3 ಕೋಟಿ 20 ಲಕ್ಷಕ್ಕೆ 10% ಕಳಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಎಷ್ಟಾಯ್ತು ಅಂತ ಕೇಳಿದ್ರು.
32 lakhs my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
Yesterday we have transferred 10 lakhs my lord. Today we are going to transfer it my lord.
ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತೀವಿ please.
ತಗೊಳ್ಳಿ. Appellant counsel, respondent counsel submits that already transferred 10 lakh and going to pay the balance of 10% today
we are going to transfer.
today and hence list this matter on. ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, ರಿಪೋರ್ಟ್ ಅಂತಂದ್ರೆ ಇದರಲ್ಲಿ
closure, date for closure may kindly be fixed.
because the appellant has to get the e-khata in her name my lord.
ಅದೆಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್
ಅಲ್ಲ, ಅದಾದ್ರೇನೆ ಇದ್ ಮಾಡಕ್ಕಾಗತ್ತೆ
list this matter on 14/11.
The order may kindly be fixed.
Huh?
Stay order may kindly be extended.
ಸ್ಟೇ ಆರ್ಡರ್ ಇದೆಯಾ?
ಹೌದು.
ಏನು?
not to construct upon the
ಅಂತ ಮಾಡಿದೀರಾ?
application.
ಎಂಟ್ರಿ ಮಾಡಿದೆ.
ಹೌದು.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ is extended till
Was
next day
not,
of hearing.
from last 2-3 days, it was not extended, my lord.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ is extended ಅಂತ ಇದೆಯಲ್ಲ. ಮಾಡಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ is extended till next date of hearing.
March, please.
ಪಾಟೀಲ್ ದಯಾನಂದ್ ಸುಬ್ರಾಯ ಗೌಡ.
Syllabus 60.
ಇಲ್ಲೇ ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್, ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಿತ್ತು.
LRs of R2 ನಾ?
ಹೌದು.
ಹೋಗಿಲ್ಲ.
ಹಾ.
They are not contesting respondents in this appeal. ಅದಕ್ಕಾಗಿ ಅವ್ರನ್ನ ಡಿಲೀಟ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದ್ರು. But original respondent was served unrepresented. ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಅದಕ್ಕಾಗಿ ಟೆಕ್ನಿಕಲ್ ನಾಟ್ ಟು ಪ್ರೊವೈಡ್ ಎನಿ ಟೆಕ್ನಿಕಲ್ ಡಿಫಿಕಲ್ಟಿ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದನ್ನ ಅಲೋ ಮಾಡಿ ಅವರಿಗೆ ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದಕ್ಕೆ ನಮ್ದೇನ್ ತಕರಾರು ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಟೈಮು ಅದರ್ ಸೈಡ್ ವಾಸ್ ವೆರಿ ಪರ್ಟಿಕ್ಯುಲರ್ ದಟ್ ಕೇಸ್ ನಡ್ಸೋದಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ, ಇವರು ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸಿಂಗ್ ಮಾಡಬಹುದು ಅದು ಇದು ಅಂತ ಹೇಳಲ್ಲ ಹೇಳಿದ್ರು ಅಂತ ಕಾಣುತ್ತೆ. ಅದಕ್ಕೆ
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ
Any of R2 was unrepresented before this court earlier.
ನೋಟಿಸ್ ಸರ್ವಾಗಿ he had remained
unrepresented. ಹೌದಲ್ಲ?
ಹೌದು.
ಈಗ LRs ಇದ್ದಾರೆ. LRs ಏನಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಬೋದಾ ಏನ? ನಮ್ಗೇನ್ ಗೊತ್ತಾಗ್ತದೆ?
ಅದೇ ಅದಕ್ಕೆ ಕೇಳ್ದೆ ನಾನು. ದಟ್ ಇಸ್
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ.
Milords, we have filed an application seeking vacating interim order for this reason, Milords. So, I just pass on this paper book file.
ಏನ್ ಹೇಳಿ MFA ಏನ್ ರಿಲೀಫ್ ಯಾರ ಮೇಲೆ ಕೇಳಿದ್ರು? ಅಲ್ಲ ಬೇಡ, ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ R2 ಇದಾರಲ್ಲ ಅವ್ರು ಎಷ್ಟು ಡಿಫೆಂಡ್ ನಂಬರ್ ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ಅಪಲೆಂಟ್?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 8.
Defendant number 1.
One,
Yes.
whether he had been represented before the lower court?
Yes. He was represented.
Here also notice was issued and unrepresented.
Milords, the application itself was filed. IA number 23 was filed.
Interim order grant ಆಗಿದೆಯಾ ಇಲ್ಲ?
Milords, interim order is granted in my favor. This is the second round of interim order which is granted in my favor. Milords, I'll just take your lordships to only 2 facts. Milords, IA number 5.
ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ
Please.
Whether the LRs of R1 are necessary or not?
Milords, for this application, they may not be necessary, Milords. For this application, they are not
What
necessary.
is the application filed before the trial court?
Milords, the application filed IA number 23 is not to carve the layout and not to sell the sites.
Not to?
Sell the sites.
That order against whom?
Milords, this is the order against the present appellants.
Appellants.
Yes.
The IA filed by whom earlier?
Milords, IA 23 is filed by the plaintiff. That is the present respondent before your lordships.
Was there any relief against D1 ಅಂತ ಕೇಳಿದೆ?
There was a relief against D1 in IA number 5, which was operative right from.
ಇಲ್ಲಿ impugned IA ಇದೆಯಲ್ಲ? Impugned IA ಅಲ್ಲಿ any prayer against defend number 1?
It is against the all defendants, Milords.
All the defendants.
All the defendants.
Then ಮತ್ತೆ ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ, ಪಾರ್ಟಿ ಬರ್ಬೇಕಲ್ಲ?
ಅಲ್ಲ ಈಗ ಅವ್ರಿಗೆ ಏನಂದ್ರೆ
in their absence how can the court
Milords, now Number 20. It has got a cascading effect and defendant number 1 and defendants. Defendant numbers 2 and 3.
ಆಯ್ತು, you can take the hand summons on the LRs of the R1 and place the same before the court next week.
Hand summons.
They are their own vendors. ಈಗ Milords, they are not even the vendors. Their own vendors, and Milords, they are not claiming even under any registered document or anything. Milords, it's a case of fraud played on the court. Milords, IA number 5 was filed in the present suit, which is a suit filed by me for specific purposes. Milords, there is some urgency, Milords. Let them.
The appellants have filed an IA 3/24 to 4/24 and 5/20. Of service, he did not choose to appear and contest the matter. In view of death, it is necessary to bring the LRs, and hence appellant counsel is directed to take hand summons against the LRs of R2 and file acknowledgement for having served the notice. List this matter on next Tuesday.
In addition, kindly order emergent notice also. ಯಾಕಂದ್ರೆ ಅವ್ರೀಗ they are in a position For everything, there is a blackmailing, ಇದು ಯಾರು ಏನ್ ಮಾಡೋದಕ್ಕೆ ಹೋದ್ರು.
ಏನಾರು ಮಾಡಿ ನೀವು ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಡಿ.
ಅಲ್ಲ ನಾವು ಅದನ್ನ ಸರ್ವಿಸ್
ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ನೀವು ಅದನ್ನೇ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ
ಅಷ್ಟು ಹಾಕ್ತೇವೆ. ಇನ್ ಅಡಿಷನ್ ಎಮರ್ಜೆಂಟ್
ನೋಟಿಸ್ ಹೋದ್ರೆ ಇನ್ನೊಂದು 10-15 ದಿವಸ ಆಗುತ್ತೆ. ಈಸ್ ಇನ್ ಹರಿ ಟು.
Lords, now the only difficulty is this, my lords. If whatever relief was granted in IA number 23, which is stated by this honorable court, is implemented, their appeal is successful. There is nothing for me. My IA 23 becomes infructuous.
Only 4 days time.
Lordships.
12-11.
interim order may kindly be.
Interim order.
Can it be an order of status quo instead, my lords?
Status quo is
Status
ಇಲ್ಲ, ಇಲ್ಲ,
quo.
status quo
Your
ಇಲ್ಲ,
lordships have granted.
ಈಗ interim order ಇದೆಯಾ?
ಹೌದು,
ಇದೆ.
interim order
Interim
ಇದೆ.
order is extended till next state of hearing.
70. R.B. Sadashivappa, H.P. Kumaraswamy.
They are non-filing of amended cast title in respect of impleading as proposed R12, wide order dated 22/10.
ಹಾಕಿದ್ದೀರಿ.
Amendment ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದೀನಿ.
Amendment ಆಗಿದೆ.
ಮಾಡಿದ್ದೀನಿ.
Sorry, the council submits that already filed amended cast title. Number 2 ಆಯ್ತು. Number 1 ಏನದು ಡೈರೆಕ್ಷನ್?
That
is non-amendment of cast title in respect of deceased R12.
ಅದು ಸರಿ ಮಾಡಾಕಿ.
MS ಶಾಂತಕುಮಾರ್ ಅಂತಿದೆ.
ಅದು ಸರಿ ಮಾಡಾಕಿದೆ.
ಅದನ್ನ ಸರಿ ಮಾಡಿ ನನ್ನೆ ಹಾಕಿದ್ದಾರೆ. Amended cost title ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತಿದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಿರಾ?
ಸರಿ ಮಾಡಿ ಹಾಕಿದೀವಿ.
ಸರಿ ಮಾಡೋದ್ ಬೇಡ್ರಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಿರಾ ಅಂತ ಕೇಳಿದೆ.
ಬರ್ದಿದ್ದೀವಿ. ಅಲ್ಲಿ
Amendment ಮಾಡಿ.
ಕೋರ್ಟ್ ಕಾಪಿ ಇರಲ್ವಾ ಮೇಡಮ್?
ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಿರೇನ್ರಿ? ಒರಿಜಿನಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಿರಾ? ಅದಕ್ಕೆ ಇರೋದು ಪಾಸ್ ಓವರ್ ನೋಡಿ. ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ, ದೆನ್ ವಿಲ್ ಕನ್ಸಿಡರ್. ಅಯ್ಯೇ ಆಮೇಲೆ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ಡ್ ಆನ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ R12 MS ಶಾಂತ, ಅದು ಕೂಡ ಇದೆ ನೋಡಿ. ಶಾಂತ್ ಕುಮಾರ್ ಅದೇ ಸೇಮ್, ಅದಕ್ಕೂ ಕೂಡ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ, ಅದ್ ನೋಡಿ ಅದೇನದು ನೋಡಿ.
ಇದು ಕ್ರಾಸ್ ಅಪೀಲ್ ಒಂದಿದೆ. ಕ್ರಾಸ್ ಅಪೀಸ್ ನಲ್ಲಿ ಏನು ನೋಟಿಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಕ್ರಾಸ್ ಅಪೀಲ್
ಹೌದು.
ಅದು ಇಟ್ಟಿರ್ತೀನಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಪಾಸ್ ಮುಂದಿನ ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿ. ಅದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಅಂತ ಇದೆ. ಅವ್ರು ಯಾರು ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ? ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ. ಇದ್ರಲ್ಲೂ ಕೂಡ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇದೆ.
18.
Also likely to be settled. It is also likely to be settled, therefore my lord.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಫಸ್ಟ್ ರೆಕಾರ್ಡ್ ಏನಿದೆ ಅದು ಸರಿ ಮಾಡಿ.
ಆಯ್ತು.
2005 ಅದು, ಅದಕ್ಕೆ
ಹೌದು. ಅಲ್ಲ
4
ಅದರಲ್ಲಿ 4
ರಾಬೋ 2005, RFA 2004.
4 ಜನ ಪಾರ್ಟೀಸ್ ಇದ್ರು, ಈಗ 40 ಆಗಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಇನ್ನು ಬಿಟ್ರೆ 80 ಆಗ್ತಾರ. ಇನ್ನೊಂದು 10 ವರ್ಷ ಇಟ್ಕೊಂಡು.
18.
For the appellant,
ಹೇಳ್ರಿ.
this application for recall has been filed. The order dated 20.
Calling the order 23/11/23 ಏನ್ ಆರ್ಡರ್
has been passed by a coordinate bench of this court.
ಹೇಳಿ ಏನಾದ್ರು. Appellant was earlier represented
The
by
appeal
Sri
was
Dinesh
dismissed
M.
for
Kulkarni.
non-prosecution.
As per the submissions made at the bar, this court issued court notice to the appellant by way of abundant caution. Court notice is not served to the appellant. Left with no other alternative, appeal stand dismissed for non-prosecution. ಹೇಳ್ರಿ ಏನು?
My lords, if it could be posted before the coordinate bench, my lords, because the order was passed by the coordinate bench.
ಏಕೆ ಅಲ್ಲೇ ಹಾಕ್ಬೇಕು ಅಂತ ಏನಾರು ಇದೆಯಾ?
ಹಂಗೆ I'll make submission.
ಹೇಳಿ ಏನು?
The
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇದು ಡಿಸ್ಮಿಸಲ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟು ಸರಿ ಅಪೇರ್ ಆಗಿದ್ರಿ ಹೇಳಿ?
my lords,
ಡಿಸ್ಮಿಸಲ್ ಆಗಿದ್ದು 23rd day of November 23.
howdo my lords, the notice we hadn't received from the court. We were given, I have filed a detailed affidavit, my lords, which is IA 1 of 24 for recall. That
ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಮೊದಲು ಅಡ್ವೊಕೇಟ್?
my lord, I was not represented.
Who was
Though
representing?
one counsel at that point of time was appearing, my lord, he has not appeared in the matter.
ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ?
And the party was not aware of.
Appellant is a religious institution at Shivamogga district represented by Swamiji. The appellant was earlier represented by Advocate Sri Dinesh M. Kulkarni, who is now practicing at Dharwad. And another advocate by name Sri P.S. Guruprasad ಅಂದ್ರೆ ಯಾರು ನೀವೇನಾ?
No, I am Keshav M. Bapar.
Who is said to be practicing at Davangere. On previous occasion, one T.S. Prasanna Kumar, who was present before the court, submitted that he is the secretary of appellant institution. And he was unable to contact the advocate Guru Prasad and Dinesh Kulkarni through telephone. Under the circumstances, issue court notice to the appellant. Attack appellant notice.
My lords, on 11/8/2023, if your lordships could peruse the order.
ಅಲ್ಲ ರೀ ನಿಮ್ ಸೆಕ್ರೆಟರಿ ರೆಗ್ಯುಲರ್ ಆಗಿ ಅಪಿಯರ್ ಆಗೋನಲ್ರಿ
Appear ಆಗಿದ್ದಾರೆ my lords, but subsequently.
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಈಗ ಲಾಯರ್ ಪ್ರಾಕ್ಟೀಸ್
My lords,
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
subsequently we obtained NOC wakalat
ಹಾ.
and we had given it to another lawyer. 7/9/2023, he was supposed to appear, but he has not filed the wakalat and appeared in the matter and not even informed us. That I have also averred at para 5. Para
Authorized
5
ಯಾರು ಇದ್ರಲ್ಲಿ?
my lords,
NR Nagaraj and Associates for R2 ಇದರ?
I have served them by post as well, but they've,
So
that has also been returned as.
Heard the appellant counsel on IA 1/24 for recalling the order dated 23/11/23. And copy is also served on the other side through registered post. And on perusal of the order dated 23rd day of November 23. And also earlier order sheet, notice was issued to the appellant. But notice was not served on the appellant. And the appeal was dismissed. The counsel appearing for the appellant would submit that though secretary was appeared before the court and obtained NOC from the earlier advocate and handed over the wakalat to counsel Sri.
Krishna Vyas, my lord, this is another advocate.
ಹೆಸರು ಏನ್ ಹೇಳಿ?
ನನ್ನ ಹೆಸರು is Keshav.
ನಿಮ್ಮ ಹೆಸರು ಬಿಡ್ರಿ ಯಾರಿಗೋ ವಕಾಲತ್ NOC
Krishna Vyas.
Krishna Vyas.
Krishna Vyas. Para 5 of my application.
Krishna Vyas. He did not file wakalat and also
Contest the matter.
appear before the court. And as a result, the appeal was dismissed. And the same is averred in paragraph number 5 of the affidavit.
5 and 6.
5 and 6 of the affidavit. And taking into note of the averments made in the affidavit as well as this court. Once notice was issued to the appellant and the same was not served on the appellant, but court ventured to dismiss the appeal and ought to have reissued the notice to the appellant. And instead of dismiss the same, and hence there are grounds to recall the order dated 23rd day of November 23. And hence delay is condoned and IA 1/24 is allowed by recalling the order dated 23/11/23. Subject to condition that the appellant counsel, now who is on record, argue the matter on merits without seeking any adjournment in the next state of hearing, dismiss this matter on 28/11.
Office to be directed to delete the name.
Delete ಮಾಡ್ತೀವಿ ಅವ್ರು.
Please.
The registry is also directed to delete the name of P.S. Guru Prasad since Keshav M. Datar has filed wakalat. But ಅದ್ರಲ್ಲಿ NOC not obtained ಅಂತಿದೆ ನಿಮ್ದು.
NOC illa, my lords, because Krishna Vyas had the NOC. He has not filed the wakalat. So therefore, considering that the the petition appellant is the party.
The office objection regarding not obtained the NOC is overruled since both the earlier advocates are not practicing and one is practicing at Dharwad and another is practicing at Davanagere. Next time argument ಮಾಡಿ.
Please, ma'am.
The appeal is restored. Post the matter for final hearing on 28/11.
My lords, if it could be had a week later, my lords.
ಅಲ್ಲರಿ 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀವಿ. 2007ನೇ ಅಪೀಲ್ ಇದು.
My lords, I
2 ವಾರ
prepare ಆಗಕ್ಕೆ time ಆಗದ.
ಸಾಕು 2 ವಾರ ಸಾಕು.
Please, grateful.
16, 17, 18 ರಜಾ ಇದೆ ನೋಡಿ 3 ದಿವಸ.
Grateful.
ಆಯ್ತು.
90 ರಾಹುಲ್ ಕಾರ್ಯಪ್ಪ N Krishnamurthy.
A 1/24 for additional documents. The A 1/24 will be considered along with main appeal. Okay, Henry. Non-filing of necessary application wide order dated 22/10/24. And what is that order?
That is the death in one of the trustees is death, my lord.
ಅದಕ್ಕೇನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಿತ್ತಲ್ಲ ಹಾಕಿದ್ರ ಇಲ್ಲ?
We are not for the charity.
Huh?
We are not for the trust, my lord.
ಮತ್ತೆ ಯಾರು ಹಾಕ್ಬೇಕು ಇದನ್ನ?
That is, there are two appeals, my lord.
Who took the
326
time?
326 and 329.
Who took the time last occasion?
My lord, the
Counsel for the appellant is directed to make appropriate amendment and also directed to bring the other trustees on record and the order really. The counsel also submit that, counsel Sri N.S. Raja submit that he has filed wakalat for trust, but in the wakalat he has shown for respondent number 3 and directed to correct the same, and unless new trustees are made as parties, question of filing wakalat also doesn't arise. Hence, the counsel for appellant is directed to file necessary application.
Lord, a week time
direction
may be given,
ಇದೆಯಲ್ರಿ?
my lord, because
Huh?
because the dead person is having a daughter and she is residing somewhere else, and we are not getting what is the address of her residence. So a week's time may be given, my lord.
Counsel, there is a direction
My lord,
against you,
I
bring the trustees, you bring them, that's all.
I'll bring them, my lord.
The appellant counsel again seeks 1 week time. And in spite of earlier order dated 22/10/24 not filed necessary application. However, finally 1 week time granted. List this matter on ಒಂದು ವಾರ ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್.
14/11.
14/11.
Connected.
ಅದ್ರಲ್ಲೇನು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿರೋದು ಯಾರು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ? ಎನ್ ರಾಜ್ ಅರಸ್ ಯಾರು? ಎನ್ ರಾಜ್ ಅರಸ್? ಹಾ? ಎನ್ ರಾಜ್ ಅರಸ್ ಯಾರು? ಯು ಆರ್ ದಿ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್. ಎನ್ ರಾಜ್ ಅರಸ್ ಯಾರು? ಅಪಲೆಂಟ್ ಅಂತ ನನಗೆ ಗೊತ್ತ್ರಿ, ಯಾರು ಅಂತ ಅಡ್ವೊಕೇಟ್ ಇಲ್ವಾ ಇಲ್ಲಿ? ನೋಡಿ, ದ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇನ್ RFA 329/11 is absent and directed to comply with office objections on IA 1/24 forthwith. If the same is not complied within 1 week, production of document ಹಾಕಿರೋದು ಯಾರ್ರಿ? Respondent ಈಗ ತಗೊಳ್ಳಿ. The respondent counsel, why you have not complied office objection? If office objections,
I've received the copy.
ಈಗ ತಗೊಳ್ಳಿ. The counsel for the respondent who filed IA number 1/24 submits that copy is served on the other side. And counsel for the respondent ನೀವು ಇದರಲ್ಲಿ respondent acknowledges the same and hence office objections is complied in RFA 329/2011. List this matter on 14/11.
20. HM Somshekraya.
Bringing the LRs of deceased R1 on record. ಹೇಳ್ರಿ.
So this is the other LRs are already on record, you know. LRs are already on record. This suit for partition. ಅದಕ್ಕೆ
ಮತ್ತೆ ಕೈ ಹಾಕಿದ್ರಿ ಎಲ್ಲರೂ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಇದ್ರೆ ಮೆಮೊ ಹಾಕ್ಬೇಕಿತ್ತಲ್ಲ ನೀವು. ಪಾರ್ಟೀಸ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತೇನೋ ಹಾಕಿದಿರಿ ನೀವು.
ಅಯ್ಯ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೆ ನಾನು, ಅಯ್ಯ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು, ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರ? ನರೇಂದ್ರ DV ಗೌಡ ಫಾರ್ R1, R3 and
ಆಮೇಲೆ
R4.
IA number 3 ಫಾರ್ TI ಅಂತ ಹಾಕೊಂಡಿದ್ದೀನಿ. IA number 2 ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್.
ಸರಿ, ಯಾರ್ಯಾರು ಇವ್ರು ಹೇಳ್ಬಿಡಿ. LRs of R1 3 and 4
3
application
2 3 and 4 ಇವರು.
So appellant counsel has filed IA 1/24 wherein
Appellant
categorically stated that respond number 3 and 4 are the LRs of deceased R1. ನೋಡಿ ಮೇಡಮ್. R2 ಏನು? R2 ಇಲ್ವಾ?
ಅಲ್ಲ, R2 ಇದ್ದಾರೆ.
R2 ಅವ್ರು ಎಲ್ಲಾರ ಅಲ್ವಾ?
ಅವ್ರು ಎಲ್ಲಾರೆ.
ಅವರು ಎಲ್ಲಾರೇನಾ?
ಅವ್ರು ಎಲ್ಲಾರೇನು?
ಹಾ.
Morama is dead. R2 ಎಲ್ಲಾರೆ ಇದ್ದಾರೆ.
ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಬರೀ 3 and 4 ಒಂದ್ ಮಾತ್ರ ಇದಾರಲ್ರಿ?
ಇಲ್ಲ, ಅವರು ನಾಗರಾಜ್ ಅಂತ ಒಬ್ರು ಇದ್ದಾರೆ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 to 4 herein are surviving ಅಂತ ಇಲ್ರಿ? ಎಲ್ಲಿ ಏನಂತ ಹೇಳಿ 2 to 4 are LRs?
ಹೌದು ಸರ್, 2 to 4 are LRs.
2 to 4 are the LRs of the respond number 1. And in view of the affidavit and application, IA is allowed. Appellant counsel is directed to amend the cast title in terms of IA number 1/24.
IA number 2 for amendment of the.
And amend the same and file amended cast title within 1 week from today.
In other 2 applications.
ಮತ್ತೇನೋ ಒಂದು amendment of appeal ಒಂದು ಏನು ಹಾಕಿದಿರಿ?
During the pendency of the appeal, the first respondent executed the gift deed in favor of the 4th respondent. ಅದನ್ನ amendment ಕೇಳ್ತಾ ಇದೆ. Amendment
ಅಲ್ಲಿ ಯಾವ್ದು amendment of appeal?
Amendment of the prayer and also.
ಸರ್ವ್ ಮಾಡಿದಿರ ಅದರ್ ಸೈಡ್ ಗೆ?
ಸರ್ವ್ ಮಾಡಿದೆ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ.
IA number 2/24.
ಹೌದು ಸರ್.
ಮಾಡಿದಾರಾ? ನೋಡಿ. Heard the IA number 2/24 for amendment and copy is also served on the other side. And appellant praise this court to add additional paragraph number 4A below para 4
And also the
Where-
prayer,
wherein pleading is that
the
if
gift
deed
deed
is executed
by the first respondent.
by the first respondent in favor of respondent number 4. And the same is subsequent to the filing of
Filing
this
of this
appeal.
problem. 7/1/2014.
Stated in the accompanying application and affidavit, IA is allowed and permitted to carry out the amendment as sought. The
You know,
appellant
IA
counsel
number
is a-
2, even
appellant
the
counsel
IA
is
number
also
3 TI,
directed
restraining
to
not to
amend the
alienate
cast
anta.
in terms of IA number 2, ಇದು appeal memo in terms of IA number 2 of 24.
IA number 3 TI is restraining the fourth respondent from alienating ಅಂತ ಒಂದಿದೆ.
Memo reporting death of R1 filed by advocate for appellant ಅದಾಯ್ತಲ್ಲ.
ಆಯ್ತು.
IA 3 ನೋಡೋಣ.
IA 3 restraining the not to
ಈಗೇನ್
alienate.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆಯಾ? ಮ್ಯಾಟರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಆಗಿತ್ತಾ?
ಇನ್ನು ಆಗಿಲ್ಲ ಸರ್.
ಅಡ್ಮಿಷನ್ ಆಗಿದೆಯಾ?
ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲ ಇನ್ನ ಅನ್ಸುತ್ತೆ. ಆಗಿದೆ.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
Post the matter for final hearing on 19/11.
21 ಕೇಸ್ ನಾಗರಾಜ್ ರಾವ್ ಸರ್ ಇದು R2 ಸತ್ತೋಗಿರೋದು.
ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ?
R2 ABC ಸರ್ವ್ ಆಗಿದೆ ಸರ್.
ABC ಸರ್ವ್ಡ್. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? KS ನಾಗರಾಜ್ ರಾವ್ ಅಂಡ್ ಅಸೋಸಿಯೇಟ್ಸ್
3 ಜನ ಇದೆ.
3 ಜನ.
ಹೌದು ಸರ್.
ಹರ್ಡ್ ಆನ್ IA 1 of 23. ಹರ್ಡ್ ಇಲ್ಲ, ಪೆರೂಸ್ಡ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಪೆರೂಸ್ಡ್ IA number 1 of 23 and there is a delay of 756 days in filing the LR application and IA number 2 of 23 where prayer is sought to set aside the abatement and IA number 3 of 23 seeking permission to bring the LRs of R2 and this court has issued notice on all IAs and in spite of service of notice, so they did not choose to appear or engage the counsel and register the application. And for the reasons stated in the accompanying application and affidavit, IAs are allowed, delay is condoned, abatement is set aside and permitted to bring the LRs of deceased R2 on record. Appellant counsel is directed to amend the cast title and file amended cast title within 1 week from today. List this matter on 19/11.
22 Inner Jagadishwara.
I am for the appellant, my lords.
For the
My lord, suit is for declaration and mandate injection, my lord. I have placed
entry matter necessary ಇದೆಯಾ? main ಮೇಲೆ
ಮೇಲೆ ಕೇಳಬಹುದು.
ಹೋದಲ್ಲ.
Application is filed by me.
ಹಾ.
My lord, after filing this application, the appellants troubled me a lot. They have come to the property, they tried to demolish my property, they threatened me. I have a lot say police complaint. Police, I have also filed a complaint against them and they have given a note that since the matter is pending before this honorable court, approach the court. That's why, my lord, I have filed an application on 151 to restrain the appellants not to disturb me. It's my property. She has only sold the property to me and now she is troubling me.
ಏನ್ರಿ ನೀವೇ ಸೇಲ್ ಮಾಡಿ ನೀವೇ ಮತ್ತೆ
My lords, I filed wakalat recently and was wakalat. I am not having a copy of the application. just
ಯಾವಾಗ
filed.
ಹಾಕಿದ್ರೆ ಹೇಳಿ ನೀವು ಒಕ್ಕಲತ್ತು?
My lord, the question is
39.
ಹಾ.
39/24 recently ಏನಿಲ್ಲ.
Files ಕೊಟ್ಟಿದ್ದಾರೆ, application ನನ್ನ ಹತ್ರ ಇಲ್ಲ. Application ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ನಾನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ, so we have this matter by next week. In fact, my lord, suit is for declaration in respect of.
Whatever it may be, once the property was sold and possession was given to them, even though you
we are not,
filed a
my
suit
lord,
for declaration disputing the sale deed,
please,
how
my
can
lord.
you enter the
No,
property
my
and
suit
cause
is,
the
my lord,
damage?
my suit is for declaration in respect of C schedule property which is encroached, put up by the construction by the dependent number 1 and 2 therein, my lord.
According to you,
Suit-
they have encroached and put up
My
the
property,
construction.
2 feet into 25 feet which is encroached.
Oh,
Suit is
2
decreed, suit is
Ah.
decreed
Well,
for in portion C schedule property is concerned. I have not seek for any damage from the plaintiff dependent therein. The court have decreed the suit in favor of C schedule property being owner and directed the dependent to pay the compensation instead of delivering the property to me. Now I am told that now he has filed an application.
Then why you went and demolished?
No, non proper, our property, non sale, manana accordingly.
ಇದು
Why should I?
my friend is
IA 1 of 24 objections ಹಾಕಿದ್ದೀರಾ?
totally misleading the
KB ಅಂತ ಏನಿದೆ, ಕೆಬಿಲ್ ಪೇಪರ್ ಬುಕ್ ಅದು.
paper book.
ನೀವು IA ಹಾಕಿರೋದು ಯಾವಾಗ?
IA is filed in August, my lord. 6th August.
6th August.
Yes.
Objections ಹಾಕಿದ್ರೆ ಇಲ್ಲ?
ಇಲ್ಲ ನಾನು ಕಾಪಿ ಇಲ್ಲ ಸರ್, ನಾನು ತಗೊಂಡು ಹಾಕ್ತೇನೆ objection.
ಕಾಪಿ earlier ನೀವು ಇರ್ಲೇ ಇಲ್ವಲ್ಲ, ಬೇರೆ
ನಾನು
advocate
ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ
earlier advocate ಇದ್ರಲ್ಲ,
ಶೇಷಗಿರಿ
ಅವ್ರ ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ನೀವು.
ಇವ್ರ ಹತ್ರ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹಾಕಿ.
I'll furnish him a copy if my friend.
Counsel for the appellant seeks 1 week time to file objections to IA 1/24 and counsel for the respondent is also directed to serve the copy of IA number 1/24 and list this matter. Next week
Your lordship may kindly take it. I'll serve it right today.
ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Objections ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕ್ಲಿ.
ಆಯ್ತು ಹಾಕ್ತೇನೆ.
Next week here ಮಾಡೋಣ.
Furnish.
List this matter on 14/11. 14th ಹಾಕಿದೀನಿ, ಅವತ್ತು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
Published.
23.
Appellant.
Madhusudan M.
In this.
ಏನ?
ಟ್ರಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಇದು, ಟ್ರಸ್ಟ್ ಸೆಕ್ರೆಟರಿ ಇಸ್ ನಾಟ್ ವೆಲ್. ಸೊ 19th ಅವ್ರನ್ನು ಕರೆಸ್ತೀವಿ ಸ್ವಾಮಿ, ತಾವು
ಈಗ ನೀವು objections ಹಾಕಿದೀರಾ?
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ,
ಫೈಲ್ ಮಾಡಿ ಸ್ವಾಮಿ.
ಈವ್ನಿಂಗ್ ಹಾಕಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
I think trustees necessary ಅಂತ.
ತಗೊಳ್ಳಿ.
20th it.
Counsel for respondent seeks time
20th it.
ಅಲ್ಲ 19th.
19th. ಆಯ್ತು.
and list this matter on 19th.
Much obliged.
Not to participate or undertaking.
ಅವ್ರು ಹೇಳಿದಾರೆ
Hello.
ಅವಾಗ್ಲೇನೆ.
Please,
Unless
please.
court passes any order, we won't
Please,
disturb on.
24.
Correction of judgment filed by advocate for appellant. ಏನ್ರಿ ಇದು?
In this case, my lordship, your
Not
lordship has
trust IA number 1/24 filed by the advocate for appellant.
disposed of the RSA.
RSA na
RSA.
ಆಯ್ತು.
Disposing the RSA, your lordship has made some observation. Para 17 and 18 of the judgment may kindly peruse, my lordship. RSA judgment.
17 and 18.
18, my lord. It is stated that any encroached portion of the land is available
The
between the
plaintiff
two.
on defendant 2 got right in respect of measurement of 15 to 80 feet. And if excess measurement is available in between the two sides, it is the CUDA, defendant number 1, has to measure and to collect the amount in accordance with law to solve the existing problem, or otherwise this litigation would be in existence forever. When the plaintiffs and defendants are neighbors, and if any excess land is available, then it is open to the defendant number 1 to measure the excess land and allot the same in favor of plaintiff and defendant number 2 by collecting the value of the property and to sort out the dispute between the plaintiff and defendant number 2. In view of the discussions made above, find that the first appellate court has committed an error in passing the order allowing the appeal and counterclaim. Hence, the judgment and decree passed by the appellate court in so is set aside and consequently decision given to the plaintiff. ಆಯ್ತು ಹೇಳಿ.
ಇದರಲ್ಲಿ equal ಆಗಿ ಮಾಡಿ ಅಂತ ಮಾಡಿದಿರ ಸ್ವಾಮಿ.
ಹೌದು.
But now what happened is my party is registration value of the said land, my lord. Now in view of the observation made by lordship, it is last paraದಲ್ಲಿ number 57 from the plaintiff equally ಅಂತ ಮಾಡಿದ್ದೀರಾ last paraದಲ್ಲಿ. So now they are claiming that you have demolished the compound wall which is existed in my property, which is encroached portion of my property, which is exceeding 187.5 square feet. And that if that land is equally divided among the two parties, then I have to demolish my compound wall including the foundation, my lord. So in order to get over from all these hurdles, I am ready to pay the amount which is required as per law, my lordship, to the CUDA.
ಅದು in favor of the CUDA.
Yes, I have ready now within the week if they
He is adjacent owner is going to lose the marginal land, alva?
that is the excess land, that is not his land.
Whatever it may be. If any marginal land is existence, it should be given to as per law, ಇಬ್ರಿಗೂ ಕೊಡ್ಬೇಕು, ಹಂಚ್ಬೇಕು.
ಅಲ್ಲ ನಮ್ದೇನಾಗಿದೆ ಅಂದ್ರೆ ನಾವು ಫೌಂಡೇಶನ್ ಆಲ್ರೆಡಿ ಲಾಂಗ್
ಅಂದ್ರೆ ನೀವೇ ಕಟ್ಟಿದ್ರಿ ಎಕ್ಸಸ್.
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಅಲ್ಲಿ ಕಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ.
ಆಯ್ತು ಏನ್ರಿ?
ನಾವು ಐ ಆಮ್ ರೆಡಿ ಟು ಪೇ ದಿ ಅಮೌಂಟ್.
It is incorrect statement. They are ಅವ್ರು ಮುಗಿಸ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಮುಗಿಸ್ಲಿ ಅವ್ರು.
ಅದ್ರಲ್ಲಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಪ್ಯಾರಾ 10 ಪೇಜ್ ನಂಬರ್ 10 ನೋಡಿ ಸರ್. ಅದ್ರಲ್ಲಿ 375 square feet excess land ಅಂತ they have themselves has produced the document before the court below, before this court in writ petition. Now I have given the detailed representation stating that I have in the possession of the land access to the 185.5.
You have given representation to the CUDA.
Yes, my lord. The Kuda is not inclined to accept my representation on the ground that
In
the
view of
only,
the order passed by this court.
in view of the order passed by this court,
Madam, ಕೂಡಾಗ ಯಾರು ನೀವು appear ಆಗ್ತೀರಾ? ಹೇಳಿ ಏನು?
equally ಅಂತ ಇದೆ.
What is the factual?
ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಹಾ, ಹೇಳಿ.
Factually incorrect statement my learned friend has made.
ಹಾ.
Now, the 10 feet which was in my sale deed, after hearing the, at length, the Sambal court has come to conclusion that out of this 10 feet, the Kuda has to measure it and to give it to 5 feet and 5 feet. Now, instead of the 375 square feet, it is 5 feet and 5 feet. Now, Kuda, in pursuance of this order in the month of August 2020, they did not pursue the matter
2020, ಇದು 2021 order.
Contempt ಎಲ್ಲ
and because of one or the other reason, they prolonged it for 1.5 years. Then I initiated contempt. Contempt also disposed. I will place it on record. And in the meanwhile, after this passing of this order by the Sambal court, they have prepared one more writ petition before the Sambal court, stating that, and they have got the interim order of status quo. And this interim order of status quo till recently, my lord, it has been prolonged up till 23rd June 2024. A copy is also. Then in view of this order passed before the Sambal court, that has to be complied, is the direction, and writ petition got dismissed before the Sambal court. WP 16,643, 2 years, 2.5 years, they prolonged it. Though my lord made an observation not to litigate and to put an end to coitus to this litigation. Now they, one or the other reason, they are prolonging and they are dragging on to harass me, because now the sworn statement made by the applicant is one of the power of attorney. He is a big contractor in the Chikkamangalore. And he is the person who is grabbing the lands and doing all these mischief. My land and my portion, my state, he knows very well. They have encroached. Now the Kuda has measured it. As per measurement, compound wall is removed. Their grievance is their foundation. No, absolutely no. Right now, at my cost, any senior member may be appointed, let him visit. And also they have made a false statement, drainage is there. There is no such drainage. Physically, we verified when Commissioner of Kuda has come and we verified it. Except this compound wall, and he has constructed up till his land and his portion. Exactly. There is no question of foundation, there is no question of drainage. False statement is making. Now, only thing is, a photograph I have produced, my lord, a staircase.
ಈಗ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಈಗ ನಾನು ತರೋದು late ಆಯ್ತು. ಒಂದೇ ಒಂದು photograph ತಗೊಂಡು. Last period. Sorry, this paragraph ಆಗಲ್ಲ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಫೋಟೋಗ್ರಾಫ್ ಒಂದು ಹಾಕಿದ್ವಿ. ಈ ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಸ್ಟೇರ್ ಕೇಸ್ ಇದು ಯಾವುದಕ್ಕೂ ಯೂಸ್ ಇಲ್ಲ. ಇವರು ಟೆರೇಸ್ ಮೇಲೆ ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಹತ್ತೋದಕ್ಕೆ ಯಾವಾಗ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಇದು ಒಂದಿರೋದು, ಇದರಲ್ಲಿ ಒಂದು ಪೋಲು, ಮೈಲಾಡ್ ಪೇಜ್ ನಂಬರ್ is 17. ಆ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಎಲ್ಲ ತೆಗ್ದಿದ್ದಾಯ್ತು. ಈ ಸ್ಟೇರ್ ಕೇಸ್ ಹಾಕೊಳ್ಳೋದು ಇದೇನಕ್ಕೆ ಉಪಯೋಗ ಇಲ್ಲ. ಇವ್ರೇನೋ ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಮೇಲ್ಗಡೆ ಟೆರೇಸ್ ಹತ್ತೋದಕ್ಕೆ.
ಈ ಜಾಗನೇ
ಹೌದು, ಇದೇ ಜಾಗ ಅವರು ಕಂಪ್ಲೀಟ್ ಆಗಿ ಕಟ್ಕೊಂಡು ಆಗೋಗಿದೆ.
10 feet.
ಹೌದು, 10 feet ಅಲ್ಲಿ ಅವ್ರು ಕಟ್ಟಿದ್ದು ಆಲ್ಮೋಸ್ಟ್ ಇದು ಅವರು ಎಂಡ್ ಆಫ್ ದೇರ್ ಇದು ಹೌಸ್ ಕಾಂಪೌಂಡ್ ಬಂದಿದೆ. ಅಲ್ಲೇನೋ ರೇಕ್ ಹಾಕಿ ಮುಚ್ಚಿಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿಗೆ ಮುಗೀತು. 5 ಅಡಿ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ, ತೆಗ್ದಿದ್ದಾಯ್ತು. ಅಲ್ಲಿಗೆ ತಾವು ಮಾಡಿದಂತ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇಟ್ ಹ್ಯಾಸ್ ಕಮ್ ಟು ಅನ್ ಎಂಡ್ ಅಂಡ್ ಆಲ್ಸೋ ಟು ಪುಟ್ ಎ ಕ್ವೈಟಸ್. Now again you want to litigate through this power of attorney holder. He is a cantankerous fellow and he is a contractor there and he is creating all this mischief. Mercilessly, my respectful submission is this application 152. The 152 intent of the legislation is if there is any arithmetical or clerical mistake, then only the Sambal code. If he is aggrieved by this order passed by the Sambal code, it's in all ways to say it is a just and very equitable relief the Sambal court has given. If he is aggrieved, let him take the matter to elsewhere, not before this Sambal court by way of this 152 application. Number one. Number two, my lord, even on the day when the matter has been disposed of, regarding this 10 feet, the Kuda learned advocate who represent Kuda, he was not so honest to submit the old records and the original records.
ಅಲ್ಲ ರೀ, rectify the error ಅಂತ ಹೆಂಗೆ ಹೇಳ್ತೀರಾ? Do you think that the order passed by this court is an error?
No.
Your prayer, what is your prayer in 152? That is a reasoned order given by this court. How you seek for the, may be pleased to rectify the error committed In the operative portion of the impugned order dated 10/8/21, passed by this court, observed that it is open to the defendant number 1 to measure,
That will clarify in my lordship.
ಏನ್ clarify ಏನ್ ಬರ್ತದೆ?
But it is the word which is
If it is any error, you can approach the appellate court, that's all.
equally the word it is used by equally.
Equally
That will
ಏನಾದ್ರು
cause the
marginal land ಇದ್ರೆ ಆ ಲ್ಯಾಂಡ್ ಅನ್ನ ಬೇರೆಯವ್ರಿಗೆ ಕೊಡಕ್ಕಾಗಲ್ಲ.
sketch may be perused my lord.
ಕೇಳಕ್ ಹೇಳ್ರಿ, if any excess land, marginal land in between two sites, that has to be given to the both the site owner,
If the marginal
both
land,
the site owners as per law.
if the marginal land is available, I have no issue, my lord.
That is
Yes, put up some construction in the marginal land by
Yaru?
encroaching that portion. The plaintiff, the appellant here.
ಇದು ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲ. ಈ ಲೇಔಟ್ ನಲ್ಲಿ ಅಲೈನ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಕ್ಸಸ್ ಲ್ಯಾಂಡ್ ಇದ್ದಿದ್ದು ನನಗೆ 1995 ನಲ್ಲಿ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಮುನ್ಸಿಪಾಲಿಟೀಸ್ ಅದನ್ನ ವ್ಯಾಲ್ಯೂ ಕಟ್ಬೇಕಂತ ಹೇಳಿ 1995 ನಲ್ಲಿ ಇವನ್ ದ ವ್ಯಾಲ್ಯೂ ಪೇಡ್ ದಟ್ ಫಾರ್ ದಿಸ್ 10 feet.
Order the appellant counsel.
Idral sketch, may kindly peruse the sketch, my lord.
I will not look into the any sketch also. When the order is very clear, it was passed in 2021, you have not passed a challenge this order, how you can now term it as it is an error? How you can term it as an error?
The lordship has specifically stated
ಅದ್ರ
there is no
ಜೊತೆಗೆ ಎಲ್ಲ ರಿಟ್ ಎಲ್ಲ ಹಾಕಿ ಈಗಾಗಲೇ 3 ವರ್ಷ ಎಲ್ಲ ಕೋರ್ಟ್ ಎಲ್ಲ ಸುತ್ತಾಡ್ಕೊಂಡು ಬಂದು ಈಗ
Contempt was filed against us only because of the status quo order. ನಮ್ಗ commissioner against ಹೌದು.
ಸ್ಟೇಟಸ್ ಆರ್ಡರ್ ತಗೊಂಡ್ರು,
Status
ನಾ ಮುಂದೆ ಹೋಗಿಲ್ಲ ಹಿಂದೆ ಹೋಗಿಲ್ಲ.
ಏನ್ ಆರ್ಡರ್?
ಇನ್ನೊಂದು ಇಂಡಿಪೆಂಡೆಂಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬಿಟ್ಟು ಅದ್ರಲ್ಲಿ
ಸ್ಟೇಟಸ್
ಇಲ್ಲ. What happened, my lordship? There is note subsequently
why you filed a writ petition against this order?
immediately notice has been
endorsement
issued, my lord.
ಆಯ್ತು.
Not against this order, my lord.
ಮತ್ತೆ
They have to demolish my compound wall. There is a notice has been
already there was
issued.
an order.
And notice, after the issuance of notice, I approach the court below by stating the
Dismiss
facts
this- I will
observed by
dismiss
your
this
lordship and
application. I will
stating that
dismiss this application with cost of rupees 1 lakh. You meet the expenses of the other side also in dragging them to the court by filing writ petition,
No,
contempt proceedings.
I am
And
not
now
filing-
also
Contempt was
filing,
initiated
now
by
filing
the other
also
side.
this application.
Contempt was initiated by the.
Who?
by me.
ನೀವು initiate
By
ಮಾಡಿದ್ರಾ?
me, ಯಾಕಂದ್ರೆ
Because we-
court order more than 1.5 2 years, they did not pursue the matter and
Did not take any decision.
yes, any action they did not take.
Decision, we have given the notice, but we could not execute
ಅವ್ರ್ದು
the
ಒಂದು
order
contempt
passed by this honorable court only because there was a status quo order.
Status quo order
ಅದೆಲ್ಲ
is
order ಮಾಡಿ
writ petition.
ಹೌದು. ಅದನ್ನ
ಅದು even
place
straight of the
ಮಾಡಿದ್ಮೇಲೆ
status quo order, they have
contempt was,
demolished the building, my lord. There is a notice issued calling upon
ಹಿಂಗ್ ಯಾವ್ದು ಡೆಮಾಲಿಶ್ ಆಗಿಲ್ಲ ನಿಮ್ ಕಾಂಪೌಂಡ್.
compound wall demolish
ಮತ್ತೆ
ಆಗಿದೆ.
ನೀವು ಹೊತ್ತಡಿದ್ನ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಬಿಟ್ರೆ
ಅಲ್ಲ, earlier it is that
ನಿಮ್
compound
ಬಿಲ್ಡಿಂಗ್
wall
ಜಾಸ್ತಿ ಇದೆ ಹೇಳಿ.
while put up in the
ಬಿಲ್ಡಿಂಗ್ ಜಾಸ್ತಿ ಇದ್ರೆ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಷನ್ ಆರ್ಡರ್ ಮಾಡೋಣ.
compound, I'm.
How you can construct a building more than your site?
ಅಲ್ಲ, your lordship,
Site area.
by observing the very same fact, your lordship has suggested in the impugned order, you have divided among the equally without
That's what.
without giving any room to further litigation.
Passed an equitable order.
So
both
after
came-
measurement only, I came to know that my encroachment is exceed the 50% of the.
ಮನೆ ಕಟ್ಟಕ್ ಗೊತ್ತಾಗಲ್ವಾ?
Absolutely no.
ಎಷ್ಟಿದೆ ನೀವೇ ಕಟ್ಕೊಂಡಿದ್ದೀರಿ ಅನ್ನೋದು
Suit ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿದೆ ಆ ಇಶ್ಯೂ.
ಗೊತ್ತಾಗಲ್ಲೇನ್ರಿ?
Now I am ready to pay the amount, my lordship, your lordship.
That's all. I will dismiss with the.
ಅವರು ಒಂದು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಅದು ಯಾಕಂದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ ತೆಗೆದುಕೊಂಡು 11/25/2016 ಸಾರಿ
ಯಾರು?
ಇವರು ಹಾಕಿದ್ದಾರೆ.
ಕಂಟೆಂಪ್ಟ್.
ಹೌದು.
ಅದೇನಾಯ್ತು?
ನಾವು ಹಾಕಿದ್ರು ಗೊತ್ತಿಲ್ಲ.
11/25/2022 BG Nagesh versus
Now if they want to demolish.
ನಮ್ಮೇಲೆ ನಾವು ಇವರು.
ಅಲ್ಲ, my respectful submission,
because we
if they have equally divided among the excess land is equally divided, my lordship, I have to demolish the entire building, my lordship, including the one side.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಜಾಸ್ತಿ ಕಟ್ಕೊಂಡಿದ್ರೆ ಡೆಮಾಲಿಷನ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ, for that only your lordship has observed, it has to be divided equally and it has to be compensated by paying the amount.
ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ ಇದ್ರೆ ಮಾತ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, collecting the amount,
Value of the property, you have to pay it to the.
I am ready to pay the value of the property, my lordship.
ಕೊಡಿ, ಪೂರ್ತಿ ಕೊಡಕ್ಕಲ್ಲ.
They have given a representation saying
ಅಲ್ಲ, ಅದನ್ನ
that.
ಪೂರ್ತಿ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, I am ready to pay.
ಅಲ್ಲ, ನನಗೆ
Whatever the land
ತಗೊಳಕಾಗುತ್ತೆ ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ನ.
entirely encroached portion ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಎನ್ಕ್ರೋಚ್ ಪೋರ್ಷನ್ ಎಷ್ಟು ನಿಮ್ಗೆ ಹಾಫ್ ಬರುತ್ತೆ ಅಷ್ಟೇ, ಇನ್ ಹಾಫ್ ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ. ಇಫ್ ಎನಿ ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ ಇನ್ ಬಿಟ್ವೀನ್ ಟೂ ಸೈಡ್ಸ್.
ಗಿಂತ ಜಾಸ್ತಿ ಸ್ವಲ್ಪ ಹೋಗಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲ, 85 ಜಾಸ್ತಿ ಹೋಗಿದೆ.
ಡೆಮಾಲಿಷ್ ಮಾಡ್ಬೇಕು. ನೀವು ಅದನ್ನ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಇಬ್ರಿಗೂ ಅರ್ಧ ಹಂಚಿ ಮೇಡಮ್ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಅರ್ಧ ಮಾಡಿದ್ದೆ.
ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಆರ್ಡರ್
ಮಾರ್ಕಿಂಗ್ ಆಗೋಗಿದೆ. ಆದ್ರೂ ಇದೊಂದು ರೀತಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಫ್ಯೂಲೆಸ್ ಅಂಡ್ ತರಳೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು GPA ಮುಖಾಂತರ ಈಗ ಮಾಡ್ತಾ ಇದೆ.
ಏನಾಗುತ್ತೆ
ವರ್ಡ್ Because
the order.
since 2011, with the,
given.
with the,
Application jotege page number 8.
with the sanction plan, I'm waiting to put up my.
Saying that 275 square, 375 ಇದೆ, his own statement, 375 square feet
ನೋಡಿ.
ಇದೆ, delivery ಜಾಗ.
What is the appellant counsel?
ಅದ್ರಲ್ಲಿ ನಾನು 275
Also the
ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
counsel appearing for the respondent.
2011 ಪ್ಲಾನ್
Here
ಸ್ಯಾಂಕ್ಷನ್
is
ಆಗಿ
start by filing an application on
ಕಟ್ಟಕ್
section
ಕಾಯ್ತಾ ಇದೀನಿ
152 of CPC to rectify the error committed in the operative portion of the impugned order dated 10/8/21.
Otherwise,
Passed by
I
this
make one
court.
submission, my lords.
ಹೇಳಿ ಏನು?
Otherwise, I will withdraw the application. I will concern, I will request the CUDA to.
ಕೂಡಾರು ಏನು ಮಾಡಕ್ಕಲ್ಲ, ಈಗ ಆರ್ಡರ್ ಇದ್ರದ್ರಿಂದ. ಈ ಆರ್ಡರ್ ಏನಿದೆಯೋ ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ದಾಗಿದೆ. ಆ ಒಂದು ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಕಿತ್ತಾಕ್ಬೇಕಷ್ಟೇ.
There is an hardship caused to the
ಆ
party.
ಒಂದು ಮೆಟ್ಲಂತ ಹಾಕಿದ್ದಾರೆ, ಒಂದು ಯಾವ್ದೋ ಕಂಬಿ ತಂದು ಅಲ್ಲಿ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ ಬಿಟ್ಟವ್ರೆ ಬೇಕಂತ. ನನ್ನ ಫೋಟೋದಲ್ಲಿ ಲಾಸ್ಟ್ ನಲ್ಲಿ 2 ಪೋಲ್ ಹಾಕಿ
ತಂದಿಲ್ಲ sir.
ಅದನ್ನ ಕಿತ್ತು ಬಿಸಾಕ್ಬೇಕಷ್ಟೇ. ಒಂದಲ್ಲ ಇನ್ನೊಂದು ಹರಳ್ಸ್ ಹಾಕೊಂಡು ನನಗೆ 2011 ಮನೆ ಕಟ್ಟಕ್ ಬಿಡ್ದಿರ ಈ ಕಾಂಟ್ರಾಕ್ಟ್.
Stay, High Court stay ಆದಾಗಲೇ demolition on the very same day they have demolished my property, compound wall of my property. my lord.
ಈ ಸೈಡ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಆ ಸೈಡ್ ನಲ್ಲಿರೋ ಇದು ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಐರನ್ ಇದು ಅದೇನಕ್ಕೂ ಉಪಯೋಗ ಇಲ್ಲ. ಅಲ್ಲಾಕಿ ನನ್ನ ಭೂಮಿನಲ್ಲಿ ಒಂದು ಮುಕ್ಕಾಲು ಅಡಿಯಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನ ಕಿತ್ತರೆ ಎಲ್ಲ ಹೋಯ್ತು. ಇವಾಗ ಕಂಪ್ಲೀಟ್ ಆಗಿ 5 feet ಏನಿದೆ ಅದು ಮಾರ್ಕ್ ಮಾಡಿದ್ದು ಆಗೋಗಿದೆ ಕೂಡ ಅವರು.
Otherwise, kindly next week I will consult my party.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಿದೆ ಡಿಸೈಡ್
ಇನ್ನೊಂದ್ಸಲ ಕನ್ಸಲ್ಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಬೇಡ ಬೇಡ ದಯವಿಟ್ಟು ನನಗೆ ಇದಕ್ಕಿನ್ನ ಹರಾಸ್ಮೆಂಟ್ ಯಾವ್ದು ಇಲ್ಲ.
ನಾನು ಹರಾಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅವರೇ
ಒಬ್ಬ GP
ಆಪರೇಟಿಂಗ್ ದೇ ಹ್ಯಾವ್ ಡೆಮಾಲಿಶ್ಡ್ ದಿ
ಆಕ್ಚುಯಲ್
ಕಾಂಪೌಂಡ್ ವಾಲ್.
ಪ್ಲೈಂಟಿಫ್ ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. GP ತಗೊಂಡು ಇಷ್ಟೆಲ್ಲ ಆಟ ಆಡಿಸಿ ಎಲ್ಲ ಹರಾಸ್.
ಅಲ್ಲ 75 years ಯಾವ ಕಾಂಟ್ರಾಕ್ಟರ್ ಅವನು? ಇಸ್ ನಾಟ್ ಎ ಕಾಂಟ್ರಾಕ್ಟರ್. ಅವರು ಏನೋ ಬೇರೆ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಚಿಕ್ಕಮಗಳೂರು
2 ಯಾಕೆ ಹಾಕಿದೆ? 2
ಅದೇ ಡಿಲೇ ಅಂತ ಹಾಕಿದೆ ಸರ್. ಅದು ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಆಗಬೇಕು. I will consult my party, my lordship. Otherwise, more hardship will cause to the appellant, my lordship.
dated 10/8/21. In support of the, and also it is stated that this court directed the first defendant to measure the land and collect the value of excess land available in between site number 57 and 46 from the plaintiff and defendant number 2 equally, and demarcate the respective sites of the plaintiff and defendant number 2. And after collecting the charges, should not give any rumor to litigate again by the parties. And in view of the above observations, surveyed the land and land is available 375 square, where the appellant has already constructed his house excluding the 100 square feet. And remaining portion of the encroached land was used by the appellant for construction of house, and said extent is utilized for drainage and basement. Hence, the observations made in paragraph number 17 and 18 of the impugned order as stated above cannot be enforced. In support of the application, affidavit is also filed. The council also brought to notice of this court the application given to the commissioner that he is ready to pay the excess value of the land which is available in view of he had already put up construction of excess area. The council appearing for the respondent filed objections contending that proviso of 156 is very clear that only clerical or arithmetical mistake in judgment and decree or orders or error arising therein from any accidental slip or omission may at any time be corrected, and cannot seek for an order to modify the earlier judgment unless the same is challenged before the appropriate forum. Also, council would contend that the appellant also approached this court by filing a writ petition number 16643 of 2022, and for a period of 2 years by work training in order of status quo after disposal of this second appeal. Harass the respondent, and this court was pleased to
No, my lords.
dismiss the writ petition on 3/6/24. Copy of the order passed is also produced as annexure R1.
I make one submission, my lord, distinction.
The council appearing for the respondent also in the objection statement contended that ನೀವೇನ್ ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀರಾ?
ನಾನು 95 ಕಟ್ಟಿದ್ದೀನಿ. ಹತ್ತಡಿಗೂ ಅದು ಡೈರೆಕ್ಟರ್ ಆಫ್ ಮುನ್ಸಿಪಾಲಿಟೀಸ್ ಇಂದ ಅಪ್ರೂವ್ ಆಗಿ ರೆಸೊಲ್ಯೂಷನ್ ಹಾಕಿ.
ನೀವೆಲ್ಲಾನು ಕ್ಲೈಮ್ ಮಾಡಕ್ ನೋಡಿದ್ರಿ?
ಇಲ್ಲ ಎಲ್ಲದಕ್ಕಲ್ಲ ನಾನು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು.
RSA ಬಂದಿದ್ದು.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು.
Respondent also produced the copy of receipt for having made the payment in terms of R2 to R4. Annexure R2 to R4. And content that already removed the compound wall. The appellant caused unnecessary obstruction by bringing order of status quo in the above writ petition. The demarcation of 5 feet is also indicated. The appellant has deliberately protruded on the fabrication work staircase into the property of this respondent number A46. Photograph is also produced as annexure R5.
Objection copies is not available to me.
Copy ಕೊಟ್ರಿ ಅವ್ರಿಗೆ?
ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ, ಹಾ.
ಆಮೇಲೆ writ petition is filed after the disposal of the RSA.
ನಾವೇನ್ ನಾನೇನ್ ಆರ್ಡರ್ ಕೊಡೋದಿಲ್ಲ, ಆಯ್ತು ನೋಡಿ, ಹಾ. And hence prayed the court to dismiss the application. Having heard the appellant counsel on IAS, and also the counsel for the respondent and counsel for new marriage, madam?
Now respondent number.
ಕೂಡ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
R1, full stop. The counsel for R1 only submits that in view of the order passed by this court, already they have taken steps. But in the meanwhile, writ petition is also filed and status quo was granted, and hence they could not implement the order passed by this court. And also both of them have initiated even contempt proceedings for non-compliance of order passed by this court. And in view of the pendency of the writ petition, could not able to implement the order. Having heard the appellant counsel and also the counsel appearing for the respondent, and also on perusal of material available on record, particularly paragraph number 17, this court having taken note of excess land available in between the two sides, specific direction was given to the CUDA to measure both the sides, and open to the defendant number 1 to measure the excess land and allot the same in favor of plaintiff and defendant number 2 by collecting the value of the property and sort out the dispute between the plaintiff and defendant number 2. Since the excess land is in between two sides. And when such recent order has been passed by this court, even considered the equity while passing such an order, and hence the appellant cannot term the said order as there is an error in passing such an order. It is also important to note that this order was passed on 10th of August 2021 and no appeal was filed, and instead of appellant filed writ petition before the court and obtained an order, and ultimately the writ petition also dismissed. And having taken note of the conduct of the appellant, and also when the order has been passed in detail, considering the factual aspects of the case, it is nothing but an abuse of process, and this application is also filed almost after 3 years. And hence application is liable to be dismissed with exemplary cost of rupees 25,000. 25,000. In view of the discussion, I pass the following order. Application is dismissed. Other one, ಇನ್ನೊಂದು ಹಾಕೊಳ್ಳಿ. The appellant sought for a rectifying the mistake passed in the order, and also the proviso under section 152 is very clear. Only if any clerical mistake and typographical error, and the same can be rectified and not modifying the order of this court, invoking section 152. And on that ground also, the appellant is not entitled for any relief. Out of the cost of rupees 25,000, and the same is payable on the respond number 1 and 2 each 5,000, remaining west with the state.
ಅಲ್ಲ ನನಗೆ ಬೇಡ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಕೊಟ್ಬಿಟ್ಟು.
Legal service authority.
4 ವರ್ಷದಿಂದ ಹರಾಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು.
ಅದು legal service authority.
55,000 ಬೇಡ ಕಡಿಮೆ.
ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ನಿಮ್ಗೆ? ನಿಮ್ಮಲ್ಲಿ ದುಡ್ಡು ಬಹಳ
My intention, your lordship has specifically stated there is no rumor for further litigation. That's why I make an application.
Sanction plan I have taken.
I agreed to deposit the amount for the excess land which is encroached by the
25,000, 20,000 ಮಾಡಿ the amount shall vest with the state. ನೀವು ಕೂಡಾದವ್ರಾ?
ಹೌದು.
ನಿಮ್ಗೂ ಬೇಡ ಹಾಗಾದ್ರೆ. ನೀವು ಹೋಗಿ
ಇಲ್ಲ ನಮ್ಗೆ ಏನಂದ್ರೆ ಅವ್ರು ನಮಗೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ. 3 ಕೇಸ್ ಹಾಕಿದಾರೆ ಇದಾದ್ಮೇಲೆ.
ನೀವು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಒಂದು ಸ್ಮಾಲ್ ಕ್ಲಾರಿಫಿಕೇಶನ್, ನಾನು ಯಾಕಂದ್ರೆ ವ್ಯಾಲ್ಯೂ ಕಟ್ಬೇಕಂತ ನಾನು 95ರಲ್ಲಿ 10 ಅಡಿಗೂ ಕಟ್ಟಾಗಿದೆ. ಅದರಿಂದ
ಅವ್ರು ಮಾಡ್ಕೋತಾರೆ.
ಒಂದು ಆಮೇಲೆ ಎರಡನೇದಾಗಿ ಇವರು ಸೆಟ್ ಬ್ಯಾಕ್ ಏನಿಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ 5 ಅಡಿನ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನ್ ಕಟ್ಟುವಲ್ಲಿ ಲೆಟ್ ದೆಮ್ ನಾಟ್ ಅಬ್ಜೆಕ್ಟ್ ಅಂತ
ಅಲ್ಲ ಎಷ್ಟು ಮೆಜರೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. whatever the encroachment made by my party, whatever the
14 ವರ್ಷದಿಂದ
ನಿಮ್ ಸೈಟ್ ಈಗ ವೇಕೆಂಟ್ ಇದೆಯಾ?
ಇದು ವೇಕೆಂಟ್ 14 ವರ್ಷದಿಂದ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್
ಇಲ್ಲ ಅವ್ರದ್ದು ವೇಕೆಂಟ್ ಇಲ್ಲ. there is a space available between the two properties, my lord.
ಅದು ಒಂದು
My party is already put up the construction.
ಅವ್ರ ಸೈಟ್ ನಂಬರ್ 57, ನಿಮ್
46. ಹೌದು 46ರಲ್ಲಿ ಕಟ್ಟಕ್ ಶುರು ಮಾಡಿದ್ರೆ
ನೀವು 46 ಕಟ್ಟೇ ಇಲ್ವಾ?
ಸರ್ 350 ಜಾಗ ಇರೋದು ಅದ್ ಹೆಂಗ್
ನೀವು ಕಟ್ಟದಂಗೆ
ಕಟ್ಟಿದ್ದೀರಾ? ಅವ್ರ ಪ್ರಕಾರ 375 ಜಾಗ ಇದೆ ಬಿಟ್ವೀನ್ ದಿ 2 ಪ್ರಾಪರ್ಟೀಸ್.
ಫೋಟೋ ಪ್ರಕಾರ
ಅಲ್ಲ ಸರ್,
ಅಲ್ಲ ನಿಮ್ದು ಈಗ ವೇಕೆಂಟ್ ಸೈಟ್ ಇದೆಯಾ?
ನಂದು ವೇಕೆಂಟ್ ಸೈಟು 2011 ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನು ಶುರು ಮಾಡಕ್ ಹೋದಾಗ ಈ ಅಪ್ಲೈ ಮಾಡಿ ಕೇಸ್ ಹಾಕೊಂಡು.
ಇಲ್ಲ ಸರ್ 375 ಅವ್ರ ಪ್ರಕಾರನೇ there is a 375 feet square feet is available between
375 ಅಲ್ಲಿ ನಿಮ್ಗೆ ಅರ್ಧ ಬರುತ್ತೆ 185. ನಾನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿರೋ ಪ್ರಕಾರ ಅಷ್ಟಕ್ಕೆ ನೀವು ಮಾತ್ರ
ಅಲ್ಲ
ಬಾಕಿದ ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
ನಮ್ಮವ್ರು ಒಂದು 60-70 ಅಡಿ ಎಂಕ್ರೋಚ್ ಮಾಡಿ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್. ದಟ್ ಇಸ್
ಹೊಡ್ದಾಕ್ತಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಹೊಡೆದಾಕಿರಿ ಇಡೀ ಬಿಲ್ಡಿಂಗ್ ಹೋಗುತ್ತೆ.
ಹೋದ್ರೆ ಹೋಗುತ್ತೆ.
ಸಾಧ್ಯನೇ ಇಲ್ಲ, ಸುಳ್ಳು ಹೇಳ್ತಾರೆ.
ಹ್ಮ್
ಇಲ್ಲ ಬಗ್ಗೆ ಮೊಬೈಲ್ ಬಲ್ಲ
ಬೆಸ್ಟ್ ವಿತ್ ದಿ ಸ್ಟೇಟ್. Amount 20,000 vest with the state. If cost is not paid within 2 weeks, the registry is directed to recover the same from the appellant. ಇನ್ನೇನ್ ಹಾಕ್ಬೇಕು? 6 weeks ಹಾಕ್ಬೇಕು. ಎಲ್ಲ ಕಡೆಗೂ ಹೋಗಕ್ಕಾಗುತ್ತೆ, ರಿಟ್ ಹಾಕಕ್ಕಾಗುತ್ತೆ, ಕಂಟೆಂಪ್ಟ್ ಹಾಕಕ್ಕಾಗುತ್ತೆ, ಎಲ್ಲ ಮಾಡಕ್ಕಾಗುತ್ತೆ. 20,000 ಕಟ್ಟಕ್ಕಾಗಲ್ಲ. ನೋ ಕೌನ್ಸಿಲ್. ನಿಮ್ಮ RSA ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ನೀವು ಇದೆಲ್ಲ ಮಾಡಿದಿರಿ ಸರ್ಕಸ್. 21 ನಲ್ಲಿ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ. 22 ನಲ್ಲಿ ನೀವು ರಿಟ್ ಹಾಕಿದಿರಿ. ನಮ್ ಕೋರ್ಟ್ ಹಂಗೆ ಇದಾವೆ, ಏನ್ ಬೇಕಾದ್ರೂ ಆರ್ಡರ್ ಕೊಡ್ತಾರೆ. ಅದಕ್ಕೆ ಹಿಂಗ ಆಗೋದು. ಸ್ಟೇಟಸ್ಕೋ ಯಾವ್ದಾರ ಒಂದ್ ರಿಟ್ ಬಂತಂದ್ರೆ ಸ್ಟೇಟಸ್ಕೋ ಎಲ್ಲ ಅಷ್ಟೇ. ಹಿಂಗ್ ಮಾಡೋ ಹೊತ್ತಿಗೆ ಹಿಂಗ ಆಗ್ತಿರೋದು. ಮತ್ತಿನ್ನೇನಲ್ವಾ? when this court has already decided the matter in the RSA, what is the ಅಷ್ಟೇ ಈಕ್ವಲಿ ಡಿಮಾರ್ಕೇಟ್ ಮಾಡ್ಬೇಕಂತ. ಹೌದು, because we have encroached the encroached portion ಅಲ್ವಾ? ಒಂದು ಕತ್ ಲಿಟಿಗೇಷನ್ ಮಾಡ್ಕೊಳ್ಳೋದು, ನಾವು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಬಾಯಿಗೆ ಬಂದು ಆರ್ಡರ್ ಬರೆಯೋದು. ಅದಕ್ಕೆ ಹಿಂಗಾಗೋದು ಹೌದಿಲ್ಲ?
ಸಪ್ರೆಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅದು ಹೇಳಲ್ಲ ಫ್ಯಾಕ್ಟ್, ಟ್ರೂ ಫ್ಯಾಕ್ಟ್. ಅಡ್ವೊಕೇಟ್ಸ್ ಹೇಳಿದಿರ ಇಷ್ಟೆಲ್ಲ ರದ್ದ ಅಂತ ಆಗೋದು. ಇಲ್ಲಿ ಆಗಿರುವಂತ ಆರ್ಡರ್ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ರೆ
ಬಿಡ್ರಿ, ಸುಮ್ನೆ ಹಾಕಿದೀನಿ 20,000 ಕಟ್ಲಿ ವಸೂಲಿ ಮಾಡ್ಲಿ.
6 weeks my lord.
ಅಲ್ಲ ದೊಡ್ಡ
6 weeks 2 weeks
ಅಲ್ಲ at least
ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಒಂದೇ ವಾರ
ಅಲ್ಲ 4 weeks ಅಂತ ಮಾಡ್ಬಿಟ್ಟು.
ಎಲ್ಲದಕ್ಕೂ ದುಡ್ಡು ಇರ್ತದೆ, ಇಲ್ಲಿ ಕಟ್ಟಕ್ಕಾಗಲ್ವಾ ಸರ್ಕಾರಕ್ಕೆ? ಕಟ್ಟಿ ನಮ್ ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ ಈಗ ಅರ್ಧ ಗಂಟೆ, ಅದಕ್ಕೆ ಕಾಸ್ಟ್ 20,000. ಅದು ಬರೀ ಎಲ್ಲ ಫ್ರಿವಲಸ್ ಲಿಟಿಗೇಷನ್ಗೆ.
25 ಹನುಮಂತ ರಾಜು
ಡಿಸ್ಮಿಸಲ್ 25 dismissal of IA 1 of 24 wide order dated 22/10/24 ಇಲ್ವಾ ಕೊಡಿ. ಏನು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಮತ್ತೊಂದು IA ಏನೋ ಈಗ ತಗೊಳ್ಳಿ. ಈಗ ಅವರು ಇಲ್ವಾ? ನಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅದ್ ಬಿಟ್ರೆ ಯಾವ್ದೋ ಬೇರೆ ಕೊಡ್ತೀರಲ್ರಿ. 22/10 ನನ್ನ ಮುಂದೆ ಇರ್ಬೇಕಲ್ಲ. ನಾವೇನೋ 22/10 ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಲ್ಲ, ಅದೆಲ್ಲ ಮೇಡಮ್? Dismissal of IA 1 of 24 wide order dated 22/10 ಅಂತಿದೆ. ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಮಾಡಿದೀವಲ್ಲ ಇಲ್ಲಿ, ನಾನು ತಗೊಳ್ಳಿ. Appellant counsel is absent and this court wide order dated 22/10/24 made an observation that in spite of application is filed for recalling the order dated 8/10/23 and office has raised the objection, appellant counsel was absent and even not complied with office objections. However, one more opportunity was given to comply with office objections within 2 weeks. And also made it clear, if not complied, list the matter for dismissal of IA 1 of 24. In spite of it, office objections not complied, and today also counsel is not before the court. And earlier also, when the recall application was filed and the same was also dismissed Void order dated 8/12/23 ಅಲ್ಲ ಮೇಡಮ್? 8/12/23. That is on IA number 2 of 23 for similar relief. Partnered
Admission
in
26.
admission.
Manjunath H.
Appellant by me, madam. Last date
Appellant for
court
the
commissioner appoint, madam.
Respondent.
Tenant and subsequent
Waiver.
purchaser dispute, my lord. Rajesh Nagar property. I have filed the application for appointment of
Why
court
it was
commissioner.
deferred?
My lord, it was at the stage, my lord, the tenant, my lord, is contending that though the electricity power connections surrendered to the BESCOM, they are continued in possession and they are stated. Therefore, appointment of commissioner.
Commissioner ಅಂತ ಹೇಳಿ.
Generator run ಮಾಡ್ತಾ ಇದೀವಿ.
ಈಗ ಐ ಹಾಕಿದ್ರಿ.
Yes, my lord.
ತಗೊಳ್ಳಿ. ಪ್ರೇಯರ್ ಕೊಡಿ ನೋಡೋಣ ಏನಂತ. Appellant counsel has filed an application and order 26 rule 9 and 10 of CPC praying this court to appoint the executive engineer, Sri Rama Mandira subdivision, BBMP Bangalore or any other person as the court commissioner for observe and carry out the inspection and submit report regarding to note down the physical features of the scheduled property and observe such other facts that may be pointed out to the court commissioner by the parties and take photographs and prepare a plan or measure. Plan ಏನಕ್ಕೆ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲಿ ಸುಮ್ನೆ ಯಾರು ಇದ್ದಾರೆ?
Only question, my lord.
ಎಷ್ಟು occupation ಅಲ್ಲಿ ಯಾರು ಇದ್ದಾರೆ ಅಂತ.
And file the same along with the report.
Lord, only question involved, whether he is continued in possession or not is the question as a tenant.
Right. So
Issue only that aspect. Entire building are not required.
counsel appearing for the respondent to contend that the only issue is only with regard to make local inspection and report whether business ಅಲ್ಲಿ ಏನೋ ಮಾಡ್ತಾ
Juice center, he is running juice center.
whether the
Connected matter ಅಲ್ಲಿ
juice
ಜಿಂಬು ಸ್ವಾಮಿ.
ಅಲ್ಲ,
Whether the
ಇದ್ರದ್ದು
juice
ಮಾತ್ರ
center
ಹೇಳಿ sir.
running in the premises and not for any other work to the commissioner. ಇವ್ರು ಹಾಕ್ಬೇಕು ಇಂಜಿನಿಯರ್ ಯಾರೋ ಒಬ್ರು
ಹೌದು,
ಅಡ್ವೊಕೇಟ್
ಅಷ್ಟೇ ಸಾಕು ಸ್ವಾಮಿ.
Having heard the appellant counsel and also the counsel appearing for the respondent, dispute is with regard to continuing of the business in the premises. Since the same is in dispute and appellant claims that still continued the business and the respondent submits that no such business is continued in the premises. And when such dispute, an advocate is enough to make inspection and submit the report whether the juice center is continued in the said disputed premises or not. ಯಾರು ಹೋಗ್ತಿರ್ರಿ ಸ್ಥಳಕ್ಕೆ ಈ ಸಂಡೆ? ಎಲ್ಲಿರೋದು ಇದು?
ಇಲ್ಲ ರಾಜಾಜಿನಗರ.
ರಾಜಾಜಿನಗರ.
ನಾಳೆನೆ ಮಾಡ್ಬೋದು. Day after tomorrow ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. Small issue only.
ಸಂಡೆ ಹೋಗ್ಲಿ ರೀ, 2 ದಿವಸ ರಜಾ ಇದೆ ಸಾಕು.
ನಾನ್ ಸಂಡೇ ಇರಲ್ಲ ಅಂತ. I will not be stationing.
ನೀವು ಇರಲ್ವಾ? ಯಾವತ್ತು ಇರ್ತೀರಿ ಹೇಳಿ ನೀವು?
Day after tomorrow, Friday or.
ಇಬ್ರು ಸಂಜೆ 5 ಗಂಟೆ
ಆಯ್ತು.
ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗಿ. ಕೋರ್ಟ್ ವರ್ಕಿಗೂ ತೊಂದರೆ ಆಗೋದು ಬೇಡ. ಆಮೇಲೆ ಅಲ್ಲಿ ಯಾರು ಮೇಡಮ್ ಹೋಗ್ತೀರಾ? ಹೋಗಿ. ಕೌನ್ಸಿಲ್ ಶ್ರೀಮತಿ KP Jayalakshmi is appointed as court commissioner and make local inspection and submit the report, and no notice is required to be issued to the appellant counsel and also the counsel for the
Respondent one.
Respondent.
One and
Directed to make local inspection at 5 PM on 8/11/24 without expecting any notice. And submit the report on ಯಾವಾಗ ಹಾಕ್ತೀರಾ ಮೇಡಮ್? ಹೋಗಿ ನೋಡೋದು ಅಷ್ಟೇ, ಬರೋದು ಅಷ್ಟೇ. ಇದೊಂದು ಬಂದು ಹಾಕೋದು. ಇಬ್ಬರು ಯಾರು ಇದಾರ ಇಲ್ಲ? ಜ್ಯೂಸ್
ಒಂದು ಸಬ್ಮಿಷನ್ ಇದರಲ್ಲಿ connected matter 6562 arising out of the same common order. Another tenant of the very same building. ಅದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡಿಸಿದ್ವಿ.
ಹಂಗಂತ ಹೇಳಿ ಎಲ್ಲಾ ಬಿಲ್ಡಿಂಗು ಆ ತರ ಮಾಡಿದ್ರೆ ಇಟ್ ಈಸ್ ಮಿಲಾರ್ಡ್.
ಅದರದೇನು ನಾವು ಮಾಡಿಲ್ಲ.
ದಟ್ ಈಸ್ ಈವನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ.
ಲಾಸ್ಟ್ ಡೇಟ್ ನಲ್ಲಿ ಸೇಮ್ ಕಾಮನ್ ಆರ್ಡರ್.
ಅದು ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ಡ್ ಆನ್ ಐಎ ಅಂತಿದೆ. ಐಎ ಅದರಲ್ಲೇನು ಐಎ?
ಸೇಮ್ ಐಎ.
Executive engineer ಅಂತ.
ಸೇಮ್ ಫ್ರೇಮ್. ಸೇಮ್
ಅದೆಲ್ಲಿದೆ?
ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಸೇಮ್. ಅದು ಅಲ್ಲಿ ಜಿಮ್ ರನ್ ಮಾಡ್ತಾ ಇದೀವಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ your lordship, they are saying Jim. Kindly see their pleadings before the court. Pleadings is contrary to.
ಅದನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊ ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಮಾಡ್ಕೊಂಡ್ ಬರೋದಕ್ಕಲ್ಲ, what they are saying running Jim.
ಎರಡು ನೋಡ್ಕೊ ಬರ್ಲಿ ಬಿಡಿ.
Same building.
ಅಲ್ಲ ಇಲ್ಲಿರೋದು ಪ್ಯಾರಾ page 45 may kindly look at Millard.
ಇನ್ನೊಂದ್ರಲ್ಲ
House.
ನೋಡಿ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನ್ ಹಾಕಿದಾರೆ ಮೇಡಮ್ ಇದ್ರೆ?
ಅದು ಕಂಟಿನ್ಯೂಷನ್ ಆಗಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ ಅನ್ನೋದು.
ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಇವತ್ತೇ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು.
Pagination ಅದೊಂದೇನಾ? The appellant counsel is directed to comply with office objections forthwith. Dependent signature. ವಕಾಲತ್ ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ?
ಕೇವೇಟ್ ಅವರು ಹಾಕಿರೋದು ಆಪೋಸಿಟ್. ನಾವು ಫೈಲ್ ಮಾಡಿದಾಗಲೇ ಹಾಕಿದ್ವಿ 23/9/2020.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಯಾರ್ದದು?
ಅದು ಸೇಮ್ ಅನದರ್ ಟೆನೆಂಟ್ ಈಶ್ವರರಾವ್, JK ಈಶ್ವರರಾವ್. ಈಸ್ ರನ್ನಿಂಗ್ ದಿ ಜಿಮ್ ಯುವರ್ ಆನರ್ ಇನ್ ದಿ ವೆರಿ ಸೇಮ್ ಬಿಲ್ಡಿಂಗ್.
ಸಿಗ್ನೇಚರ್ ಅಲ್ಲಿ ಇದೆ ಒಂದು.
ಪ್ಲೈಂಟ್ ಅಲ್ಲೆಲ್ಲ ಕಾಣಿಸುತ್ತೆ. ಪೇಜ್ ನಂಬರ್ 43 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಪ್ರೆಸ್ಡ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲ.
ಮೇಡಮ್ ವಕಾಲತ್ ಇದೆ ನೋಡಿ. ಕೇವೇಟ್
ಅವ್ರು ಹಾಕಿರೋದು.
ಅವ್ರು ಹಾಕಿರೋದು ಮೇಡಮ್.
ಇದ್ರಲ್ಲಿ ಸೇಮ್ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಜಿಮ್ ರನ್ ಮಾಡ್ತಾ ಇದೀವಿ.
ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಇರೋ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ. ಈಗ ಡಿಪೋನೆಂಟ್ ಅದ ಡಿಪೋಸಿಷನ್ ಇತ್ತವಳೆ ಅಂತದ್ದು ಅಫಿಡವಿಟ್, ಸೋರ್ನ್ ಅಫಿಡವಿಟ್.
ಇಲ್ಲ ಇದೆಯಲ್ಲ ವೆರಿಫೈಂಗ್ ಅಡಬಿಟ್ 39 ಪೇಜ್ ನಂಬರ್ 39. ಪೇಜ್ ನಂಬರ್ 39 ಕೈಂಡ್ಲಿ ಬಿ ಪ್ರೆಸ್ಡ್.
ಕೇವೇಟ್ ಅವ್ರು ಹಾಕಿಲ್ರಿ. ಕೇವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿದ್ರು. ಇವ್ರು ಅಪಲೆಂಟ್ ತಾನೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು. ಕೇವೇಟ್ ಹಾಕಿ ಬರುತ್ತೆ.
ನಮ್ದು ಪೇಜ್ ನಂಬರ್ 39 ಇದೆ.
ಅಪೀಲ್ ವಕಾಲತ್ ತಗೊಂಡ್ರಿ ಆಯ್ತಾ ಮಂಜುನಾಥ್? ಈಗ ಕೊಡಿ, ಅಷ್ಟೇ ನೋಡ್ಬೇಕಾಗಿರೋದು. ಸಿಗ್ನೇಚರ್ ಇವನ ಹೆಸರೇನ್ರಿ?
JK ಈಶ್ವರರಾವ್. ಈಶ್ವರರಾವ್.
ಈಗ ಯಾರು ಅಫಿಡವಿಟ್ ಹಾಕಿರೋರು?
ಅವರೇ ಈಶ್ವರರಾವ್. ಅವ್ರ ಕನ್ಫ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದು ಮಾಡಿದ್ರು.
ಏನ್ರಿ ಇದು ಸಿಗ್ನೇಚರ್?
ಅವ್ರದ್ದು ವಕಾಲತ್ ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವರು ಇದ್ರಲ್ಲೆಲ್ಲ ಅದು ಪ್ಲೈಂಟ್ ನಲ್ಲಿ ಇರೋಂಥದ್ದು ಸೇಮ್ ಇದೆ ನೋಡಿ ಸರ್. ನಾನು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಐ ವಿಲ್ ಕ್ಯೂರ್ ದಿ ಡಿಫೆಕ್ಟ್ ಬೈ ಫೈಲಿಂಗ್ ದಿ ಫ್ರೆಶ್ ಅಫಿಡವಿಟ್. ನಾವು ವಕಾಲತ್ತಲ್ಲಿ ಮಾಡಿರೋದನ್ನ ನಾವು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿರೋದಿಲ್ಲ ಸ್ವಾಮಿ. ಅವ್ರು ಬಂದಿದ್ದಾಗ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿರ್ತೀವಿ.
ಆಯ್ತ್ರಿ, ಅವನ ಹೆಂಗ್ರಿ ಡಿಫರೆಂಟ್ ಆಗಿ ಸೈನ್ ಮಾಡ್ತಾನೆ?
ಡಿಫೆಂಡೆಂಟ್ ಆಗಿ ಸೈನ್ ಮಾಡಿಲ್ಲ, ಡಿಪೋನೆಂಟ್
ಆಗಿ ಸೈನ್ ಮಾಡ್ತಾನೆ.
ಡಿಫರೆಂಟ್ ಅಂತಂದ್ರೆ ಅವರು
ಫೋರ್ಜರಿ ಮಾಡಿರೋದು
ಇಲ್ಲ
ಅಷ್ಟೇ
ಅವರೇ. ನಾನೇ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ ಸರ್.
ನೀವು ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ರಿ, ಬಟ್ ಇಟ್ಸ್ ಫೋರ್ಜರಿ. ಈ ಎರಡು ಸಿಗ್ನೇಚರ್ ಕಳ್ಸೋಣ.
ಕಳಿಸಿ ಆಯ್ತು. ಐ ವಿಲ್.
ಮತ್ತೆ ವಕಾಲತ್ ಅಂಡ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ನೋಡಿರಿ ಡಿಫರೆಂಟ್ ಇದೆ.
ನಮ್ ಮುಂದೆನೆ ಮಾಡಿದ್ದಾರೆ. ಅದರಿಂದ
ಈ ಸಿಗ್ನೇಚರ್ಗೂ ಲಾಟ್ ಆಫ್ ಡಿಫರೆನ್ಸ್.
ಐ ವಿಲ್ ಕೀಪ್ ದ present him before this honorable court. I got no objection for.
No, ಒಂದೇ allow ಮಾಡೋದು, ಇದು ಮಾಡೋದಿಲ್ಲ.
I rectified.
ಇದರಲ್ಲಿ
rectified affidavit.
Even page 33 may look at Millard appeal memo.
Sending the entity.
Page 33 ನಲ್ಲಿ ಇರೋದು wrong entire content. Page what they are saying running regime. Page 33 saying that selling the stamps and different seals.
ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಮೇಡಮ್,
seal ಎಲ್ಲ ಮಾರ್ತಾರೆ ಅಂತ.
Another IA is also filed in MFA 6562 of 24. The office has raised the objection that the wakalat found in the appeal memo and also in the affidavit filed along with the application signature varies, and this court also compared the same, and on comparison of the same also both the signatures are different, and hence the very IA is rejected. IA is rejected. Ashte told. Rejected. The
Reports should be submitted in the first appeal Millard report.
The council court commissioner is appointed to directed to submit the report on 12/11.
I will submit the appeal petition to the
commissioner. Fee of rupees ಎಷ್ಟು madam visit ಹೋಗಿ ಮಾಡ್ಕೊ ಬರಕ್ಕೆ
5,000.
5,000 is fixed to pay the same by the appellant.
Apply.
27 Vinitha PC Shankar Vasiraj.
Appear for respondent, my lords.
I appear for appellant.
I am filing for two memo, my lordship.
memo for the recent Rajasthan court, Bilwara court has passed order for recovery proceedings has stayed. And one more is medical records of he is surviving cancer patient.
Copies have not
One more.
furnished.
Please put the other side ಗೆ.
I can show.
ಏನಿದು?
ರಾಜಸ್ಥಾನ್ ಕೋರ್ಟ್ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ 83,000 ಇದು ಆಗಿತ್ತು ಆರ್ಡರ್ ಆಗಿತ್ತು. The recovery proceedings stays along with I have filed a translation copy. Kindly see the
Lordship, as per my.
translation copy I have filed it along with. ಅಲ್ಲಿ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ. The kindly see the translation copy.
The case of above mentioned subject on one, the proceedings for recovery of interim maintenance in the case of opposite party residing at flat number so and so main. State till further orders.
Stay.
The recovery warrant issued in the.
10.10 up to
Warrant.
recovery of warrant.
10-10-24
10-10.
10-10-24 ಏನಾಯ್ತು?
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಇದು ಸ್ಟಿಲ್ ಸೇಮ್ ಆಸ್ ಇಟ್ ಇಸ್ ಸ್ಟೇಟಸ್ ಕೋ.
ಮೊದಲು ಮೇಂಟೆನೆನ್ಸ್ ಆರ್ಡರ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದು ಯಾರು?
ಅದು ಸೇಮ್ ಕೋರ್ಟ್ ಓನ್ಲಿ.
ಸೇಮ್ ಕೋರ್ಟ್ ಮತ್ತೆ ಸೇಮ್ ಕೋರ್ಟ್
ಸೇಮ್ ಕೋರ್ಟ್ ನೋ ಸೇಮ್ ಕೋರ್ಟ್ ಇಸ್ ಸ್ಟೇಡ್.
ಅಗ್ರಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಮಾಡಿದೆಲ್ಲ ಸ್ವಾಮಿ.
ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್ ದೇರ್ ಓನ್ ಆರ್ಡರ್ ಕ್ಯಾನ್ ಸ್ಟೇ.
ಅಲ್ಲ ಸೇಮ್ ಕೋರ್ಟ್ ಇಸ್ ಸೆಲ್ಫ್ ಸ್ಟೇಡ್. ಲಾಸ್ಟ್ ಡೇಟ್
ಆಗುತ್ತೆ ಅಂತ ಕೇಳಿದೆ ನಾನು.
ಅಲ್ಲ ಅದು ಅಲ್ಲಿ ಏನಾಗಿತ್ತು without the assets and liabilities filing, the previous judge has passed the order. And on that ground, the same similar judge has came, then the court has stayed.
Already whether the very same court can stay the very same court order.
The same court has stayed, I don't know about.
Let the.
And last date of hearing.
How it will come in the way? Last time
last date of hearing, the clarification is this court has observed that the 14/6/23, the MC petition has filed before the family trial court, and same day has the respondent has called to Phoenix Mall.
ಈ ಆರ್ಡರ್ ನಲ್ಲಿ ಒಂದ್ಸರಿ ಆರ್ಡರ್ ಕೊಟ್ಟ ಮೇಲೆ ಮತ್ತೆ ವೆರಿ ಸೇಮ್ ಕೋರ್ಟ್ ವಿತೌಟ್ ಹಿಯರಿಂಗ್ ದಿ ಅದರ್ ಸೈಡ್ ಹೌ ಕ್ಯಾನ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಪಾಸ್ ಸಚ್ ಎನ್ ಆರ್ಡರ್?
I can clarify.
State till further orders ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Number was changed.
Number was changed. The petition, other petition file ಆಗಿದೆ ಸ್ವಾಮಿ. Last building the court change. The court ಬೇರೆ ಕೋರ್ಟ್ ಹತ್ರ ಇದು ಮಾಡಿದ್ದಾರೆ. Appellate court mostly. The case number is 3-3-2-24. She miss 319 ಅಲ್ಲಿ ಇದು ಆಗಿತ್ತು ಆರ್ಡರ್ 83,000 ಪಾಸ್ ಆಗಿದ್ದು.
ಆಯ್ತು ಬಿಡಿ, ಅದು
ಅದರ್ ಕೋರ್ಟ್
ನಿಮ್ಮಿಬ್ರು ಬಿಟ್ಟಿದ್ದು ನಾವೇನು ಇದರಲ್ಲಿ.
No, last
issue is only with regard to
the injection. Injection. The
ಇದೇನು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನ್ ಹಾಕಿದೆ?
medical, he is surviving cancer patient, my lords. He is surviving cancer patient. The appellant is admitted in appeal memo itself. They are only admitted in. He is surviving cancer severely. And last time this court has observed that on 14/6/23, the MC petition same day filed the trial court, and he called for discussion this one Phoenix Mall. But the main intention is the MC filing. My client suggested me. Main intention of the MC
divorce petition file ಮಾಡಿ on the same day.
ಅದ main intention ಅವಳು ಇದು the both marriage is second marriage, both are divorced. At least my client he should not broken again his life, matrimonial life. For fearing purpose, he filed the petition before the matrimonial case in MC trial court. And same day, my lawyer has called to her, and he instructed to your husband has filed the MC petition. Kindly come with the mediation and resolve the matter. But the last date of hearing, the appellant has misguided this court. Is stating that he is throwing out of the court on that reason. We have the file the MC petition.
Sir, the moot question is, you have filed divorce petition.
Yes.
ಹೌದಾ?
Yes.
On the same day evening,
ಅದೇ ಅವಳಿಗೆ
you called your wife.
Wife.
Come to particular place.
Yes.
Why you called her? Once you have filed the divorce.
No,
petition-
regularly, we,
Ah,
same
their
day.
allegation is that by calling
Yes,
her to
yes,
the
kindly.
mall, you went and removed all
No, my
belongings to
lordship, I
her
can.
and thrown out her from
no,
the
what-
premises.
last
That is their case.
No, last setup, they are misguided this court. He used to, whatever the Ola, Uber, she is booking, the respondent is booking. Kindly, I have placed it before this honorable court, kindly see in past, how many, past days and past years, he is only booking that WhatsApp chats record they have placed it before this court in last date of hearing. And they are stating that. And same day, how can they knows, my lordship, if same day 14/6 only, if MC petition filed, how they will know? If one, at least 15 days it will take for notice. My lawyer is suggested for them, at least come to mediation.
You answered to my question. After filing of the divorce petition, why you sent a message to her to come to a particular place, that is mall?
That only I am suggesting. I'm praying for this honorable court. He used to book every day,
ಆಯ್ತ್ರಿ, ನೀವ್ ಯಾಕ್ರಿ MC petition file ಮಾಡಿ, divorce petition file ಮಾಡಿ ಬೆಳಗ್ಗೆ?
ಅಲ್ಲ, ಅದು discussion.
ಸಂಜೆ ಯಾಕೆ ಮಾಲಿಕ್ ಕರೆದ್ರಿ?
ಅಲ್ಲ, for discussion for my lordship.
ಏನ್ ಡಿಸ್ಕಷನ್?
ಅಲ್ಲಿ ಮನೆ ಹತ್ರ
ಕೋರ್ಟ್ ಹೋದ್ಮೇಲೆ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, at least ಮಾತುಕತೆ ಆಡಿ ರಿಸಾಲ್ವ್ ಮಾಡಾಮಿ. She used to do this simply. She past days she is harassing him.
Fraud on the
And she obtained in the trial court is clearly observed that they suppressing the fact in the court material, whatever they posted before this in Rajasthan court, they are stating that in obtaining in 83,000 of the maintenance, they themselves stating that
83,000 ಅಥವಾ 5,000?
no, my lordship. ಅಲ್ಲ, ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ
competent court decide the same.
The clearly observed, kindly see the trial court judgment, my lordship. Order copy, kindly see the trial court order. Clearly observed that the findings, reasons, the purpose of discuss both the points together in order to avoid the petition of fact as they interconnected another requirement. Require common discussion. Plaintiff has filed this suit for grant permanent injunction in favor of the plaintiff, restraining the defendant anybody claiming through him interfering peaceful possession enjoyment of scheduled property along with the plaintiff. The plaintiff filed an order I number 3 and I 39 rule 1 and 2 CPC temporary injunction restraining the defendant interfering with her peaceful possession. She stating that her peaceful possession, she has not any records placed before the trial court, my lordship. She is not having any title and any rights over the property. I have placed I am having the title and ownership. I have placed before the trial court the sale deed. Till disposal of this court order on 18/7/23 granted temporary injunction in favor of the plaintiff restraining interfering the peaceful possession of the suicidal property. Para number 8. After the appearance of the defendant had filed I number 7 and order 39 rule 4 151 CPC to vacate the interim order injunction several grounds, specifically that absolute owner of suicidal property, strength of ex parte order, plaintiff is not allowing him the entire suicidal property. It is further contended that the permanent resident of Bhilwara, Rajasthan, she obtained ex parte order. She is staying in Bangalore. She has not filed any one petition except OS 297, my lordship. All cases she filed in FIR and FIR along with miscellaneous petition 125 maintenance petition, another FIR. All cases she filed before the Rajasthan only. It clearly shows that she is residing in Rajasthan itself. The trial court is clearly observed that obtained ex parte order injunction suppressing the material fact with malified intention to harass the defendant who is a cancer survivor suffering from the acute diabetes. From this conduct of the plaintiff, the defendant is constrained to stay the paying guest, PG. He is the owner, he is staying till today, till 1.5 year PG. On all of this contention, defendant impressed upon the court vacating the ex parte order granting in favor of the plaintiff. In this scenario, let us examine the contention of the plaintiff.
it is stated that plaintiff, I number 3, that she is the legally wedded wife. Defendant in apartment portal is mentioned that both the plaintiff and defendant are the owner. In apartment portal, they are not having any title, they are not having joint ownership in share deed. Simply they showed in apartment portal the joint owner. This misguided in the trial court. She has been in possession and enjoyment of suitable property along with the defendant from this part of pleading. Obviously, according to the plaintiff, both the plaintiff and defendant are the owners of the suitable property. On other hand, document placed by the defendant, I have placed before the material registered agreement to the share deed on 26/9/2009 reads that defendant here in the purchaser of the suitable property valuable sale consideration. The name of the plaintiff is not reflected. The clearly stating that in the said registered document, mere mentioning that plaintiff and defendant are the owner of scheduled flat in apartment portal does not indicate that plaintiff is also the joint owner suitable property. Moreover, the plaintiff has not placed any such document to show that her name is entered in the owners in the apartment portal. It is settled principle of law that no order of injunction shall be granted against the joint owner or co-owner in the property. In the present case, defendant is the absolute owner of this suitable property. Plaintiff on strengthen on marital relationship with the defendant obtained snatch the ex parte order injunction by the suppressing the true fact. What true fact before the,
According to you, where
What?
she is staying now?
according
to you.
my lordship, according to my knowledge, whenever necessary about the OS and OS 297 suit, whenever necessary, she will come before this in Bangalore. As per the whichever material court records findings, court observed that two FIR filed in Rajasthan. One is a cyber crime. One is 498A.
You are not answering to my question.
No, it clearly shows the
Where she is staying now?
Rajasthan itself. She is staying in Rajasthan, Bilwara. Yes, my lordship, absolutely. She is clearly shows the document.
Go to the impugned order in paragraph number 8. What you have pleaded before the trial court?
Which one? After paragraph 8, my lordship. After appearance of the defendant has filed I number 7 under 39 rule.
One sentence from this conduct of the plaintiff, defendant is constrained to stay in paying.
Oh yes, PG.
In paying guest accommodation.
No, defendant is staying. I am staying in PG right now. I am staying PG, my lordship.
Who is in occupation of the premises?
She will only intention. Her intention is harass. She will door lock it and she will go to the Rajasthan, my lordship. Her intention only snatch the property. She is for compromise purpose. She spoken with me 1 crore. Either 1 crore you have to give the amount. Either you have to give the flat. In previous similar cases only she filed previous most probably maybe in previous also she took the divorce. This type of attitude, if I give a no compromise, she will marry another one. How the court, how she will play the court of law, my lordship, misrepresenting.
Lordship.
She is habitual, then that means.
Yes, but
Lordship, only
The
three
court, no, last time clearly they argued, my lordship, the opportunity should be given me.
But no, I mean,
so many grounds I am having. Kindly see the para number 9 of the order. In the scenario, let us examine the contention of the plaintiff. It is stated that plaintiff.
You are reading the order of the
Yes, yes, my lord.
trial court.
Yes, my lord.
I have already read the order.
And my humble submission is this honorable court. My main grounds is the respondent is the cancer patient. He cannot stay in PG. If any cancer patient is staying in in PG, what about the other persons? They will fear about. He mostly required, and he want to take the help of his parents, my lordship. On that ground, they vacated the order. There is no error in the trial court order. In whichever FIR has been filed against me, against me, that FIR itself, kindly see the FIR copy. FIR copy of the page number I have placed before 276 in objection. Kindly see the
Again, madam, any,
Lordship,
one second, ನನ್ನ
Yes.
question ಗೆ ಮೊದಲು answer
FIR B report ಆಗಿದೆ ಸ್ವಾಮಿ.
Any chance of reunion?
She has filed a petition for restitution only.
Aye,
That is the reason she did not file take shelter in domestic violence case. She would have taken, she would have filed. That is the only reason she did not file. Even restitution, the mediation, it was, he never turned up. And whatever they are making a submission here, that 83,500 preparing that case also. Then a warrant was issued. Then that warrant was got executed through the
Now,
commissioner here.
We complied.
It is executed now, according to him, it is stayed.
There's court of law, my lordship.
In state, that is next for arrears. Only to get away with that arrest, he had made a meager payment in the police station and just escaped. And in fact, your lordship, cancer survive every now and then he is making a submission. It is after curing, it is the appellant who took care of him, went to Bombay, they took a treatment and everything. I just highlight the dates, your lordship. March 1st, he executed wakalat. 10th of March, he takes her to the IVF. No, I mean,
March 1st for filing of divorce petition.
divorce petition.
Divorce petition.
Yes, and I have placed it, your lordship, on record. And what he is saying, he is staying in PG, it is on his own wish, because I have the video clippings and everything. And voluntarily, he took all her jewelry and went. And he is stating that FIR and all, in between, he has stated that he has, when the last time your lordship has posed a question, why he had sent a text message asking her to come to a mall. He said in between that for a discussion. If that was the case, your lordship, why did he go to the house and took all her valuables and told the manager and he vacated? All these things are recorded in the apartment CCTV. All footage I have produced, it's a part of record. And now also I may be permitted to, it is a copy. Along with 65, because electronic, it is. And in fact, your lordship, and as he is saying PG and all these things, your lordship, and the court before the Rajasthan court, after looking into his salary and assets and liability, has passed a well-deserved maintenance order. That also.
What are these photographs?
Photographs, he's saying he's staying in PG and he's not. This is all now recently, he's saying cancer survival and all these things, your lordship. He is enjoying and he's going and he's only he's saying and coming.
Means I should not enjoy.
No, you have all the right.
You want to harass it
Cancer
only.
patient can also enjoy.
But
Life is short.
lordship, only one submission till he gets cured. Now he is not a cancer patient. Initial stage, it is the appellant who took care of him. And now after it is cured and everything, he just, asked her to leave. In fact, if she wanted to go separate or anything, she would not have filed the restitution petition, your lordship. And when it is referred to mediation, he should have participated in
How
that.
you want to join him?
She was always ready.
Henry.
And in fact, your lordship, in fact, he is telling, this is the submission.
Nim suggestion on Nim.
I'm telling you, Kelly.
Region also hotage.
He is not ready to take
He is
her
not
back.
ready.
Yes, FIRs on myself and my family.
She is going to withdraw all cases also which have been filed. Now whether she is going to withdraw all the cases. You need not pay the maintenance also, whether you are ready to take care of her.
My lord, just my mistake is I got into a fake marriage. That's, I got into the fake marriage. That's the only reality and that is my only mistake.
Fake marriage?
Yes.
Why?
Yes, my lord, this was everything pre-planned. She has done in previous marriages also.
You would have verified before the marriage.
That's the, sir, I have already done.
Yours is also a second marriage.
Yes, both.
So you are having first experience also.
No, first is mutual. First one is mutual, my lord. First one is mutual.
How you will fall into the second marriage of fake marriage?
No, matrimonial. The matrimonial side will Nowadays, so many is happening, matrimonial, only the.
Now there is an admission on the part of you. He is staying in a guest PG. And it means that you are not in possession of the premises. Then I will pass an order. Or let
No,
it-
no, my lord,
let it
Tipo.
There in the PG itself.
No, as per my observation,
That is the
she
case.
kindly see I have filed it objection kindly.
Your objection only the referred by the trial court.
My
in
lordship,
passing an
kindly,
order.
no, kindly see the page number 64.
From this conduct
tra-
of the plaintiff,
no, the-
defendant is constrained to stay. in
Suppressing fact, my lordship,
guest accommodation.
court suppressing.
This is your pleading, Ray. That is your pleading. That has been extracted by the trial court in paragraph number 8. That he is staying in PG. Now also you said that he is paying in PG only.
No, Section 7, the Section 7 Family Court has, the Family Court Act does not have the entertain the petition itself, my lordship. I am having the citation, kindly see the. Kindly see the Allahabad High Court judgment, so kindly see. Section 7 itself does not having the entertain the petition.
Madam, why you have pleaded in case number 319 of 23?
Can I read, my lords?
Which was filed on 31/7/23. That is
Correct.
extracted in paragraph number
I will-
11
I'll
of the order of the
clarify.
trial court.
I'll clarify that. Last
Where
occasion, I
categorically
clarified.
stated that due to which the plaintiff is forced to live with her parents.
I'll clarify that. Last occasion, I clarified.
Hmm.
When 14, when he had called her and when she had gone to the Phoenix Mall and he had vacated.
Removed her belongings.
Yes. Then immediately I went and lodged a complaint, FIR,
Where
jurisdiction Ramurthy Nagar.
Here
Police.
in Bangalore?
Yes,
Then-
please, your lordship. Then they did not entertain my complaint. Then I had to wait. My parents had calmed down
Hmm.
from Rajasthan.
Hmm.
After 10 days, on 24th, my complaint was registered after knocking the door of police.
Yes.
In fact, he filed a FIR against her whole family members who were not there at all, because after marriage, only 2 of them, they were staying here.
Hmm.
The one more conduct of him, your lordship, I just bring it to your notice, that as I already mentioned, the dates, then subsequently after that IVF procedure, then he insists her
On what date went for
10th
IVF
10th
procedure?
of March,
10th of March. March
March
of
of
23 or 24?
23.
That is prior to this incident.
No, I'll come to that. Then followed
What date divorce petition was? filed?
14/6. That is what I'm telling.
14/6, that is.
Correct.
ಹಿಂದಿನ ಸ್ಟೋರಿ ಬೇಡ, ಮುಂದಿನ ಸ್ಟೋರಿ ಮಾತ್ರ ಹೇಳಿ.
14/6 petition ವಕಾಲತೆ ಮಾರ್ಚ್
ಹಿಂದಿಂದೆಲ್ಲ ಬಿಟ್ಬಿಟ್ರಿ, ಹಿಂದೆಲ್ಲ
ಆಯ್ತಾಯ್ತು.
ಚೆನ್ನಾಗಿತ್ತು, ಈಗ ಮಾತ್ರ ಡಿಫರೆನ್ಸ್ ಹೇಳಿ.
ಅಲ್ಲಿಂದ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ he came and I have all the video clippings.
ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್.
ಅದಾದ್ಮೇಲೆ
ಇಂಜಂಕ್ಷನ್
yes,
ಆರ್ಡರ್.
he came and put her out of the house. That is where I had to go to my parents. I had to take shelter.
ಇಂಜಂಕ್ಷನ್
Here.
ಆರ್ಡರ್ ನಿಮ್ ಪರವಾಗಿ ಆಗಿದೆ ಯಾವಾಗ?
ಹೌದು, that is on 17. That is
17/7/23.
yes, your lordship.
17/7/23.
Yes.
ಹಾ.
Subsequently, when he has put me out of the, and in between,
On what date he put her out from the house according to you?
that is after the immediately,
Injunction order was
the
granted on
17th, once the
17/7/23.
injunction order, we got it, we complied the injunction order. Once he got the notice, immediately after 2 days, he has done this.
Hmm.
So that is where she was scared. And
What is
one
the
more
date?
thing,
What is the date of filing of divorce petition?
14, 14/6,
14/6. Huh.
yes. That subsequently I have filed the injunction suit.
Hmm.
He has filed a divorce petition on 14/6.
Hmm.
Subsequent to that, I have filed the injunction suit. After when I have filed the FIR, it was not registered and all.
Hmm.
In the meantime, your lordship, some intimate pictures and of theirs when they were together and all, he tried to put on the social media and to send to her.
All fake stories, my lord.
After taking.
After.
My lordship, not at all related to injection suit. This is the bare in injection suit.
I will hear first.
No, not at all related to the fact of whatever they're stating. This is the bare injection suit purely based on the position.
Posing some questions to her, let her answer, then I will hear.
No
you.
fake story. What about the grounds?
I will hear also.
They're not observing grounds ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ. ಸುಮ್ನೆ fake story ಅದು ಇತ್ತು ಇದು ಆಯ್ತು ಕತೆ.
According to you, fake story, let her also make submission.
Yes, my
You are a responsible officer before the court. You
Yes,
make
my lordship.
submission before the
Sorry,
court.
sorry.
How you are practicing, she is also practicing.
Yes, my
Allow her
lord.
to make submission. Yes, madam.
Yes.
Order was passed on
17.
17/7/23.
Yes.
Interim injunction was granted.
Yes.
On what date he removed your belongings? That is immediate on the date
14th itself.
14/6/23.
Yes, yes.
Only removed the belongings, that's all. She was not prevented from
No,
residing.
no, he told the manager there only, to the apartment manager, to get out of the house.
Then,
That is what he has told on that very particular day.
yes. Then
Then-
how,
then-
how, if you have been removed from the house on 14/6/23 itself,
Then your lordship, the
then how
cops
you
have,
can, how you can get an order of interim injunction order on 17/7/23?
cops, your lordship, they, then where I have lodged a complaint, the cops have come, all I have the video recordings. They put me,
You are not answering to my question,
please,
madam.
your lordship,
Already he filed a divorce petition on 14/6/23.
please, please.
According to you, he called
Yes,
your client to come to a particular
Yes.
mall.
yes,
By that time, he went and removed your belongings.
yes,
That
please.
is on 14/6/23 itself.
Correct.
That means you have been thrown out from the house on that day itself,
Police
14/6/23.
put me back on the
That's what I am asking, on what date?
same date, your lordship. I have
Same
gave
day.
same date.
Ah,
That is what, same
but
date. they-
according to you, the police did not entertain your complaint.
My
on
complaint, they did not
14/6/23.
register FIR.
Then,
They had come to the premises. They did not register FIR. They did come to the premises and along with him only. And that's the reason I placed the CD, your lordship, where all the recordings, where the apartment CCTV footages are there. Then she was put in the possession. That is how I could, and I have clarified also, I never claimed I am the absolute owner. Nowhere I have claimed.
that is secondary, madam.
Correct.
You answer to the points only. Then why you went and filed petition on 31/7/23 stating that you are staying
He
with
was
your
threatening
parents?
me, your lordship. He was
Be
threatening.
threatening. What is your pleading before the Rajasthan court in case number 319 of 23 in paragraph number 4 of the said
Correct.
petition?
I,
Dated 31/7/23.
31,
This
and
is subsequent to the getting an order of injunction
correct, your lordship.
before this court.
Correct.
Then
He used to come to the premises, even though there was an injunction order, because he has a lawyer friend who's in the same condominium where he is residing, taking help of him, and he used to try to enter the premises. This is where he used to threaten. There are a lot of things which is the materials are.
When you pleaded, madam, plaintiff, due to which plaintiff is forced to live with her parents.
That is where, your lordship, because of the threat posed by him. That is where she don't have
But
any
you are,
more.
you are in possession of the premises
Yes,
which
yes.
you are residing?
Yes, please.
Then why
yes.
you made the
That is the
statement that you have
that is
been forced to
that
live with
that is
your
the
parents?
particular time when he has posed a threat and all, your lordship. That is where she did not have any other go. That is where her parents have came to
Also,
help.
while filing the petition, also you were given address of the Rajasthan.
Yes, my lord.
That is a parental
Bhilwara,
home.
Rajasthan.
Parental home, your lordship.
Parental home only.
Correct, your lordship. Parent, because that is why, because here, your lordship, she did not have any moral support when he was posing all this threat to her. That is where her parents came to help her out. Because they being there, your lordship, they could not help her here.
Now where she is staying?
Here, your lordship, only because of my only submission is that, your lordship, she is under the medical treatment for the IVF procedure, which he has insisted to undergo.
That is
which
long back, that is in the month of
No, no,
March,
it is.
March
he-
2023.
No, no, it is follow-up. I have produced all the documents.
March
Subsequently,
2023.
subsequently, that initiated on 10th of March. It is she has undergone.
Where is the admission in the objection statement that he is staying in guest house?
Pardon, your lordship.
In the objection statement,
Yes, your lordship.
where he has pleaded that he is staying in guest house? That's what the trial court has observed in the order of the trial court, that there is an admission.
His objection at page number 38, your lordship.
Page number?
38, that is IA 7's affidavit.
In your appeal memo,
Yes, your lordship.
OS number 297 of 23, page number 23. Defendant humbly submits. He is not allowed to reside in the house own residence because of the threatening and violent behavior of the plaintiff towards defendant. Defendant is ailing from several diseases, also constrained to live in PG. Paragraph number 3.
Yes, Your Lordship.
Inception of the marriage, so and so. Adala story gal aamele indi bada.
And everywhere he is saying PG. It is he who voluntarily left. And in fact, Your Lordship, here when the MC petition, it was referred to the mediation. Even in the mediation,
Where is the copy of the divorce petition, madam?
divorce petition, it is not part, I have not produced. the update.
Address ಯಾವ್ದು ತೋರಿಸಿದ್ದಾರೆ while filing the divorce
ಹಾ,
petition.
ಅದು ಕಂಪನಿ ಅಡ್ರೆಸ್ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ.
14/6/23.
They are stated in company address.
ಯಾರ್ದು?
ಇದು ನಾವು ನಾನು ಕೊಟ್ಟಿದ್ದು ಸೇಮ್.
Petition ಹಾಕಿರೋದು ನೀವು.
ನಾನು ಹಾಕಿರೋದು ಸೇಮ್ ಅಡ್ರೆಸ್ ಮೇಲೆ. ಸೇಮ್ ವರ್ಮಾ ಅಡ್ರೆಸ್.
14/6/23 address.
ಸೇಮ್ ಇದು ವಾಟ್ ಎವರ್ ನಾವು ಅಪೀಲ್ ಮೆಮೋ ವಿಲ್ ಬಿ ದೇರ್.
ಇಬ್ರದು ಸೇಮ್ ಅಡ್ರೆಸ್?
No. In MC petition, I am staying in
ನೀವು ಬೇರೆ ಅಡ್ರೆಸ್
ರಾಜಸ್ಥಾನ್ ಅಡ್ರೆಸ್ ಮೇಲೆ.
ಯಾರ್ದು?
ರಾಜಸ್ಥಾನ್ ಅಡ್ರೆಸ್.
ಅಲ್ಲ ನಿಮ್ದು ಕೇಳಿ.
ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ ಎಲ್ಲಿದೆ ಹೋಗ್ಲಿ ನಮ್ಗೆ ಹೇಳಿ ಎಲ್ಲಿದೆ ನಾನೇ ನೋಡ್ತೀನಿ.
ಇಲ್ಲ ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಕಾಪಿ ಹಾಕಿಲ್ಲ ಇಬ್ರು
ಹಾಕಿದ್ರು.
Because divorce petition was filed on 14/6/23.
Yes.
Next month this suit was filed.
MC address
Same address they have, same address he has given. Both the address, MC petition, both petitioner and Lordship, I could maybe permitted to produce the MC petition copy.
Five not five. ಎರಡು ಒಂದೇ.
OS ಅಲ್ಲಿ ಕಂಪ್ನಿ ಅಡ್ರೆಸ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಪರ್ಟಿ ತಗೊಳ್ತಾರೆ ಸ್ವಾಮಿ. ಈಗ MC petition ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಗಿ OS ಹಾಕಿದ್ದಾರೆ. They knows where I am residing. The suppressing that also, the cost title. Misrepresenting, you can kindly see the.
Even now, we don't know.
Company address ತಗೊಂಡ್ಬಿಟ್ಟು she knows before, because they filed FIR also, where I am residing, police came in PG. Kindly see the FIR copy, my lordship. My objection statement, kindly see the FIR copy, page number 31, 293 FIR, I am residing.
Admittedly, you are not in possession of the premises, counsel, according to your own admission.
No, possession, that means what about the, I am not defining or defining about the taking contention of the position. What is the ground for the it clearly shows that in Rajasthan Bilwara court, they are stating that in CMIS 319, I am thrown out from the house. The suppressing suppressing material fact, they obtained the 83,000.
No, counsel, there is no such averment that she has been thrown.
I can see the.
Where is that?
Kindly see the translation copy. Ide Swami. Kindly see my objection statement. Page number, along with translation copy of page number 62. Kindly see the paragraph number 4. That the behavior of the defendant has always been mental, physical, cruel towards the plaintiff, despite the regular discharge of all material duties by the plaintiff.
Where is the copy of the petition filed before the Rajasthan court in
No,
319?
order copy, maintenance order.
Not order copy, 319 petition copy.
Petition copy, we have not obtained, my lordship. The court application along with order copy. In order also, the court observed that I am thrown out from the court. She is staying in a parental material home.
The order passed by this.
Kindly see in the cost title also, they are stating that
Trial court
my
only-
company address, my lordship.
Court only
They
explained-
knows very well I am residing in.
Trial court only in the order stated that while seeking claim petition, It is stated that the behavior of the defendant has been and continues to be the cruel.
Oh, that
towards
only
the
I am
plaintiff,
reading, paragraph number
due to
4.
which the plaintiff is forced to live with
Yes.
her parents.
Yes.
Except this,
Hmm.
nowhere it is stated that she was thrown out from the petition schedule premises. Where is that the discussion?
No, that only I have filed in objection, kindly see. Page number 62.
You have a copy
In
of
translation copy of.
you have a copy of the petition, madam?
It's
Translation.
petition
319.
319. I,
Translation copy I have filed it, kindly see.
319.
And same order also, page number 66. Paragraph number first itself admitted that due to the cruel behavior of the petitioner was forced to live with her parents and she was thrown out of the house. This has observed before the trial court clearly. On that ground, the vacated the interim order and she is stating that I am staying in PG, in Costatal, in Rajasthan Bilwara court. Kindly see the Costatal respondent 09 solution employee ID number 210 9th floor. The pre-planned, everything is there, pre-planning, technically using my lordship. Their intention only to harass for me. Anyway, they want to get either from Rajasthan court of maintenance and they want to throw out from for me house also. Trial court clearly observed that. The owner itself, how can he stay out of the house? He is having title deed. That clearly observed in Allahabad High Court judgment that I filed before this honorable court. If permitted, I can read it. Which are now the FIR, none melu same FIR agutte, same offense. Our mel 424 FIR same still pending ide. None mel agirodu 2 FIR, the B report file agide adu. They are stating that.
ಅವಶ್ಯಕತೆ ಏನಿದೆ ಅಷ್ಟು ಮಾತ್ರ ಹೇಳಿ ಈ ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡಕ್ಕೆ.
ಅಲ್ಲ FIR ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದಾರೆ. FIR ಅವ್ರದ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಸೇಮ್ ಅಫೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಸ್ ಆಗ್ತದೆ ಅದು ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ
ಪೊಲೀಸ್ನವ್ರ ಕೆಲಸ. ಇದೇನ್ರಿ ಕಾಪಿ ನಿಮ್ಮ ಹತ್ರ?
I'm sorry, Your Lordship, I don't have the 319's petition copy. The order.
This court wanted to know whether
Yes.
there is a pleading that the appellant was thrown out from the house.
Swami clearly observed in order copy itself.
Order ಇದೆ ರೀ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
ಅಲ್ಲ ಪ್ಲೀಡಿಂಗ್ ಇದ್ಮೇಲೆ ಆರ್ಡರ್ ಕಾಪಿ ಆರ್ಡರ್ ಬರುತ್ತಾನೆ ಸ್ವಾಮಿ.
Counsel.
Lordship, I may be permitted.
Cannot be extended my lordship interim order.
Both the counsels are directed to produce the copy of the petition filed before the Rajasthan court in Simis ado.
Simis 319.
9 of 23. This matter next week al kodi date kodi.
My lordship interim order cannot be extended.
Interim order may be.
Simply harassing my lordship.
Interim order ಏನಿದೆ?
Interim order.
And next
sought for
till date
injunction.
ಇವತ್ತಿಗಿತ್ತು.
The interim order granted earlier is extended till next date of hearing.
Grateful.
28. 10 Basavaraj, Anil Kumar R.
Same connected matter. Next week.
230 million it was. You understood that matter could be taken up 230. They were supposed to file the documents.
Passed over ಮೇಲೆ. Documents ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ.
ಹಾಕ್ತೀರಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ನೋಡಿ ಪಾಸ್ ಓವರ್.
230 million.
ಪಾಸ್ ಓವರ್ ಅಂದ್ರೆ 230 ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡೋದಿಲ್ಲ. ಯಾವಾಗ ರೀಚ್ ಆಗುತ್ತೋ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
Mission matter 29.
This case appear for appellant Millard. Millard, for formation of Bangalore Asan Railway Broad Gauge Line Millard. The
delay in 1554 days.
After got the after taking the amount Millard, they have filed this appeal Millard.
ಆಯ್ತು ಮೇಡಮ್, ಯಾಕೆ ಡಿಲೇ 1554 days?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಮೀಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
5 ವರ್ಷ ಆಯ್ತು. 5 ವರ್ಷದ ಡಿಲೇಗೆ ಏನು ಹೇಳಿ ಫಸ್ಟ್?
ಪ್ಯಾರಾ ನಂಬರ್ 3 Millard.
Paragraph number
3 of the affidavit have stated Millard. In the similar, I submit that the above appeal is preferred by me as against the judgment and award dated 26/2/2015, passed in LLC number 178 of 2010 on the file of so-and-so. even though the judgment and award came to be passed on 26/2/2015 and I received the award amount on 17/11/2017. I further submit that in the first week of August 2019, when I go to my advocate office to inquire in the another matter, my trial court advocate has informed me to prepare appeal before the Honorable High Court of Karnataka because the trial court has awarded lower compensation in LS case, and he further informed that he could not able to attend the cases in High Court. Hence, he informed me to contact present advocate. My lord, thereafter he contacted me and I have filed the appeal, my lord. In the similar notification and similar village, my lord.
You have received the even award amount in 2017 itself.
17, my
Then
lord,
you
but
filed an appeal in 2019.
19, my lord.
Order was passed in the month of February 2015.
My lord,
Huh?
you don't know the legal procedure, my lord. Thereafter, my lord.
Is the only count? Third.
My lord.
Day number 1 of 19, and there is a delay of 1,554 days in filing the appeal. And reason assigned in the affidavit in paragraph number 3 that the judgment and award was passed on 26/2/2015. Even though judgment and award came to be passed on 26/2/15, and appellant has received the amount on 17/11/2017. And also it is stated that in the first week of August 2019, when we go to the advocate office to inquire in the another matter, the advocate has
28.
informed him to prepare an appeal before the High Court of Karnataka.
28/8, I have filed the appeal, my lord. Court fee also paid on the same day.
Could not able to attend the cases in High Court, hence he informed to contact the present advocate and immediately contacted the advocate and filed this appeal in 2019.
On 28/8/2019, I have filed the appeal.
And hence there is a delay in filing the appeal. Having heard the appellant counsel and also the reason mentioned in paragraph number 2 of the affidavit, it is very clear that the award amount was received on 17/11/2017 itself. And matter was also disposed of on 26/2/2015. And even after receiving the award amount in 2017 also, not filed any appeal. The only reason assigned that advocate instructed him to file an appeal in 2019 when he went and met the advocate. And the same cannot be a ground to condone the delay of 1,550.
And I will file a necessary application.
In a delay in
Affidavit, my
filing
lord.
the appeal, and hence no grounds are made out to condone the delay, and hence
My lord, I have
the delay.
paid the 60,000 court fee, my lord, in
4
this
days
matter. Like, in the similar circumstances, my lord, ship has
cannot be
order, my lord.
condoned. It's a clear case of negligence on the part of the appellant. Even after receiving the award amount, also not filed any appeal. Dissatisfied with the award amount granted. And having taken the amount also kept quiet for a period of 2 years and filed the appeal, and hence no reasons.
My lord, in this matter, my lordship, one submission, my lord. In this similar circumstances, my lord, lordship has passed the order, my
ಏನ್
lord.
ಪಾಸ್ ಮಾಡಿದ್ರು?
Same notification, same ಇದು.
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು?
2019 appeal is the
ಎನಾನ್ಸ್
same.
ಮಾಡಿದಾರೆ ಅಂತನಾ?
Please, my lord.
ಎನಾನ್ಸ್ ಮಾಡಿದ್ರೆ ಟೈಮ್ ಅಲ್ಲಿ ಬಂದಿದಾರೆ, ಎನಾನ್ಸ್ ಆಗಿರುತ್ತೆ.
ಇಲ್ಲ, ಅದು there is also delay, my lord. 2000 same judgment, my lord.
ಡಿಲೇ
Same ಅದ್ರೊಳಗೂ same days ಇದೆ ಸ್ವಾಮಿ.
ಪ್ರಶ್ನೆ ಎಷ್ಟು ದಿವಸ ಇದೆ ಡಿಲೇ? ಇದ್ರಲ್ಲಿ ಏನ್ ಡಿಲೇ ಇಲ್ಲ.
ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಡಿಲೇ?
ಡಿಲೇ ಇದೆ.
ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿದೆ
ಅಲ್ಲ,
ಡಿಲೇ?
ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ, ಅದ್ರೊಳಗೆ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಅಂದ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ ಮೊದ್ಲೇನೆ.
ಅಲ್ಲ, ಡಿಲೇ ಕಂಡೋನ್ ಆಯ್ತು ಅಷ್ಟೇನೆ, ಅದಕ್ಕೆ therefore my lord
ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇದೆ ಹೇಳಿ?
1000 days ಡಿಲೇ ಇತ್ತು ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ನೋಡಿ
ಅಲ್ಲ,
ತೋರ್ಸಿ.
ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಪಿಟಿಷನ್ ಇದು ಅಫಿಡವಿಟ್ ಮೇಲೆ. ಅಲ್ಲ, ಯಾಕೆ ಅಂತ ಅಂದ್ರೆ ಸೇಮ್ ಸಿಮಿಲರ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್, ಸೇಮ್ ಅನೌನ್ಸ್ಮೆಂಟ್ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಇನ್ ದಿಸ್ ಅಪೀಲ್ ಆಲ್ಸೋ, my lord.
This was filed in 2017 itself.
My lord,
This appeal was filed in 2017.
2017 ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್, my lord.
ನೋಟಿಫಿಕೇಶನ್ ಇರ್ಬೋದ್ರಿ, ಆರ್ಡರ್ ಯಾವಾಗಿಂದ ಹೇಳಿ?
ಅಲ್ಲ, ಡಿಲೇ ಇನ್ ದಿ LAC ಮ್ಯಾಟರ್, my lord, ಸುಪ್ರೀಂ
ಮ್ಯಾಟರ್ ಆದ್ರೇನು?
ಅಲ್ಲ, ಇದ್ರೊಳಗೆ ಅಲ್ಲ, ಆತರ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಡಿಲೇ ಮೇ ಬಿ ಕಂಡೋನ್ ಮೇಲೆ, ಅಲ್ಲ, ನೋಟಿಸ್ ಮೇ ಬಿ ಆರ್ಡರ್ ಮೇಲೆ ದೇರ್ ಆಫ್ಟರ್.
ನೋ ಗ್ರೌಂಡ್ಸ್.
ಅಲ್ಲ notice may be, ಅಲ್ಲ
Consider the averment made in paragraph number 3.
there is a Supreme Court judgment. I will produce the same, my lord.
Judgment ಅಲ್ಲಿ ನೀವಿದ್ದೀರಾ
ಅಲ್ಲ
ಇಲ್ಲಲ್ಲ? You have no locus to make any submission.
ಅಲ್ಲ I will submit, my lord.
Submission counsel?
My lord, kindly have it on Monday, my lord. I will produce the citations, my lord.
Reasons assigned is not satisfactory.
ಅಲ್ಲ my lord,
Down the delay.
my lord, I will produce the citation, my lord, in this matter, my lord. Same notification, same village, my lord. That is.
ನಂಗೆಲ್ಲ ಕೋರ್ಟಿಗೆ ಬರಕ
ಅಲ್ಲ ಇಲ್ಲ, ಅದು ಡಿಲೇ ಆಗಿರೋದು ಅವ್ರ ಕಡೆಯಿಂದ ಆಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ.
ನಾವೇನ್ ಮಾಡಕ್ಕಲ್ಲ.
ಅಲ್ಲ ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ನಾನು ಕೋರ್ಟ್ ಫೀ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, 60,000 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೀನಿ. ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಅಲ್ಲ ಕೈಂಡ್ಲಿ ನೋಟಿಸ್ ಮೇ ಬಿ ಆರ್ಡರ್ ಮೇಲೆ ದೇರ್ ಆಫ್ಟರ್
5 ವರ್ಷದ ಮೇಲೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಕ್ಕಲ್ಲ.
ಅಲ್ಲ 5 years ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು 5 years ಆಗಿಲ್ಲ.
1500
ಇಲ್ಲ 4 years ಆಗಿದೆ ಸ್ವಾಮಿ ಇದು. ಅಲ್ಲ ನಾನು ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಸೈಟೇಷನ್ ಮೈ ಲಾರ್ಡ್, ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಮಂಡೇ ಮೈ ಲಾರ್ಡ್. I have a citation, my lord, in this matter. My lordship, I am requesting my lordship in this matter. They lost 1 acre land, my lord, in this matter, my lord. ಅಲ್ಲ ನಾನು ಡಿಲೇಗೆ ನಾನು ಸಫಿಷಿಯಂಟ್ ರೀಸನ್.
ಕಾಂಪನ್ಸೇಷನ್ ನೀವು 2017
ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
19
ಅಲ್ಲ ಅವರು ಲೀಗಲ್ ನಾಲೆಡ್ಜ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ವಿತ್ ಇನ್ ಟೈಮ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಲೀಗಲ್ ನಾಲೆಡ್ಜ್ ಇಲ್ಲ.
No, compensation is paid later. I was not having any.
No, in the year 2017 they were taken.
The court fee. That is not the case.
My lord, kindly have it on Monday, my lord. I will produce the citation along with thereafter.
What is the time of the court?
My lord, I have citations, my lord. I will produce, my lord. Only one copy I have produced.
ನೋಡಿ ಅದನ್ನು ನೋಡೋಣ.
ಅಲ್ಲ one copy ಇದೆ ಅಷ್ಟೇ, ಅದಕ್ಕೋಸ್ಕರ.
It depends upon facts of each case. Condonation of delay.
Delay is
knowledge about the same, then it's okay.
I will submit on Monday, my lord.
Knowledge and also taken the.
My lord, I will submit on Monday, my lord. Same similar circumstances, my lordship has passed the order, my lord. ಅಲ್ಲ ಅದು ನಾನು ನೋಡ್ಬೇಕು ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಒಂದೇ ಕಾಪಿ ಇರೋದು. I will come on Monday, my lord.
2:30.
ಅಲ್ಲ ಮಂಡೇ ಸ್ವಾಮಿ, ಮಂಡೇ.
No date, 2:30.
ಅಲ್ಲ I will file the affidavit also, my lord, fresh affidavit file ಮಾಡ್ತೀನಿ along with.
2:30, whatever is there, you make submission. Yes, serial number 30. Yes.
Appellant, my lord, lordship may grant 1 week time, my lord.
The other day it was heard, someday reported judgment, order 23 rule 3.
You have to look into some decisions.
Lordship judgment is there.
Otherwise, pass over, my lord. He will gone to another court.
Compromise.
He was gone to another court.
Compromise decree, they filed a separate suit challenging compromise decree. Your lordship reported judgment is there. The last occasion it has been said.
There is another court, my lord. Lordship may grant 1 week time. Week time, my lord. He has to looking into some decisions.
ಎರಡು ಧಾರವಾಡ ಬೆಂಚ್.
ನೋಡ್ಬೇಕು ಅಂತ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ. ಸಿಕ್ಕಿಲ್ಲ ನೋಡ್ಬೇಕು ಅಂತ.
ಏನ್ ಸಿಕ್ಕಿಲ್ಲ?
ಡಿಸಿಷನ್ಸ್. ವೀಕ್ ಟೈಮ್ ಗ್ರಾಂಟ್ ಮಾಡಿ.
ನಿಮ್ಗ ಈಗ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಇರೋದಾರ ನೀವಾ?
ಅಲ್ಲ
ಸಿಕ್ಕಿಲ್ಲ, ನಮ್ಗೆ ಸಿಕ್ಕಿಲ್ಲ ಹಂಗಾಗಿ.
ಇಲ್ಲಿದೆ ನಮಗೆ
ನಮ್ಮ ಹತ್ರ ಸಿಕ್ಕಿದೆ, ನಮ್ಮ ಹತ್ರ ಇದೆ.
ನಮಗೆ ಸಿಕ್ಕಿಲ್ಲ,
ನಿಮಗೆ ಸಿಕ್ಕಿಲ್ಲ, ನೀವು ನೋಡ್ತೀರಾ?
1 week ಟೈಮ್ ಗ್ರಾಂಟ್.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ನಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಗಿಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ರೀ. ನಾನು ಹ್ಯಾವ್ ರೆಫರ್ಡ್ ಆಲ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್.
gone to another court. My colleague is gone to another court.
ತ್ರಿಲೋಕಿನಾಥ್ ಹೇಳಿದೀನಿ, ಬೇರೆದೆಲ್ಲ ಸುಮಾರು ಒಂದು 10 ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ.
4 judgment
ರೆಫರ್ ಮಾಡಿ.
Even recent judgment of Supreme Court in 2022 3 na 24 refer ಮಾಡಿದೀನಿ ನೋಡಿ.
grant 1 week time, we will look into that.
ತ್ರಿಲೋಕಿನಾಥ್ ಇದರಲ್ಲೂ ಇದೆ 2020. Supreme Court judgment recent ALR 2023 Karnataka 1277. Third, the appellant counsel seeks time to verify and submit regarding the judgments passed by the apex court. ನಿಮಗೆ ಮೊನ್ನೆನೇ ಹೇಳಿದ್ನಲ್ರಿ ನಾನು, ತ್ರಿಲೋಕಿನಾಥ್ ಕೇಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Another court ಸ್ವಾಮಿ, ಅವೆಲ್ಲ
ಆಯ್ತು, list this matter on 1411. Serial number 31.
I've been served with a copy, the objections, I've been served with a copy of the objections in the morning.
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರಾ?
Swami, day for yesterday they have filed an IA and I got it day for yesterday evening by email. I've just prepared my objection today.
ಯಾವ್ದು ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇಶ್ಯೂಸ್?
House
apartment.
I've served the copy on them.
ಯಾವಾಗ ಕಾಪಿ ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ ಅವ್ರು ಗೋ ಥ್ರೂ ಅಲ್ವಾ? The counsel for the appellant submits that he has filed he has received the copy of the statement of objections and documents ಕೊಟ್ಟಿದ್ದಾರಾ? List this matter day after tomorrow. Entry matter ಏನಾದ್ರು ಇದೆಯಾ? Entry matter ಇಲ್ಲಲ್ಲ? ಇಲ್ಲೇನು entry matter ಇಲ್ಲ? List this matter on 1911.
May request my lords on 20th, if I may request my lords.
ಆಯ್ತು 20th.
Great.
ಇವತ್ತು ಅವ್ರ senior counsel ಕೇಳಿಕೊಂಡಂಗೆ ಇವತ್ತು 6 ಗೆ this honorable court gave the date. Again, it is being put. My lord, this is, I'm sorry to make a mention. Last week, an application of order 1 rule 10 came to be dismissed. Immediately an IA came to be filed. Already one IA has been filed way back in February 2023. That IA is still pending. One more IA has been pending. It is identical to that IA.
Present IA.
Present IA.
Similar.
Yes. I have already filed objection. Once again, I am filing objection. So this is only to drag the matter for no reason.
20th. ಹೇಳಿ ನೋಡೋಣ.
Please.
Much obliged.
Don't seek again time on 20th.
Last occasion, your lordship has asked the registry.
On humble submission. 20th, I am fully tied. 21st.
21st working entry? 21st.
Thursday.
21st.
Much obliged.
Last time, your lordship has asked the registry whether one more citation is necessary or not. I have taken citation on 6/3/22 before the trial court.
ತಗೊಂಡಿದ್ದೀರಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಂಡಿದ್ದೀನಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಯ್ತು, ಇಲ್ಲಿ ಕೇಳಿದೆ.
ಇಲ್ಲಿ ಕೇಳ್ತಾ ತಾವು ರಿಜಿಸ್ಟ್ರಿ ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಹೇಳಿದೀನಿ.
ಇಲ್ಲಿ ಏನದೇನು ಇಲ್ಲ, ಫಾರ್ಮಲ್ ಆಗಿ ಮ್ಯಾಂಡೇಟರಿ ಏನಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ
ಆಯ್ತು, ಏನ್ ರೀಸನ್ ಏನ್ ಹೇಳಿ
ಪ್ಲೀಸ್. ಇನ್ ದಿಸ್ ಕೇಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ
ರಿಜೆಕ್ಷನ್ ರೀಸನ್ ಏನು?
ರಿಜೆಕ್ಟ್ ರೀಸನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವ್ರ ಇದ್ರ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನನ್ನ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲೇ ಸಹಿ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿಲ್ಲ.
ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕಾಗುತ್ತಲ್ಲ?
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ಬಂದಿದ್ಯಾ?
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ಕೊಡಿ. Mere identification of signature of attesting witness as exhibit P1A is not sufficient to prove the due execution of the said will in accordance with law. When such being the case, the petitioners have not complied with any of the formalities as defined in section 63C of Succession Act, Treasury section 3 of Transfer of Property Act. Therefore, exhibit P1 will is not proved in accordance with law. That is under section 3 of so and so. What is the evidence?
Evidence is the PW1 and PW2 mail. One is scribe, another is attester. Registered will of 6/9/2009. This also identifies the signature and is same marked as P1A.
Paragraph number ನೋಡಿ 17 ಓದಿ.
70. Now turning to the facts of the case, the petitioner has examined one attesting witness, exhibit P1 registered will, PW2 Patil BK Siddhalingaya is the one of the attesting witness. P1 is the affidavit filed in lieu of examination in chief. He has deposed that 7/9 the deceased Girijamba contacted him and requested him to attest the proposed will. Went to the sub-registrar and at Magadi, where it was typed and executed by Girijamba and Chandrappa in favor of the petitioner. That he read over the will, affixed his signature, attesting witness that at the time they were good in health condition and capable of executing the will, and he came identify the signature and signatures of the testator and testatrix. He identified signature as same is marked as P1A. He has not deposed that. the deceased Srimati Girijamba and Chandrappa put their signature or thumb impression to exhibit P1 before him and another attesting witness. He has not deposed about the presence of another attesting witness. He has not deposed that he signed exhibit P1 as an attesting witness in the presence of the deceased Girijamba and Chandrappa and another attesting witness. He has not deposed that another attesting witness is signed in his presence. I have produced the examination in chief. Identical matter, your lordship has ordered, but I could not get the judgment, latest judgment, your lordship has.
The observation made by the trial court in paragraph number 17 that the executants have read the contents of the will and having understood the same, only they affix their signature another ಬಗ್ಗೆ ಎಲ್ಲೂ evidence ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ except identifying the signature ಅಂತ reasoning ಕೊಟ್ಟಿರೋದು. ಹೌದಾ? ಮತ್ತೆ ಎಲ್ಲಿದೆ ಆ ಎವಿಡೆನ್ಸ್? ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್. That's what I read, the evidence of PW2 also.
Examination.
PW2 ನಲ್ಲಿ ಇದೆ ನೋಡಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ.
Please.
ಕಾಲ್ ಮಾಡಿದ್ರು, ನಾನು ಓದ್ದೆ, ನಾನು ವಿಲ್ ಓದ್ದೆ, ಸೈನ್ ಮಾಡಿದೆ, ಅದೆಲ್ಲ ಸರಿ. At the time of execution of the will, the executor Sri Chandrappa and were in good health condition and capable of executing the will ಅಂತ ಬರೀತೀರಿ ನೀವು ಅಷ್ಟೇ. Said will is not executed by anybody's force. They executed the will voluntarily without any force ಅಂತ ಹೇಳ್ತಾರೆ.
Relation and show good and towards executors, and hence the will is dated has been executed. The will is genuine. I can be able to identify my signature and also signature of the executors on the will.
Yes, where is the answer to the reasoning of the trial court? You examined only PW2?
PW2.
Any other witness?
Illa.
Obre.
Scribe on examined. PW1. PW2.
In registered will?
Registered. 7/9/2009.
ಅದನ್ನ ಹೇಳಿಸ್ಬೇಕಲ್ಲ ನೀವು ನಿಮ್ಮ ವಿಟ್ನೆಸ್ ಕೇಳಿ. ಎಲ್ಲಿ ಹೇಳ್ಸಿದಿರಿ? Mere marking of signature is not enough ಅಂತ. That is the reasoning given based on the judgment of the Supreme Court.
If your lordship permit me, I will file. If your lordship permit me, I will file necessary affidavit.
Order is very clear. Read over the will and affix his signature, attesting witness that at the time they were in good health, so and so. Signature of the testatrix and testatrix. He identifies his signature. He has not deposed that deceased government so and so put their signature on left thumb impressions to exhibit P1 before him. ಅವನ್ ಮುಂದೆ ಸೈನ್ ಮಾಡಿದ್ರು ಅಂತಲೂ ಇಲ್ಲ. And another attesting witness ಕೂಡ ಯಾರು ಸೈನ್ ಮಾಡಿದ್ರು ಅನ್ನೋದ್ರು ಹೇಳೋದಿಲ್ಲ. He has not deposed about the presence of another attesting witness. He has not deposed that he had signed exhibit P1 as an attesting witness in the presence of deceased so and so. ಏನು ಇಲ್ಲ, nothing. Formal ಆಗಿ affidavit ಬರ್ಸಿ ಹಾಕ್ಸಿರೋದು.
If your lordship permit, I will file necessary affidavit. Necessary affidavit.
ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ? ರಿಮಾಂಡ್ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, ರಿಮಾಂಡ್ ಮಾಡೋದ್ ಬದಲು ಇಲ್ಲೇ
ಇನ್ನೊಬ್ರು ಯಾರು ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್?
ಅಲ್ಲ, ಇಲ್ಲೇ affidavit ಹಾಕ್ಬಿಡ್ತೇನೆ. ಇಲ್ಲೇ before your lordship I will file affidavit.
ನಮ್ಮ ಮುಂದೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಬೇರೆ ವಿಟ್ನೆಸ್ ಇದಾರ? ಅವ್ರ ಬಗ್ಗೆನೂ ನೀವೇನು ಹೇಳಿಲ್ಲ. ಇನ್ನೊಬ್ಬ ಯಾರು ವಿಟ್ನೆಸ್ ಸೈನ್ ಮಾಡ್ದ ಅದನ್ನು ಹೇಳಿಲ್ಲ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ. ವೆರಿ ಬಾಲ್ಡ್ ಅಫಿಡವಿಟ್. ಆಮೇಲೆ ಹೋಗ್ಲಿ ಯಾರು ಇದ್ದ ಅಂತಾನು ಹೇಳಿಲ್ಲ, ಇನ್ನೊಬ್ಬ ವಿಟ್ನೆಸ್ ಯಾರು ಅಂತಾನು ಹೇಳಿಲ್ಲ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ. PW2 ಎವಿಡೆನ್ಸ್ ವೆರಿ ವಿಲ್ ಎಲ್ಲಿದೆ? ಎಕ್ಸಿಬಿಟ್
ವಿಲ್
P1
P1
ಎಲ್ಲಿ ಇದೆಯಲ್ಲ, ಮಾರ್ಕು ಹಾಕಿಲ್ಲ. ಎಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ ಅವರು. ಒರಿಜಿನಲ್ ವಿಲ್ ಅಂತ ಇದೆಯಲ್ರಿ ಎಕ್ಸಿಬಿಟ್ P1.
ಒರಿಜಿನಲ್ ವಿಲ್ ಎಕ್ಸಿಬಿಟ್ P1
ಇದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ. ಒರಿಜಿನಲ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಒರಿಜಿನಲ್ ವಿಲ್ ಹಾಕಿದ್ದಲ್ಲಿ
ಮಾರ್ಕ್ ಆಗಿಲ್ವಲ್ಲ ಇದು ಇಲ್ಲಿದೆ ಮೇಡಮ್ ಇಲ್ಲಿ P&S 42/21 ಎಕ್ಸಿಬಿಟ್ P1 ಅದ್ರ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿದಿರಿ ನೀವು ಇಲ್ಲ ಅಲ್ಲ ಒರಿಜಿನಲ್ ಎಲ್ಲ ತಗೊಬಿಟ್ಟಿದ್ದೀರಾ ವಾಪಸ್ಸು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ಲೇಸ್ ಮಾಡಿ
ಅಲ್ಲ ತಗೊಂಡಿದ್ದೆ ಯಾಕಂದ್ರೆ ಒರಿಜಿನಲ್ ಬಿಲ್ ಅಂತಿದೆ ಎಕ್ಸಿಬಿಟ್ P1 ಒರಿಜಿನಲ್ ಬಿಲ್ ಅಂತಿದೆ.
ಹೌ ದೇ ಆರ್ ರಿಲೇಟೆಡ್ ಟು ದಿ ಪಿಟಿಷನರ್ ಟೆಸ್ಟೇಟರ್ಸ್ ಹೇಗೆ ರಿಲೇಟಿವ್ಸ್ ಅಂತ ಇವರಿಗೆ ಇವ್ರು ಯಾರ್ರೀ ಬೆನಿಫಿಷಿಯರೀಸ್ ಯಾರು ಅಂದ್ರೆ ಈ ಚಂದ್ರಶೇಖರ ಅಂಡ್ ಅನದರ್
ಅವರು ಅವರ ಬ್ರದರ್ಸ್ ಸನ್ ಗಿರಿಜಂಬಾಸ್ ಬ್ರದರ್ಸ್ ಸನ್
ಗಿರಿಜಮ್ಮನ್ನ
ಗಿರಿಜಮ್ಮ ಬ್ರದರ್ಸ್ ಸನ್ ಇನ್ನೊಬ್ರು ಅವಳ ಸಿಸ್ಟರ್ಸ್ ಸನ್ ಚಂದ್ರಪ್ಪ ಸಿಸ್ಟರ್ಸ್ ಸನ್
ಚಂದ್ರಪ್ಪ
ಚಂದ್ರಪ್ಪ ಅವ್ರ ಸಿಸ್ಟರ್ಸ್ ಅನ್ನು ಇವ್ರ ಬ್ರದರ್ಸ್
ಅಂದ್ರೆ ಅವ್ರಿಬ್ರು ಅವರ ಅಣ್ಣನ ಮಗ ಮತ್ತೆ ತಂಗಿ ಮಗನಿಗೆ ಮಾಡಿದಾರ
ಮಾಡಿದ್ ಅವ್ರಿಗೆ ಇಶ್ಯೂಸ್ ಇಲ್ಲ ನೋ ಇಶ್ಯೂಸ್
ಏನಿಲ್ಲ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ PW2 Third, the appellant counsel. This appeal is filed challenging the order passed by the trial court in rejecting the petition only on the ground that the witness who has been examined as PW2 and is an attesting witness not spoken anything about in his presence the testators have signed the will and also not spoken about any other witness was present and in his presence only all of them have been signed. Being agreed by the said order, the present appeal is filed and counsel appearing for the appellant would contend that if an opportunity is given, he is going to examine other attesting witness as well as going to file additional affidavit and lead further evidence in view of the observations made by the trial court. Admittedly, document exhibit P1 is a registered document and the same is executed in favor of brother son of Girijambala, Girijamba, and also the sister son of Chandrappa, who are the testators. And also, there are no respondents in the matter. And when such being the case, and also appellant produced number of documents before the trial court, particularly RTC ಎಲ್ಲ ಯಾಕೆ ಹಾಕಿದಿರಿ ನೀವು ಮಾರ್ಕ್ ಆಗಿದೆಯಾ
ಅದೇ ತೋರಿಸ್ಲಿಕ್ಕೆ
ಇಲ್ಲಿ ಮಾತ್ರ ಹಾಕಿದಿರ ಅಷ್ಟೇ ಅಲ್ಲ ಹಾಕಿಲ್ಲ ಬೇಡ ಏನಾಯ್ತು ಮೇಡಮ್ ಬೇಡ ನಂಬರ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ದಟ್ ಈಸ್ RTC to show that property was standing in the name of Chandrappa. And though these documents are produced before this court, not produced the same before the trial court. Having heard the appellant counsel and also the reasons assigned by the trial court, and when the counsel makes the submission that he is going to examine other attesting witness and also read additional evidence before the court, considering the fact that document of will based on the same, the relief is sought. It is appropriate to set aside the order and remand the matter to lead additional evidence. And trial court is directed to give an opportunity to the appellant to lead additional evidence by examining the other attesting witness. In view of the discussions made up, I pass the following order. Appeal is allowed, interim order is set aside, matter is remanded back to the trial court to consider the matter afresh in view of the observations made by this court. The appellant is directed to appear before the trial court on 29th of November 2024. The registry is directed to send the records TCR forthwith to enable the trial court to take up the matter on 29th without fail.
But
33.
For the appellants, my lord, for the appellant, my lords. My lords, the present matter is with regard to the, is the petitioner, is a petitioner appeal, my lords, challenging the order dated 19/1/2018, my lords, passed by the 9th Additional District and Sessions Judge, Bangalore Rural, my lords, wherein the learned trial court has refused to grant probate of the will dated 7/5/2009 on the sole ground, my lords, that the will dated 7/5/2009 does not have an executor. My lords, germanely, my lords, the facts before this honorable court, my lords, on 9/8/2006, my lords, one Balraju, who is the testator of the present will dated 7/5/2009, marked as Exhibit P1 before the learned trial court, in order to meet his various familial necessities, my lords, entered into an agreement of sale with the appellant, my lords, with the appellant petitioner, my lords, and the same was came to be registered as document number 2190 of 2006 and 7, my lords. Subsequently, on account of not being able to arrange the various documents, my lords, and on account of not being able to carry out assist the petitioner in terms of getting the compliances done, on 7/5/2009, the a will came into being, my lords, which is an unregistered will by the testator Sri Balraju, my lords, wherein the said testator bequeathed the scheduled property, bequeathed the scheduled properties to the appellant petitioner, my lords, stating that after the death of the testator, the property mentioned in the scheduled property would go to the name of the appellant petitioner, my lords. My lords, on 23/7/2011, my lords, the testator Balraju passes away, my lords, and the petitioner comes to know at a much later date, my lords, and upon learning of the death of the testator Sri Balraju, my lords, the appellant petitioner filed P&SC number 25 of 2017, my lords, before the 9th Additional District and Sessions Judge, Bangalore Rural. Now, my lords, on 15/8/2017, my lords, we carried out the paper citation. The appellant petitioner carried out the paper citation in the Kannada daily newspaper, my lords, Samyukta Karnataka, upon which the notice was given in the newspaper and none appeared, my lords. To which the learned trial court directed that the appellant petitioner lead their evidence, my lords, to which the appellant has led 3 witnesses, my lords. PW1 being himself, PW2 namely Nagesh, and PW3 by the name of Sridhar Naidu, who are the PW2 and 3 being the attesting witnesses, my lords. Now, my lords, on 19/1/2018, my lords, the learned trial court comes to the conclusion, my lords. If I may peruse my lord's kind concern to the appeal paper, the appeal book, my lords, ink page 22, my lords, para 8. The petitioner to prove the execution of the will got examined 2 attesting witnesses by the name Nagesh and V. Sridhar Naidu as PW2 and 3. The testimony of PW2 indicating that the testator was his neighbor and the wife of the testator died several years back, leaving behind the testator with no issues. The testator, his mother, his paternal uncle and auntie entered into a partition on 31/7/2006, and the said partition in the said partition, the scheduled property is allotted to the share of the deceased Balraj. During the lifetime of the testator, he was enjoying the scheduled property, and later he decided to bequeath the scheduled properties in favor of the petitioner, and accordingly executed the will on 7/5/2009 and bequeathed the scheduled properties in favor of the petitioner. At the time of execution of the will, the deceased Balraj was healthy, both physically and mentally. On 7/5/2009, the deceased Balraj has handed over the will to his custody, and he passed away on 23/7/2011. After several years, he met the petitioner and handed over the will. PW2 has identified the will and also the signatures of himself and the testator as per Exhibit P1, Exhibit P1A and P1B. He has produced his Aadhaar card and election identity cards as Exhibit P5 and P6.
Paragraph 9, my lords. Another attesting witness, V. Sridhar Naidu, was examined as PW3, has deposed that he know deceased testator who is the friend of the petitioner. Deceased Balraj often used to visit the house of the petitioner, and out of their relation, they entered into an agreement of sale on 9/8/2006 pertaining to the scheduled property. However, the testator was unable to accumulate the property documents within stipulated time for executing the sale deed. Accordingly, the testator executed unregistered will on 7/5/2009 and bequeathed the scheduled properties in favor of the petitioner. He is one of the attesting witnesses to the will, and the testator was healthy both physically and mentally at the time of executing the will. PW3 has identified the will, his signature, and also the signature of the testator as Exhibit P1, P1C, P1B. He has also identified his Aadhaar and driving licenses as Exhibit P7 and 8. Now, my lords, despite the finding that there is a proof that the unregistered will dated 7/5/2009 was entered into bequeathing the scheduled properties to the appellant petitioner, the learned trial court in para 10, my lords, this is the reasoning given by this is where the reasoning commences, my lords, of the learned trial court. My lords, para 10, my lords. My lords, if I may.
Will ಯಾವಾಗ execute ಆಗಿದ್ದು ತೀರ್ಕೊಂಡಿದ್ದೆ ಅವಾಗ?
My lords, ತೀರ್ಕೊಂಡಿರೋ date, my lords, is 23/7/2011.
Date of
the date of the will is 7/5/2009, my lords.
What is the reason for bequeathing the property in favor of you?
My lords, the reason given by the testator Sri Balraju in his will, my lords, Exhibit P1, was that on account of when the testator was in need of various finances at the time when he had a financial crunch, the appellant had lended a hand and in fact given him finances to meet various familial exigencies, my lords. And on account of not being able to provide the various documents or provide the various property related incidents, the testator, on account of the good relations that the testator had with the appellant, sought to bequeath the said. My lords, if I may continue, my lords, para 10, my lords. My lords, if I may be permitted to read.
Go to will.
Please, my lords. Para 10 of the said
Will,
judgment, my
will,
lords.
agree. You
Hello?
read will.
Will again, my lords. My lords, in entry 4 of the will, paragraph 4 of the will, my lords, exhibit P1. ಅದರಂತ ದಿನಾಂಕ 31/7/2006 ರಂದು ವಿಭಾಗ ಪತ್ರವನ್ನು ನೋಡನು ಮಾಡಿಕೊಂಡು ವೆಂಕಟಪ್ಪ ನಾರಾಯಣಮ್ಮ ಮತ್ತು ನನ್ನ ಚಿಕ್ಕಮ್ಮ ಬಾಲಮ್ಮಗೆ 1 lakh ರುಗಳ ನಗದಿನಿಂದನೆ. Apologies, my lords. I have slight impediment in reading. My lords, in paragraphs 4 and 5 of the said will.
There was an agreement of sale in favor of the benefit. And now you are relying upon that subsequently, without the sale deed, there is a will.
Yes, my lords.
Favor of you.
Yes, my lords.
That is also an unregistered document.
My lords, but I have to prove in order, my lords, a will can be registered, can be both registered and unregistered, subject to proving the circumstances behind the will as per section 68 of the Indian Evidence Act, my lords. Now, section 67 pari materia of the Bharatiya Sakshi Adhiniyam.
And witness who has examined as PW2, not spoken anything about the very execution of document, knowing fully well that he is executing the document. Except stating that he was physically and mentally healthy.
My lords, there was no coercion whatsoever, my lords.
It may be. Even PW3 also attesting witness?
Yes, my lords. PW2 and PW3 are the attesting
This
witnesses.
evidence is also very clear with regard to only this making the signature.
Yes, my lords.
He also did not speak anything about in his presence, only the testator executed the will by affixing his signature, knowing fully well that the contents of the document, nothing. That's all.
My lords, now the learned trial court, my lords, the reasoning given comes from para 10 to 12, my lords. My lords, said in paragraph 10, my lords, section 222 of the Indian Succession Act is extracted, my lords, as to whom the probate can be granted. Subsequently, para 11, my lords. Therefore, the is very clear that the probate certificate has to be issued in the name of the executor appointed by the will. Now it is relevant to refer the definition of the term executor. Section 2C of the Act defines
counsel and appeal is filed against the rejection of the probate petition filed on the ground that no executor has been appointed.
Lords, if I may.
In the will remind Martin Keligin Courtiga.
My lords, respectfully, my lords, if I may just submit one small aspect, my lords. My lords, the learned trial court, my lords, has after the examination of PW1, PW2 and PW3, my lords, in paragraphs 8 and 9 that I have just read out to my lords, my lords.
Counsel, the trial court has not considered the evidence of attesting witnesses, instead of only on the ground that executor was not appointed and rejected the same. I am going to set aside the order on that ground and also remand the matter to consider with regard to the proving of the document of will. That's all.
Certainly, my lords.
So, ಏನಾಯ್ತು madam?
Please, my lords.
No executor was appointed under the will and hence question of granting the probate doesn't arise. The counsel in support of his argument, he relied upon the judgment of division bench dated 7th day of November 2019 passed in MFA number 3238 of 2019, wherein similar issue was considered and the division bench comes to the conclusion that even in the absence of non-appointment of executor also, the court can grant the relief under section 276 of the Act. This court also referring the division bench judgment in the judgment dated 1st day of February 2024, in MFA number 4399 of 23 also, having considered the section 217, 218, 220, 222, 223, 224, 227, 229, 213, 232, 234 and 276 of the Act, as well as the material on record allowed the same and granted the relief. Having heard the appellant counsel and also on perusal of the material, particularly reasoning assigned by the trial court only considered though evidence was discussed of PW 2 and 3 who are the attesting witnesses, and having considered section 222 of the Indian Succession Act, comes to the conclusion that no executor was appointed. And the reasoning given by the trial court that in the absence of appointment of executor, question of granting the probate doesn't arise is an erroneous. In view of the order passed by the division bench referred above, as well as this court also considered the same in the other MFA. However, taking into note of material on record, not discussed anything about the proving of the will, even though witnesses were examined. And hence matter requires to be remitted back to the trial court to consider the same with regard to the proving of the will, and no discussion was made except mentioning the evidence of PW 2 and 3 and whether execution of will has been proved or not been discussed. Hence matter requires to be considered afresh to discuss the same in keeping section 63 of the Evidence Act to prove the same. In view of the discussions made above, I pass the following order. Appeal is allowed, impugned order is set aside, matter is remitted back to the trial court to consider the matter afresh in view of the observations made by this court regarding proving of the will, discussing the evidence of PW 2 and 3, whether the same is in consonance with the section 63 of the Evidence Act. The appellant is directed to appear before the trial court on 29th of April 2024. Remaining matters at 2:30.
Submission. Grateful, my lords.
Submission, my lord.
ಹೇಳಿ.
Serial number 39, my lord. Voting settlement ಇದೆ. Draft ಎಲ್ಲ ಇದೆ. ಅದು ಸ್ವಲ್ಪ ಟೈಟ್. Draft ಎಲ್ಲ ರೆಡಿ ಇದೆ. ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
ಪಾರ್ಟಿ ಇದಾರ.
Huh? R1? R1 B2F ಅಂತಿದ್ದಾರೆ ಯಾರು? ಹಾ.
ಹೌದು. RD ನಾವೇ.
ಆಯ್ತ್ರಿ, ಕಾಂಪ್ರಮೈಸ್ ರೆಡಿ ಇದೀರಾ ಏನು?
ಎಲ್ಲರೂ ರೆಡಿ ಇದಾರೆ.
ಮತ್ತೇನು?
ಆ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಸಪರೇಟ್ ಇದಾರೆ, ಇಬ್ರು ಹೆಣ್ಮಕ್ಳು ಒಬ್ರು ಗಂಡ್ ಮಗ, ನಾವು ಸಪರೇಟ್ ಇದೀವಿ. ನಮ್ ಶೇರ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಇದಿದೆ ಡಿಸ್ಪ್ಯೂಟ್, ಅದು ಕ್ಲಾರಿಫಿಕೇಶನ್
ಫೈನಲ್ ಮಾಡ್ಬೇಕಾ?
ಹೌದು ಸ್ವಲ್ಪ ಒಂದ್ 3 ವಾರ ಟೈಮ್ ಕೊಡಿ.
ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ whom?
ಐ ಆಮ್ ಫಾರ್ R1B.
ಯಾವ ಮ್ಯಾಟರ್ ರೀ ನೀವು ಹೇಳ್ತೀರ? 39
ಸರ್ 39.
ಸರ್ ಗೀತಾದೇವಿ MP.
ಹೌದು ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇವ್ರು ಗೀತಾದೇವಿ ಅವ್ರಿಗೆ, ಅಪಿಲೆಂಟ್ ಇವರು.
ಸರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಅಪಲೆಂಟ್ ತಗೊಳ್ಳಿ. Appellant counsel and counsel for the respondent submits that already matter has been settled and only they have to give final touch for the compromise petition and hence seeks time and hence list this matter.
3 weeks.
ಯಾವಾಗ ಬೇಕು?
3 ವಾರ ಎಂಡ್ ಆಫ್ ಲಾಸ್ಟ್ ಅಲ್ಲ
ಫೈನಲ್ ಆಗಿದೆ.
ನಾವ್ ಒಂದ್ ಕಿತ್ತ ನೋಡ್ಕೊಂಡು ಇದ್ ಮಾಡ್ತೀವಿ.
ಮ್ಯಾಟರ್ ಆನ್ 29/11
Please,
ಅಲ್ವಾ? 3 ವಾರನೇ ಆಯ್ತು. 29 ಮತ್ತೆ ಡೇಟ್ ಕೇಳ್ಬೇಡಿ ಅಷ್ಟೇ. ಹಾ ಹೇಳಿ. 43 ಏನಾಗ್ಬೇಕು? 43 ಏನಾಗ್ಬೇಕು? 2006 ನೋ ಡೇಟ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 46.
ಯಾವ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದ್ರು ಕೊಡಲ್ಲ ಡೇಟ್. 2006 ಸಾಕು, 18 ವರ್ಷ ಆಗಿರೋದು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಕೇಳೋಣ.
ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. 46 ಸೀನಿಯರ್ ಇಲ್ಲ, ಹಾಗಾಗಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೈ ಲಾರ್ಡ್.
ಯಾವ ಇಯರ್?
46 2006 ಮೈ ಲಾರ್ಡ್.
ನೋ ಡೇಟ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಈಗ ಆಯ್ತಲ್ಲ, ಅದು 29/11 ಅಲ್ಲ ಅಪಿಯರೆನ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಅಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಸಾಹೇಬರು 29/4 ಅಂತ ಹೇಳ್ಬಿಟ್ರು, ಅದು 29/11 ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಅಲ್ಲಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಹೌದೌದು, ಗೊತ್ತಾಯ್ತು. 20,000 ನೀವು ಕೊಟ್ಟಿದ್ದ? ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ, ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ, ತರಿಸ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ.
ಮೇಡಮ್ ಸಾರಿ, ಅದ್ರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಟು ಬಿ ಗೋ ಬ್ಯಾಕ್ ಆಗ್ಬೇಕಾಯ್ತು. ಅದೊಂದು ಸಾಹೇಬ್ರು ಹೇಳಿಲ್ಲ, ಮಿಕ್ಕಿದೆಲ್ಲ ಹೇಳಿದ್ರು. 33 ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಟು ಬಿ ಸೆಂಟ್ ಬ್ಯಾಕ್ ಅಂತ ಒಂದು ಹೇಳಿಲ್ಲ.
ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ಅದು.
ಓಕೆ, ಅಲ್ಲ ಅದು ಒಂದಿಲ್ಲ ಅಂದ್ರೆ, ಯಾಕಂದ್ರೆ ವಿತೌಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹೋಗೋದಿಕ್ ಆಗಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
ಹೇಳ್ತೀನಿ ಬಿಡಿ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಇದು ತರ್ಸ್ಕೊಡ್ತೀನಿ. 2:30 ಮೇಲೆ ಬರ್ತೀರಾ? ಸರಿ. ಆಮೇಲೆ ನಿಮ್ಗೆ ಯಾವಾಗ ಫ್ರೀ ಆಗೋದೋ ಬನ್ನಿ, ನಾನು ತರ್ಸ್ಕೊಡ್ತೀನಿ. ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. ಹೇಳಿ.
ಹೆಸರು
ನಿಮ್ಮ ಹೆಸರೇನು?
ಅಮಿತ್ ಅಲ್ಲ.
ಮೀತ್ ಅಲ್ವಾ?
ಸೆಕೆಂಡ್ ಹೆಸರು ಇದೆ,
ಬೇಡ, ನಾನು ಬರ್ತೀನಿ. ಇಲ್ಲಿದೆ, ಅವ್ರು LM ಚಿದಾನಂದಿಯ ಬೇಡವಾ? ಇಬ್ಬರದು ಇರ್ಲಾ?
ಇಬ್ಬರದು ಇರ್ಲಿ, ಬಟ್ ಆರ್ಗ್ಯೂಡ್ ಅಮಿತ್ LM ಆನ್ ಬಿಹಾಫ್ ಆಫ್ LM ಚಿದಾನಂದಿ ಅಂತ ಹೇಳ್ಬಿಡಿ.
ಹಂಗ ಹೇಳ? ಪರವಾಗಿಲ್ವಾ?
ಎಸ್ ಮೇಡಮ್. ಆರ್ಗ್ಯೂಯಿಂಗ್ ಆಪರ್ಚುನಿಟಿ ಸಿಕ್ಬಿಟ್ರೆ ಸಾಕು ನಮ್ಗೆ.
ಮಾಡಿ ಹಾಕಿದ್ದೀನಿ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಅದ್ರ ಮೇಲೆ ಮಿಸ್ಲೆನಿಯಸ್ ಇದ್ದು ಡೌಟ್ ಅಯ್ಯೇ ಹೆಂಗ್ ತೋರಿಸ್ಬೇಕು ಹೇಳಿ.
ಎರಡೂವರೆಗೆ ಸಿಗ್ಬೋದು, ಎರಡು ಮುಕ್ಕಾಯಿಗೆ ನೋಡ್ಕೊಳ್ಬೇಕು.
ಎಲ್ಲೋ ಕೊಟ್ಟು
ಚೆಕ್ ಕೊಡ್ಬೇಕು. ಸೆಟ್ಟಿಂಗ್
ಇಲ್ಲಾಂದ್ರೆ ಚೇಂಬರ್ ಹೋಗ್ತೀರಾ ಅಲ್ಲಿ ಹೇಳ ಈಗ ಹೋದ್ರೆ ಅಲ್ಲೇ ತಗೊಂಡ್ಬಿಟ್ಟು ಹೋಗ್ತೀರಾ ಇವಾಗ.
ಮೇಡಮ್ ಕ್ಲಾರಿಫಿಕೇಶನ್, ಅದರಲ್ಲಿ ನಾವು ಅಫಿಡವಿಟ್ ಸೈನ್ ಆಗಿರೋದು ನೋಟ್ರಿ ಆಗಿರೋದು ಅದರಲ್ಲಿದೆ, ಒರಿಜಿನಲ್ ಕಾಪಿ ಮಾತ್ರ ಅದರಲ್ಲಿ ಅನೆಕ್ಸ್ ಆಗಿದೆ.
ಎರಡು ತರ್ತೀನಿ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೊಡ್ತೀರಾ? ಸಿಸ್ಟಮ್ ಇದು ಪೆಂಡಿಂಗ್ ನಾವು ಹೋಗ್ಬೇಕು. ಅದನ್ನೇ ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ ನೆಕ್ಸ್ಟ್ ಒನ್ ಆಫ್ 19 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ 230 ಮ್ಯಾಟ್ರು ಇದೆ. ಅದೇ ತಗೊಳ್ಳಿ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ 14ನೇ ತಾರೀಕು ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಆಮೇಲೆ ನಾವು ಅದು 25 ಏನ್ ನಂಬರ್ ಏನು 74 53 19 ಇಲ್ಲಿ ಡೇಟು 14 ತೋರಿಸ್ತಿದೆ. ಅದರಲ್ಲಿ ಇರೋದು 25 ಯಾವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದ್ದು 30 ಸ್ಟೇ ಪೆಂಡಿಂಗ್ ಬ್ಯಾಂಕ್ ಹೋಗ್ಬಿಟ್ಟು ಹಾ 28 ಇಲ್ಲ 230 ಮ್ಯಾಟ್ರ್ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಹಾಕಿರ್ತಾರೆ ಅಲ್ಲಿ ಇದು ಸೈನ್ ಕೆಳಗಡೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅದು ಯಾವ್ದು ಡೇಟ್ ಇರೋದು 30 ಅಲ್ಲ 25/9 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆಯಾ 11 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆಯಾ 14 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ನಾನು ಎರಡು ಬರ್ಕೊಂಡಿದ್ದೀನಿ. ಅವರು ಫಸ್ಟ್ 14 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ 29 ಹೇಳಿರೋದು 25 ಕೂಡ ಅಲ್ಲ 25ಗೆ ಹಾಕಿ ಇಲ್ಲ ಇಲ್ಲ ಅದು ಮಿಸ್ ಏನಾಗಲ್ಲ. ಊಟ ಹೋಗ್ಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ ಪಿನ್ ಮಾಡ್ಬಿಟ್ಟು ಇಟ್ಬಿಡ್ತೀರಾ ಇನ್ನೇನು? ಯಾವುದು? ಹಾ, ಇಲ್ಲೇ ಸ್ಟಾಪ್ಲರ್ ಬೇಕಾ?
Hello, sir, court officer. Hello, court officer. Hello, court officer. Am I audible? Hello? Hello? Am I audible, sir?
ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ. ಅವ್ರು ಹಂಗೆ ಅಂತ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ವಾಪಸ್ ಇದನ್ನ ಅವ್ರು ಅದನ್ನೇ ಹಾಕಿರೋದು ರಾಂಗ್ ಇದು ಅಂತ. 52ನಾ? 52 ಇಲ್ಲ ಇದೆ. ಹ್ಮ್. ನೋಡಿ ಒಂದ್ಸತಿ ಹೋಗಿ ಅಲ್ಲಿ ಅದು ಮೆಮೊ ಹಂಗಂತ ಹೇಳಿದ್ದಾರೆ, ಒಂದ್ಸತಿ ನೋಡ್ಬಿಡಿ.
ಮೇಡಮ್ ಇದು ನಿನ್ನೆಯಿಂದ ಈ ಫೈಲ್ ಇಲ್ಲೇ ಇದೆ ಮೇಡಮ್.
ಇಲ್ಲೇ ಇದೆ ನೋಡಿ ಅದು. ಅದಾ ಅದ್ ನಾನು ತಗೊಂಡೆ ಅದು. ಆಮೇಲೆ ಆ ಚೆಂಬು ಕೊಡೋಗ್ಬಿಟ್ಟು
ಹಲೋ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಮೇಡಮ್.
ಆಮ್ ಆಡಿಬಲ್ ಮ್ಯಾಮ್. ಮ್ಯಾಮ್ ಈಗ ಬಂದು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೋ 2:30 ಲಿಸ್ಟ್ ತಗೋತಾರೋ ಮ್ಯಾಮ್?
2:30.
ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು. ಈಗ ರಿಸರ್ವ್ ಮಾಡಿ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಅದು ರಿಸರ್ವ್ ಆಗಿದೆ. ಆಮೇಲೆ ಇದು ಹೋದ್ರೆ ತಗೊಂಬನ್ನಿ 2:30 ಬೇಕು ನಮ್ಗೆ. ಇದು ಹೋದ್ರೆ 24 ಸೇರಿಸ್ಬಿಡಿ. ಸಂಗೀತ ಮಾಡಿದ್ರೆ ಆ ಮುಂದ್ಗಡೆ ಒಂದು ಟೀಪಾಯ್ ತರ ಇದೆಯಲ್ಲ ಗ್ಲಾಸ್, ಅದ್ಮೇಲೆ ಫೈಲ್ ಪಾಸ್ ಓವರ್ಗೆ ಅಂತ 2:30 ಇದೆ ಸರ್. ನಿಮ್ಗೆ ಪಾಸ್ ಹಾ ಹೌದು ಕರಿತೀನಿ, ಬಟ್ ಇವಾಗ 2:30 ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ 2:30 ಇದೆ ಸರ್. ಇದು ಇಲ್ಲ ಬಂದ್ಬಿಡ್ತೀವಿ ಈಗ. ಒಂದು 10 ಮ್ಯಾಟ್ರ್ ಏನೋ ಇದೆ. ಆಮೇಲೆ ಪಾಸ್ ಅಲ್ಲ 2:30 10 ಆದ್ಮೇಲೆ ಪಾಸ್ ಓವರ್. ಅದು ಇವತ್ತಿದ್ಯಾ? ಕೂತಿದಾರಲ್ಲ ಅಲ್ಲ, ನಾನು ಅದೇ ಅವ್ರನ್ನು ನಾನು ಯಾವ್ದು ನಂಬರ್ ಮರ್ತೋಗಿದ್ದೇನೆ. ನಿಮ್ದು 9ನೇದು. ಕರಿಯತ್ ಬಿಡಲ್ಲ. ಯಾವ್ದು ಮ್ಯಾಟ್ರ 50 ಅದಿದ್ಯಾ? ಇದಾವ ಬೇರೆ ಯಾವ್ದು ಅಲ್ವಾ? ಅದೇ ಇದೆ. ನಿಮ್ಗೆ ಯಾವ್ದು ಹೇಳಿದ್ರು? ಹೌದಾ? ಅಲ್ಲ ಅದು ಎಷ್ಟನೇದು, ಒಂದು ಎಷ್ಟನೇ ತಾರೀಕು? ನಿಮ್ದು ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರು? ಹೌದು ಅವರೇ ಅದು. ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರು? ಪಾರ್ಟೆಡ್ ಇನ್ ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ H.N. ಬಸವರಾಜು ಪಾಸ್ ಓವರ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ.
ಮೇಡಮ್ ಅನಿತಾ ಎಂ ರೆಡ್ಡಿ ಅಂತ ಇರ್ತಾರೆ.
ತಗೊಂತಾರ ಇದು ತಗೊಂತಾರ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅವರೇ
ಬರ್ತದ. ಫಸ್ಟ್ ಕಲ್ಬುರ್ಗಿ ಕರ್ಸ್ಬಿಡಿ. ನಟರಾಜನ್ ಸಾಹೇಬ್ರದ್ದು ಇದೆಯಾ, ನಮ್ಮದು ಇದೆಯಾ? ಇದು ಅವ್ರಿಗೆ ಮಾತ್ರ. ಕರೆಸ್ತೀವಿ 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 ನೋಡೋಣ, ಬಂದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Matter pertains to Kalburgi bench, serial number 1, Mahantesh Patil.
Lordship, this is a successive bail petition, Your Lordship. And I require for time to file the detailed objection. 302 is the offense. 302 is the offense, Your Lordship.
Have you filed any statement of objections?
Lordship, no. No, Your Lordship, not yet filed.
Are you going to file objections or you are arguing?
No. Kindly grant me 1 week time, Your Lordship. Within that, I will file the objections.
HCGP 6, 1 week time to file statement of objections. Counsel for the petitioner idara illa absent. This matter, next witness. 1311.
Yes. Serial number 2,
Serial number 2, Mahantesh Patil. Idu avurdena?
Yes, Your Lordship. This is a writ petition. Along with 482, Your Lordship. Earlier, this honorable court directed to the state regarding the reinvestigate the matter. And that was complied by the state and reinvestigated matter. And now they again filed the writ petition by saying that kindly peruse the prayer, Your Lordship.
Petitioner counsel idara Mahantesh Patil.
Illa, sorry, sir, illa. He is not on screen.
Counsel is absent, HCGP is present, list this matter on 1311. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇದ್ರದ್ದು ಇದೆ ಅಂದ್ರೆ ಕಲ್ಬುರ್ಗಿ ನಟರಾಜನ್ ಸಾಹೇಬ್ರದ್ದು ಯಾವ್ದೋ ಒಂದಿದೆ ಅಂತ ಇದು ನಮ್ ಕೊಡ್ತ್ರಿ ಇದು ಕಲ್ಬುರ್ಗಿ ಇದೆ ಇದು ಎರಡೂನು ಮಾಡಿದಾರಷ್ಟೇ ಆಯ್ತು ಇಬ್ರು ಇದಾರ ಅದರ್ ಸೈಡು
He is present, Mel.
We have completed, therefore it's only
For the respondent in this case, respondent number 129, my lord. My lord had directed me the other day to confine myself regarding the granting of status quo. Now I have filed my cross objection under order 41 rule 22, saying that it was not adequate and that I had passed the triple test for granting the interim injunction, my lord. Now the triple test of prima facie case, balance of convenience and irreparable loss. My respectful submission is
that is not on merits counsel. It is only in respect of ad interim order.
My lord is right. Ad interim order only. Now everything started, my lord, when we entered into a one-time settlement with respondent number 10 and 11, my lord. That is Messrs. India Bulls. Now, it may be in their preliminary objection or in their appeal memo, my lord. It sounds more like the appeal memo and the preliminary objection is being echoed by respondent number 10 and 11, my lord. It speaks completely on what their version is, my lord. My respectful submission, my lord, may kindly see is the photograph.
His main contention is while granting the status quo order, no reasons are assigned by the trial court to grant the relief of status quo.
My lord is right.
That is his main argument.
My lord is right. Now it was vacation, my lord, and at that point in time,
maybe a vacation or regular bench.
My lord is right. My lord is right. There was grave urgency for the court to ensure that the shares, it is protected, my lord. Now the very notice itself is defective, my lord. I would like to demonstrate.
Counsel, the same will be considered by the very same court on merits.
Please, my lord.
Merits not yet considered the application filed by you.
My lord is
and
right.
other side have also appeared and filed statement
Please,
of
my lord.
objections.
Now
let the trial court consider the matter on merits. Only now scope is only challenge is made in respect of the ad interim order granted by the trial court, granting of status quo.
My humble submission, my lord. I have also challenged that order by way of my cross objection.
Illide cross objection.
41 rule 22 ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Illide ಹಾಕಿದ್ದೀರಾ? Illide.
It is before my lord. File ಮಾಡಿದ್ದೀನಿ.
ಎರಡು ಇದೆಯಾ?
ಎರಡಿದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು.
Now under such circumstances,
ಎರಡು ಮ್ಯಾಟರ್ ಇದೆ ಮೇಡಮ್. ಎಲ್ಲಿದೆ? ಯಾವಾಗ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಆಫೀಸರ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
The day my lord directed me to file cross objections, it was filed.
Why should I direct you to file a cross
I
objections,
was
counsel?
on they were on caveat, my lord.
Huh.
I had filed my caveat and I had filed my cross objections on that day itself. my lord.
No such cross objection is numbered, counsel here. Maybe you have filed objections.
No, my lord, it is under order 41 rule 22.
No such numbering.
Please, my lord.
ಇಲ್ಲಿ ಆ ತರದ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಮೇಡಮ್
ತಮ್ಮ ಗಮನಕ್ಕೆ ತೋರಿಸ್ತೀನಿ.
ಇಲ್ಲಲ್ಲ
Cross objection.
ಓನ್ಲಿ ಒನ್ ಮ್ಯಾಟರ್.
No, my lord.
ಎರಡ್ ಮ್ಯಾಟರ್ ನಂಬರ್ ಆಗಿದೆ ಅಂದ್ರೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ ಆಗಿದೆಯಾ?
Copy also has been served on to them, my lord.
ಕಾಪಿ ಆಗಿರ್ಬೋದ್ರಿ, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ನಿಮ್ ಕ್ರಾಪ್ ಅಂತ ಕೇಳಿದೆ.
List ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಮತ್ತೆ ಎಲ್ಲಿದೆ ಕ್ರಾಪ್? ನೀವು ಫೈಲ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಆಗ್ಬಿಟ್ರೆ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ಕ್ರಾಪ್ ನ ಪುಟಪ್ ಮಾಡಿಸ್ಬೇಕಲ್ಲ.
ಮಾಡಿಸ್ತೀನಿ.
ಯಾವಾಗ?
ನಾಳೆ ಬೆಳಗ್ಗೆ ಮಾಡಿಸ್ತೀನಿ. It is done. Now, my lord, this cross objection needs to be heard in the light of the inadequacy of the orders passed by the learned trial court, my lord. And there are certain facts which are replete on record, which needs to be brought to the notice of this honorable court. It is not filed yesterday, my lord.
ಅದ್ ಪುಟಪ್ ಮಾಡಿಸಿ ನೋಡ್, then we'll see.
Please, my lord. I'll do it right away, my lord.
ಈಗ್ಲಾರು ಮಾಡಿಸಿ, ನಾಳೆನಾರು ಮಾಡಿ.
Office may be directed, my lord.
ಏನು ನಾನೇನು ಅಂತ ಡೈರೆಕ್ಟ್ ಮಾಡಿ, ನನ್ ಮುಂದೆ ಯಾವ ಲಿಸ್ಟು ಇಲ್ಲ. ಮತ್ತೆ
I will go
ನೀವು
verify, my
ನೀವು ಕ್ರಾಪ್ ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ you have to pursue that crop also.
my lord.
When the matter was listed alone,
How?
appeal filed by them,
Please, my lord.
that is your duty.
My lord is right.
ಮತ್ತೆ
It is my responsibility. I'll do it right away.
ಮಾಡಿ ನೋಡಿ ಅದೇನು ನೋಡ್ಕೊಂಡು
Please, my lord.
ಹೊಸವರು ಇಟ್ಟಿರಿ ಫೈಲು, ಬಂದ್ರೆ ಫೈಲ್ ಏರ್ ಮಾಡೋಣ, ಇಲ್ಲವ್ರು ಇಲ್ಲ.
ಇವಾಗಲೇ ಮಾಡಿಸ್ತೀನಿ ಸರ್.
ಆಯ್ತು.
ಹೋಗ್ಬೇಕು.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾರ್ಮಲಿ ನಂಬರ್ ಆದ್ರೆ ಅದ್ರ ಜೊತೆಲ್ಲ ಹಾಕ್ತಾರಲ್ವ. ನೆನ್ನೆ ಎಲ್ಲ ಅವ್ರು ಅವಾಗ್ಲೇ ಮಾಡಿದೀನಿ ಅವತ್ತೇ ಅಂತಾರಲ್ಲ, ಆಫೀಸಲ್ಲಿ ಅವತ್ತೇ ಫೈಲ್ ಮಾಡಿದ್ರು.
My lord had directed me to file it before Saturday, about 2 weeks back, my lord. It was filed on that day.
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಆಯ್ತು ನೋಡು.
Please, my lord. Okay.
List 1. Matter at 2:30.
Hmm.
56. Sayed
230.
Umar.
230 matters.
Non-compliance of first time.
Told petitioner counsel absent. Bail matter, 1 week time granted to comply with office objections. List this matter on 13/11.
Third time non-compliance, 57.
Authorized TA.
Basuraju TA.
Idu bail petition. This matter is listed for third time and no representation and also office objections not complied. And hence post the matter after compliance.
Orders
Don't need
matter
to call.
58. Sirajuddin Ahmed.
Sirajuddin Ahmad. Ilwa? Petitioner counsel absent, list this matter. Last time ಏನಾಗಿದೆ ನೋಡಿ?
Non-compliance to 2 weeks time.
2 weeks ಆಗಿದೆ, ಆಯ್ತು. List this matter on 13/11 ಕೊಟ್ಟಿರಿ ನೋಡಿ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ next time.
59.
Vikram Raj.
Your Lordships, on the last occasion, your Lordships had asked me to check the status of the cases pending before the petitioner as against the petitioner.
Details of antecedents of the petitioner, copies also served on the learned counsel for the petitioner. ಹೇಳಿ.
Sir, as per the objections filed by the respondent, your Lordships, it reflects that there are 7 cases pending. As on date, your Lordship, serial number 2, that is, your Lordships may look into the objections filed by the respondent.
Not objections, only details are given.
Details, your Lordship, details. Idರಲ್ಲಿ
Case number 2 na?
Crime number 107 of 15, your Lordship, ಅದರಲ್ಲಿ section 302 read with 30.
107 and 302 ಇದೆ.
ಹೌದು ಸರ್, ಅದು ಎಕ್ವಿಟ್ ಆಗಿದೆ.
Acquittal
Acquittal.
ಆಯ್ತು.
SC 52 of 16 acquittal. Then serial number 3, your Lordships, ಅದು ಎಕ್ವಿಟ್ ಆಗಿದೆ.
Acquit
SC
ಆಗಿದೆ.
ಹೌದು, SCD of 87 of 21. And 4, 5, 6, 7 are pending.
4, 5, 6, 7. What about 8?
8 is the present crime number.
Now present.
Yes, before your Lordships.
1. Crime number 58 of 2012.
Just a notice was issued under 41(1)(a), your Lordship.
An offense, and what is the offense?
Offense has before this, your lordships is under 394, 397.
394, 397.
And co-accused, accused number 2 was already is granted bail by your lordships and have furnished the order also.
Where is that order?
What I have furnished separately, lordship, I can furnish it again. 3537 of 20.
ಯಾವ್ದು ಹಾಕಿದಾರ ನೋಡಿ. A2, this is A2.
Dated 16 May 24.
Lakshman.
Lakshman was accused number 2.
What is the reason for granting bail in favor of A2?
A2 was granted bail on the premise, your lordships, that recovery of rupees 500 was only recovered from him. And
take note of the gravity of the offence while exercising the power under section 439 of CRPC, and the mobile is worth of rupees 3,000, and the allegation is that very snatched an amount of rupees 500 and the same was not recovered, but knife was recovered at the instance of accused number 1. And so also the mobile. And there is no recovery except motorcycle at the instance of the petition. Now, on case motorcycle matra. Niminda recovery I knife and the mobile.
your lordship, both were presented before the place, your lordships, but the knife and the mobile phone were recovered from the vehicle of accused number 2. Even though it was
Vehicle from accused number 2.
accused number 2, the vehicle.
From you, mobile and the knife.
Mobile
Whether they had caused any injuries?
Injuries were caused, your lordships. I have produced the wound certificate.
Wound certificate.
ಕೊಟ್ಟಿದ್ದೇನೆ, your lordships.
Yeah.
Dated 19 September 24. Additional documents.
Additional document.
Additional documents ಅಲ್ಲಿ page number 29.
19-9. Page number?
29. 29.
29.
29.
Contusion. Only assaulted one person or?
Only, there was only one person, your lords. And the opinion,
History by 3 people on 10 PM near Urva.
opinion is at the bottom of the certificate, your lordships, which is simple in nature, the injuries.
Only one is injured, madam? Huh. Why he did not approach this court earlier?
No, he had approached earlier,
A2 only approached.
only A2 approached.
Huh. Why this accused has not approached, whether he was in custody in other cases?
No, he was in, he had approached the sessions court, your lordship, but thereafter, this
Incident of the year.
May ಅಲ್ಲಿ ಆಗಿತ್ತು ಅದು.
Hmm?
As on the date of commission of the crime, he was on bail, your lordship.
He was on bail in other cases also.
Yes, your lordship.
Huh. Yes, madam.
The allegation against this petitioner is that he is the one who's assaulted with the knife.
He assaulted with knife.
Knife.
Injuries is simple in nature. Voter. Huh.
Squashed by this petition.
So I heard the petition of counsel and also the counsel appearing for state. This petition is filed by accused number 1. And specific court act allegation is made against him is that he inflicted injury with knife. And also snatched the mobile. And the recovery is also made at the instance of this petitioner, that is knife and mobile. The other allegation against accused number 2 is that vehicle was recovered at his instance, and this court already granted bail in favor of accused number 2 in criminal petition number 53537 of 2024. Cases are registered. In 2 cases, he has already been acquitted, and other cases are pending. Per contra, the counsel appearing for the respondent state would submit that though the injury is simple in nature, but he involved in 8 cases. And those cases from 2012 to 2024. And having taken note of the crime number 107 of 2015, offense invoked against him is 302, and counsel for the petitioner would submit that he has already been acquitted. And so also in crime number 45 of 2021 also he has been acquitted. But in other case 46 of 22, crime case number offense is 302, read with section 34 of IPC, and also Arms Act. And he has been enlarged on bail, but he had indulged in committing similar offences, and he is an habitual offender. Having heard the petitioner counsel and also the counsel appearing for the state, the allegation made against this petitioner in crime number 7 of 24, that he had indulged in committing the offence of 394, 397, read with section 334 of IPC. And material also discloses that only recovery of mobile and also the knife, and counsel appearing for the petitioner also brought to notice of this court the nature of injury, and injury is also simple in nature, that is also a contusion. And when such being the case, when this court already exercised the discretion in favor of accused number 2, no doubt recovery is against him only the motorcycle, but in the case on hand, knife and mobile was seized. And having taken note of the gravity of the offense and nature of injuries, though indulged in other offences, already he has been acquitted in 2 cases, and other cases are pending, and mere pending of other cases is not a ground to dismiss the bail petition, having considered the allegation of assault with knife also, injury is simple in nature, and hence this court can enlarge him with conditions. Any of the discussions made upon, I pass the following order: enlarged. Other conditions haki, innon condition haki, if the petitioner indulges in committing of any similar offences in future, the state is given liberty to approach this court for the cancellation of bail.
Grateful.
Stop ಮಾಡಬೇಕು.
Yes.
ಮತ್ತೆ ಮುಂದೆ ಕೇಸಸ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಮತ್ತೆ ಬೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಆಗ್ತದೆ.
Grateful.
ಬಾಲಕೃಷ್ಣ MR. Unnikrishan CGSC ಹೇಳಿ
We
ಮೇಡಮ್.
are yet to file our objections, my lord. A date may be fixed. We have to file our objections, my lord. A date may be fixed for this matter.
How much time is required to file statement of objection?
21st, my lord, 21st.
No, yes, already served the copy of the objections.
ಯಾವ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರ?
Yesterday he served the copy of the,
already
have been
served the copy.
misdirected.
but it was
I
not
was not-
signed by the deponent.
ತಗೊಳ್ಳಿ. Counsel for ತಗೊಳ್ಳಿ ಹಿಂಗ ಹಾಕ್ಬಿಡಿ. CGSC seeks time to file statement of objections. And hence 1 week time granted, list this matter on 13/11. Next Wednesday.
61 Ganesha K.
Ganesha K. Unnikrishnan.
Petitioner, your lord.
My lord, even this matter, we are
Not
yet to
special
file our
case, huh?
objections. For this matter as well, we are yet to file our
This
objections.
matter also you seek time.
Yes,
In
my
fact,
lord.
this honorable court has a direct and last day to serve the copy
Last
and
time
free
order sheet
Prasanna
ಕೊಡಿ.
Kumar.
ಇದೇನೆ ಇಬ್ಬರ ಹೆಸರಾಗಿ ತೋರಿಸಿದೆ, ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ
ಹೌದು, ಅವ್ರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಿ ಸರ್.
ಹಾ?
ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ.
ಪ್ರಸನ್ನ ಕುಮಾರ್ learned special PP accept notice for respondent. Petitioner to serve the copy of this petition and the learned PP forthwith. ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ಕೆ
ಹೌದು, ಸರ್ವ್ ಆಗಿದೆ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರಿ ಅಷ್ಟೇನೆ. ಆಯ್ತು ತಗೊಳ್ಳಿ ಸಾಕು. The counsel for the respondent seeks time to file statement of objection, list this matter on 13/11. Registry is directed to delete the name of who is appearing in this matter, Madam Prasanna Kumar or
Unnikrishnan M. my-
Unnikrishnan?
Unnikrishnan M, my lord.
Last time someone has accepted notice ಅಂತಿದೆ, Prasanna Kumar. ತಗೊಳ್ಳಿ. The registry is directed to delete the name of Prasanna Kumar since counsel Unnikrishnan appears for the respondent.
62
30B.
62 Latif B.
ಲತೀಫ್ ಬಿ ಹೇಳ್ರಿ.
Pass over.
ಪಾಸ್ ಓವರ್ ರೀಚ್ ಆಗಲ್ಲ ಆಮೇಲೆ. ಪಾಸ್ ಓವರ್.
63
ಆರ್ಡರ್ಡ್ ಪ್ರಸನ್ನ ಕುಮಾರ್.
ಇದರಲ್ಲಿ ಇದು
ಹಾ
ಕನೆಕ್ಟ್ ಅದೊಂದು ಮಾತ್ರ ಮಿಸ್ ಆಗಿದೆ. ಆಲ್ಸೋ ಡೈರೆಕ್ಟೆಡ್ ಮೇಲ್ ಆನ್ ಮೀ ಟು ಪ್ರಿಪೇರ್ ದಿಸ್
ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅದು. 6251 of 24.
ನೋಡ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ರಿ.
63, 64, 65 and 68 ಬಂದಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್. ಅದರಲ್ಲಿ ಇದು
64,
63, 64,
65
and 68 ಮೇಲ.
68 ಆಲ್ಸೋ.
68 ಆಲ್ಸೋ. ಅದ್ರ ಜೊತೆಗೆ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 6251.
6251 ಆರ್ಡರ್ ಇದೆಯಾ ಆಲ್ರೆಡಿ ಪುಟ್ ಅಪ್ ಮಾಡಿ ಅಂತ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು ಅದು. ಇಟ್ ವಾಸ್ ಆಲ್ರೆಡಿ ಲಿಸ್ಟೆಡ್ ಬಟ್ ನಾವು ಇದೊಂದು ಮಾತ್ರ
ಡಿಲೀಟ್ ಆಗ್ತದೆ ಈ ಸರಿ.
ಇಟ್ ವಾಸ್ ಲಿಸ್ಟೆಡ್ ನಾಟ್ ಆಲ್ ಆಫ್ ದೆಮ್ ಆರ್ ನಾಟ್ ಕನೆಕ್ಷನ್ಗೆ ಏನು ಆರ್ಡರ್ ಇಲ್ಲ, ಜೊತೆಗೆ ಬರ್ತಾ ಇದೆ ಅಷ್ಟೇ.
ಒಂದೇ ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್? ಇಲ್ವಾ?
ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಆಗಿ ಲಿಸ್ಟ್ ಇದಾಗಿರ್ಲಿಲ್ಲ, ಕನೆಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ.
ತೊಗೊಳ್ಳಿ. The petitioner counsel submits that other connected matter criminal petition number
6251 of 24.
6251 of 24 also to be listed along with these petitions, and hence registry is directed to connect all the matters serial number 63, 64,
65,
65,
68 and criminal petition 6251 of
petition number
6251 of 24.
6251 of
24
ಅಲ್ಲ
24.
24.
Can I request on Monday?
ಯಾವಾಗ ಬೇಕು?
Monday.
ಈ ಮಂಡೇ?
ಇದೆ
ಮಂಡೇ ಇಲ್ಲ, ವೆಡ್ನೆಸ್ಡೇ ಮಾತ್ರ.
Please.
ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಓನ್ಲಿ ವೆಡ್ನೆಸ್ಡೇ.
Please.
1311.
66 Srivatsava.
Petition.
Manjunath Prasad for R2 additional SPP. ಹೇಳಿ.
Matter has been settled before the trial court, my lord, through compromise petition. So, and also executed the sale deed to the third.
Compromise between whom?
Petitioner and the respondents, my lord.
Petitioner and respondent.
Yes.
Then why you have filed this petition? If it is compromised.
No, my lord, what has happened is a civil suit was filed challenging the fraudulent sale deed. During the course of the proceedings before the civil court, the Canara Bank initiated proceedings in respect of my property because loan was there for more than 60 lakhs. Then Canara Bank said, whatever you people do with criminal court, you do, or civil. Has filed the memo. In that memo, at 29, page 29, you are not in the petition, my lord, by way of a separate memo, it is filed. Compromise petition and hakidare. Page 29, you are lordship, my kind.
29,
Yes, ma'am. In that OS 122 of 2020 that is initiated by the respondent, a memo came to be filed, wherein it is stated that plaintiff and defendants 1 to 4 entered into memorandum of understanding by document number so and so. And as per memorandum, scheduled property is agreed to be sold to one Dhaneshwar Lakshman Rao Dasre, and out of the sale price of the defendants 1 to 4 are entitled to 27 lakhs. And it is also agreed that the plaintiff to withdraw PCR 254 of 2020. That is the subject matter of petition before lordship. There is no question of withdrawal of PCR because the stage has already crossed. Cognizance has been taken by the court. And on earlier occasion, the very same petitioners have approached this court and filed criminal petition 4208 of 2020. And your lordship on 13/1/2021. Please to dismiss the petition. Of course, the offences alleged are appears to be compoundable.
Compoundable.
Compound appears. ಅವರು ಜಾಯಿಂಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಇದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿ
Then you have to compound the offense before the trial court, that's
ಟ್ರಯಲ್
all.
ಕೊಟ್ಟ ಅಷ್ಟೇ, ಅದನ್ನ ಮಾಡ್ಬೇಕಾಯ್ತು, ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ.
My lord, being the vendor, we have already confirmed the sale deed and there is no question of offense being
Without
and
that,
also there is sale deed is valid when
Any compromise, you file an application for compounding of offenses, that's all.
see, it's a
Unless
civil
it is
nature, my lordship, and
Unless it is compounded.
yes, my lordship,
According to him, already court has taken the cognizance.
yes, my lordship.
Matter is pending.
If we go there and we file a
Trustee is filed
petition,
by
my
the-
lord, they say it's civil in nature and there's no.
Whatever it may be, madam, already case is registered and cognizance is taken.
Charge sheet is
Criminal-
filed.
In the
criminal
summons stage,
proceeding
my
is pending. You compound the offense, that's all.
it's in the summons stage, my lordship.
Even if it is summons says also case can be compounded, madam.
Yes, my lordship.
Hmm?
So being the sale deed is valid and there is no question of offense.
I don't know. Now there is a charge sheet against your client.
Yes, my
What
lordship.
you are going to do, you do it, that's all. What do you want now? You want time?
Next date, my lordship.
Petitioner counsel seeks time. List this matter on 13/11.
My lordship, one small submission, next week, last week of November,
Note, last week of November.
after 17th, my lordship.
27,
67,
11.
Karunakara.
Karunakara. ಏನಾಯ್ತು ಮೇಡಮ್ ಅಡಿಷನಲ್ ಎಸ್ ಪಿ ಏನಾಯ್ತು
Mutation report.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಸೆಕ್ಯೂರ್ ಮಾಡಕ್ಕೆ
ಡೈರೆಕ್ಟೆಡ್ ಟು ಕೀಪ್ ದಿ ಐಒ ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಐಒ has not given any documents. Last time you made such submission before the court. Whether this court has to remind you,
No, your lordship.
then you must be alert.
Please,
When the case is called.
apologies, your lordships. The report is that your lordships, the Tahsildar over there has informed that until that there is court direction, they cannot secure, they cannot, until the court direction is there. And until there is a written direct order to the Tahsildar, your lordships, with regard to the getting the original documents with mutation register, they cannot they cannot give that. Otherwise, they produce this attested copy of some.
What prevented to make this said submission in the earlier dates for almost 2.5 months?
Please, your
When you
lordship,
instructed IO,
please, your
what
lordships.
prevented her to
Your lordships, the IO.
communicate the same to you?
The original IO who was there, he's been transferred, your lordships.
When
The
the earlier
who is in
IO,
charge?
when the earlier IO was transferred,
11/8, your lordships.
11/8,
Please, your lordships.
when she took charge,
From 11/8.
11/8 only, direction, when the direction was given by this court. Order sheet nodi madam,
10/7/24. 10/7/24.
10/7/24.
Until
After 2 months of filing of the suit and the allegation of fabrication of document is alleged in the complaint, the counsel for the petitioner brought to notice of this court regarding discrepancy in mentioning the relationship between the parties in the complaint and also in the charge sheet. Investigation has been completed and charge sheet is also filed. Hence, further proceedings is state in a state of hearing accordingly so and so. Not 10/7 order. That is only a stay.
I think
Petitioner has produced two MRs bearing number MR4 and MR4 of 1998-99. Both MRs pertains to the same transfer in favor of the petitioner hearing. Learned additional PPP is directed to get the records of both the MR numbers. List the matter on 24/7/24. This order was passed on 18/7/24. Next. 24/7. Mutation register extract are submitted before the criminal court and seeks time to get the same from the concerned court. This is the submission you made.
Because your lordships, that's what I was also.
In criminal case, it was submitted. Now you are giving other reasons.
Lordships.
When you have already produced the documents in criminal court, what prevented you
Your
in
Lordships,
producing the same before the court?
Your Lordships, the original documents are with the Tahsildar, Your Lordship, still. Even in the court, it seems right now she's submitting that, even in the court.
Where is
Please
the letter given by the Tahsildar? Stating that if court directs only, the records will be produced. MR is different, madam, what you have placed before this court. Earlier is MR's bearing number MR4 of 9798. But here you have produced MR7 and 9798. Another MR is 4 of 9899. Both MRs are pertains to the same transfer in favor of the petitioner herein. Here you have given a different MR number, 7 and 8. 7 and 8. Where is the letter given by the Tahsildar?
There is no letter.
Where is the letter given to the Tahsildar? Seeking the records from the Tahsildar. Whether IO is secured the records or not during the course of investigation.
Lordships, this is the letter given to the person.
Whether IO has secured the records while investigating the matter or not, madam. When the charge sheet is filed, ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಬರೀ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ PCR ರೀ PCR ಆದ್ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ
Charge sheet complete.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆ
ಹೌದು.
ಮತ್ತೆ
Charge sheet filed on dated 28/9/21.
ನೋಡಿ, when this court directed IO be present before the court, thereafter only letter was given on 4/11. This is dated 4/11. Hmm? 4/11.
But I had been following with them
Day
from
before
past.
yesterday.
Please, Your Lordship.
Direction was given in the month of July.
July.
Then. And also she took charge in the month of August.
August.
Why she is very negligent about the court order? ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿರೋದು ಅವರಿಗೆ ಸೆಕ್ಯೂರ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನೋದು ಕೇಳಿದೆ ದಾಖಲೆ. I will initiate the proceedings against the.
Your Lordships,
IO.
there are people in the office, Your Lordships, walkie, there are people in the office through whom we inform the officials.
ಎಲ್ಲಿದೆ ಅದು? ಅದ್ರ ಬಗ್ಗೆ ಏನು ರೆಕಾರ್ಡ್ ಏನಿದೆ?
There is no, or, Your Lordships, we inform them through phone call. We talk to
ಮತ್ತೇನ್
them.
ಮಾಡ್ಬೇಕು ಹೇಳಿ ಈಗ?
And I've been following it up from past 2 months, Your Lordships.
ನೋಡಿ, past 2 months in the, where is the result, madam? Sorry. Today also she came with empty hands. Where is the letter given by the Tahsildar? Only he has given the letter on 4th.
Your Lordships,
Where is
the
the reply
Tahsildar-
given by the Tahsildar? Shall I secure Tahsildar also?
He has not.
Shall I
given-
secure the Tahsildar also?
Lordships, next stage she's doing.
Sorry, IO is present before the court and submits a letter is given to the Tahsildar on 4/11/24. And record reveals that in spite of directed to produce the records in the month of July, till date no steps are taken. The IO submits through additional SPP is that the Tahsildar has replied unless the court passes an order not going to furnish the records to the IO. Hence, AGA is directed to instruct the Tahsildar to hand over the records to the IO. If fails to hand over the same, instruct the Tahsildar to be present before the court. This matter on 13/11.
Stay,
Hmm.
stay.
ಇದೆಯಾ? Stay granted is extended till next date of hearing. 13 ಬೇಡ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡಿ. ಅಷ್ಟೊಳಗೆ ಸೆಕ್ಯೂರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರು. 20/11.
Macham.
69.
69.
GS Prasanna Kumar.
May please.
Hmm.
The present petition is a second 482 petition, my lords.
Second 482.
Yes, my lords. Earlier, the
Ah.
482 petition had been filed by accused 2 to 4.
Hmm.
And my lords had dismissed the 482 petition. The present petition
8224 is dismissed.
out,
Ah.
12th February 2021, my lords.
Criminal petition number
My lords, it was a criminal petition number
2717. 2020.
2717 of
This
2020.
petition is filed by accused number 1.
No, 3.
Three.
Wait, he was part of the earlier petition.
Earlier
Yes,
petition
my lords,
also
he was part of it.
Ah,
Yes,
now
my
what is the
My
change?
lords, the change in circumstances that took place
Hmm.
were 4, my lords. One is his discharge application
Hmm.
came to be rejected, 239, my lords.
Ah.
Then, my lords, this particular petitioner, at the time of the alleged fabrication of record, my lords, the fabrication of record is shown to have been done.
According to you, he was not in the
Germany, my lords,
country-
Hamburg, Germany.
Country, he was in.
Yes, Germany, my lords,
Germany.
Hamburg, Germany.
Ah.
So documents of that nature, my lords, unimpeachable nature, which is produced, my lords.
Ah.
Meanwhile, my lords, death of A2, who-
ಅಲ್ಲಿದ್ದ ಅಂತ ತೋರ್ಸಕ್ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್
documents, passport as well as visa were produced.
ಹೇಳಿ ಯಾವ್ದು?
Annexures were produced it with a memo. Additional documents, the pass. My lords, it's produced on 4/7/2022, my lords. There's a copy of declaration of residence certificate, my lords. And the passport.
4/7?
4/7/2022.
22.
How? 23 or 22? Is it? My apologies.
2023.
It's, 23. I'm sorry, my lords.
23.
23.
23.
2023.
23 is here, that's
Yes,
why.
my lords.
Ah.
Adralli, 3 documents, my lords.
Hmm.
Mainly, one is copy of declaration.
Hmm.
My lords would get that at page 2, 18/10/2019.
18,
18/10/2019.
page number?
Page 2 ಅಲ್ಲಿ.
Page 2.
ಹೌದು, 2.
Page 2 only your synopsis. Brief facts.
In additional document, page number 2, my lord.
Page 2 only.
25/3/23. 25/3/23, 25/3/23. 4/7/23.
My lords gets that memo, my lords, 4/7.
4/7/23.
Howd, my
Ah.
lords, in that, my lords, deed,
Ah.
the copy of declaration of residence certificate. that
Residence
is-
certificate, yes.
My lords, that's dated 18/10/2019
Ah.
from Hamburg, Germany, my lords.
Ah.
And my lords, it discloses that he's been there since 27th June
June.
2005.
Hmm.
And this is followed by the travel details with visa stamping, my lords, on the next page.
Ah.
And then we have also,
This is intermittent travel.
yes, my lords, how? Because he was coming down, because his father, brother are all here, my lords. He was traveling between Germany. The dates are there, my lords. We put the stamping date, during which time.
When this document of mutation.
Yes, my
transfer
lords,
of
that
mutation
the
was
date,
taken.
my lords, 2 dates of relevance. My lords, the relinquishment deed, which they say the fabrication of the signature of the grandfather of the complainant, who's the father of A1. So allegation is, my lords, my father, A1, had fabricated the signature of my grandfather who was dead. Well, he relinquished it. That's the allegation, my lords. So that relinquishment deed is dated 6 to 2007, my lords. And it was for a consideration of 13,500, my lords, relinquishment. A1 relinquished the rights in favor of A2. The next date of importance would be, my lords, mutation. My lords, mutation had taken place on 1/1.
Mutation based on this
Yes, my lords,
relinquishment. deed?
relinquishment.
Ah.
That was on 1/1/2013.
2013.
So, my lords, what had happened is my lords wanted to know who filed that application for mutation, and that's how, my lords, the various orders that were passed, asking them to produce it, since it was not part of the charge sheet. Anyway, my lords, they were not in a position to produce that application, nor is it part of the charge sheet. This is where it
Then they
stands.
come up with an reason that the very file was
And
misplaced.
then the proceedings and all that took place.
Yes.
My lords, the complaint which is now given is dated 2/8/2019, my lords. My lords, the original joint purchase of this property, my lords, was done by Sidde Gowda, my lords. Sidde Gowda, who is the grandfather of the complainant and father of A1, Sidde Gowda. He, along with Revana Siddhaya, A2, they jointly purchased this property in 1987, my lords. 28/3/1987. Two survey numbers, my lords.
1987.
Yes, my lords. 28/3/1987. Two survey numbers. 24 guntas in survey number 58/2 and 15 guntas in survey number 65/3. My lords, Sidde Gowda, he died on 25/4/1996. My lords, his son A1 Kalyan Kumar. His son, my lords, A1 Kalyan Kumar. And there's a daughter also. My lords, daughter is nowhere involved in this. She has no problem with the transaction. They were the two LRs, my lords. My lords, when this relinquishment deed was done, my lords, that was done on 6/2/2007. My lords, this relinquishment deed is done by Kalyan Kumar in favor of A2, my lords. But he doesn't sign as Kalyan Kumar. He signs as his father who was already dead, Sidde Gowda. That's the crux, my lords. My lords, on that basis, my lords, the beneficiary to it is Revana Siddhaya A2, who is now dead, my lords.
A2 is also dead.
He's dead. That's father of the present petitioner, my lords. He's dead. Now, my lords, the mutations take place only on 1/1/2013. And the present complaint, which is given by the grandson of Sidde Gowda and son of A1, is on 2/8/2019, my lords. After 12 years, he gives his complaint. My lords, his whole complaint is, this was a joint property. My grandfather passed away. My father signs as my grandfather and relinquished this for a consideration of 13,500. So this is a case of fabrication of records, 468/471. How we are roped in is, my lords, as beneficiaries that we got this benefit because MR record was transferred into my name, they should be hauled up for breach of trust and cheating. This is sum and substance of the whole complaint that has been given, my lords. Now, my lords, my entire submission is, my lords, during the point, now the whole relinquishment deed, my lords, according to them also, I am not part of it, my lords. The children, A3 and A4, children of A2 are not part of the relinquishment deed. It is only A1 and A2. So, my lords, insofar as fabrication, 468/471 doesn't come there.
You are not a party.
I'm not a party to it, my lords. I only, being a beneficiary under the MR, I should be hauled up for a case of cheating and breach of trust. My lords would kindly now notice the entire chart sheet which we have produced, my lords. Just hearsay that is there in it. I'll just point out, my lords, with the reading of this entire chart sheet, whether the ingredients are made out, my lords. My lords, if my lords, we have produced the chart sheet.
Sum up. Instead of reading, sum up.
Sum up. My lords, two witnesses, my lords, yes, my lords. Two witnesses who are there in the chart sheet, both hearsay. They say we came to know of it. They don't.
CWO?
My lords, CWs 2 and CW3. That's the only aspect insofar as the 161 statements are concerned, my lords. And then so far as documents are concerned, the relinquishment deed itself between A1 and A2 for a consideration that had taken place. And my lords, even if A1, my lords, who was the LR, if he had signed in his own name, property could have gone. He need not have signed in the name of his deceased father. But anyway, my lords, he signed in the name of deceased father. So their whole allegation is father should not have done it in that manner and he should be hauled up for 468(4). This is the sum and substance that we get in this entire charge sheet. And in the mutations, my lords, the mutations are there and the RTCs are there. The RTCs of 2019 would disclose that it is in the
But according to you, A3 father also had purchased the property
joint.
with Sidegu.
Yes, my lord, joint property.
Ah.
Then he relinquished,
Jointly.
yes, jointly, he relinquished his share for a consideration.
A2.
A2. This is all that they say, my lords, and rest of the documents in this charge sheet are only RTCs and MR extracts. This is all that we have. There is no FSL also, my lords. In this case, probably FSL also is not required because it's a case of a FSL. But even if the whole charge sheet is believed to be true now, my lords, their entire case
But
is
now MR is made in favor of A3.
A3. My lords, whether it amounts to an offense of 415 or 420 or breach of trust, that is where it will come down to, my lords. Now, on that aspect, my lords, just the judgments that I'm relying on, my lords, and mainly the present judgment, my lords, Delhi Race Club, which says what are the ingredients of cheating and breach of trust. There, my lords, they clearly say, so far as cheating is concerned, dishonest intention at the inception, entrustment of the property, the breach that takes place contrary to what was agreed upon, consequential gain, consequential loss. This is how they put it for cheating, my lords. For breach of trust, only one ingredient which will be lacking, my lords, dishonest intention at the inception. If that is lacking, the rest of it is their entrustment, breach. It amounts to a case of breach of trust. My respectful submission, my lords, this entire charge sheet allegation, if it is seen, my lords, it will not bring it under either breach of trust or cheating. And the specific case is so far as the father having done a fabrication. So A1 and A2. A2 is dead, my lords. A1 is their father. A3 and A4 are the children of A2. Now, my lords, A3, who has been in Germany, my lords, throughout that period when the alleged fabrication has taken place, has come at a point of time, my lords, as
A2 died in which year?
my lords, A2, date of death of A2, 15/3/2023, my lords.
2023.
How?
Recently.
Father died.
If father died in 23.
Yes.
How this A3 got the mutation in favor
Earlier.
of him?
Earlier, my lords.
Why?
Yes, earlier.
And what is the basis?
I'm sorry, my lords.
What is the basis for transfer?
My lords, partitions took place.
Partition between A2 and A3.
Yes, my lords. That took place. That's not part of the charge sheet.
Is it a registered partnership?
Is it registered partition? Illa.
No.
My lords, the whole thing they say is this mutation is dated 1/1/2013. Earlier, my lords, mutation, where father on the basis of the partition would give me that property, my lords. They have no grievance about that partition and all that, my lords. They say the mutation, since it stands in the name of A3, A3 should also be an accused in this case. This is the sum and substance of the whole case. That's the reason my lords wanted to know whether was I a signatory to the application.
Who gave the application?
My lords, it was given only by the father, and that is the reason the investigating officer doesn't even make that application a part of the charge sheet. My lords wanted to know from the original where it is. It is not there at all, they say, my lords. So with this material, my lords, whether the ingredients of these offences are made out, this would be my respectful submission. Ingredients are not made out, my lords. And even at the stage of discharge, my lords, when we approached the court and pointed out that at that undisputed point of time, I was not there here when the alleged fabrication took place, my lords, the trial court, only on the basis of saying there could be a needle of suspicion, not even a grave suspicion, they would reject my 239 discharge application, my lords.
On 1/1/2013.
Was I in India, my lords? Yes, my lords, I was in India.
1/1/2013.
Yes, my lords, I was in India.
But according to you are in Germany on what date?
My lords, kindly notice that list, my lords. Please notice that list.
Only on 7/1/2013.
No, my lords, if my lords would kindly have that list, my lords, the travel visa stamping only.
travel details with visa stamping.
Adರಲ್ಲಿ, this particular period, my lords, 1/1/2013, my lords would notice at serial number 10 and 11 ಅಲ್ಲಿ, I traveled from Germany to Bangalore on 15/12/2012.
2012.
Yes, my lords. I went back on 7/1/2013. And this mutation
Not the
was,
date of mutation on 1/1/2013.
why I was here, my lords. 1/1/2013, I was in
You are
Bangalore.
in Bangalore only.
I was in Bangalore. My lords, I have
And
absolute,
then you cannot avail the ground that you are in Germany.
no, for the fabrication of record.
Fabrication.
Not for
Trans-
mutation. No, my lords.
Mutation is concerned, you are
No,
in
no, I
Germany,
was here. I
not
was
in
here.
Germany,
My
you are
lords,
in India only.
yes, my lords. Whole thing is about the fabrication, my lords, because the entire rights flowed from the fabricated record. During which time I was not in India at all, my lords. My father was a beneficiary. Father gave it to me under a MR, mutation, my lords. So I was not aware of this transaction till the MR entries were done in my name.
Yes.
So, my lords, just 2-3 decisions I have kept, my lords, but probably discharge only, what would be the scope there, only to that extent. But most importantly will be this Delhi Race Club, my lords, where they say what are the essential ingredients. I'll only pass that one judgment, my lords. I'll not make it bulky for the court. My lords, the relevant portion there, just that one paragraph, my lords. They put the ingredients of the two offenses. My lords, paragraph 29 may be noticed, my lords. Because, my lords, they start
It is
at
all settled law. Cheating is
settled,
concerned, it must be at the inception.
inception. So only
And that
difference,
is the only paragraph you are relying upon?
my lords, because it starts from paragraph 24, difference between criminal breach of trust and cheating, 24 only. From there, they start extracting the whole thing.
Yes.
They show that the subtle difference between the two is, my lords, dishonest intention at the inception for cheating.
What are the offenses are invoked?
My lords, the offenses in our case that are invoked are sections 419, 419, my lords, 420, 465, 468. 465, 468, A1 and A2, my lords.
Fabrication.
Yes, my lords. So far as we would be concerned, only cheating.
Yes.
That's all, my lords.
Yes.
My lord,
You are appearing for complainant?
respondent number 2, complainant, my lord.
Or?
Complainant, respondent number 2.
2.
My lord, in his complaint, my lord, page number 16, he has clearly stated, my lord, he has made allegation against all 4 accused, my lord. All 4 accused, they involved in the impersonation of the Siddhegowda. He died in the year 1996, my lord. My lord, in their application, my lord, before the trial court for discharge, he has clearly stated, my lord, in para number 3, petitioner is working.
Counsel complaint may be several allegations.
Please, my lord.
But the very fact is that relinquishment deed was executed by A1 in favor of A2.
Please, my lord.
In the name of Siddhegowda.
Please, please.
But whether this petitioner had indulged in such act.
My lord, that is the main allegation, my lord, by the complainant, my lord. In their application also, my lord, para number 3, my lord, they have clearly stated, my lord, petitioner, accused number 3, that is petitioner here in my lord, never visited to India and visited his original native place since 2005, my lord. He never visited, but in their passport, my lord, he has visited to
Details are frequent details.
many times he visited to India, my lord. And in application before for mutation, my lord, he has put his signature.
Assuming that he was in India only.
Please, my lord.
What is the this petitioner?
That is not.
That is the crux of the issue. Yes. Yes, counsel. State how you are going to defend filing of charge sheet against this petitioner. Maybe there is an allegation that all of them have joined together, but offences are invoked under section 419, 420, 465, 468 in respect of the A1
and
who
A2.
had indulged in executing the relinquishment deed in the name of Siddhegowda, who was not alive, no dispute. Invoke section 419 and 420 against this petitioner What is the material? Maybe a beneficiary. According to him that there was a partition between him and his father, A2. Based on that partition only, he got it transferred. Hmm. Ah. Ah. But 1/1/2013, he was in India only. He was in India only. Ah. Ah. Hmm. Hmm. According to he is a beneficiary, that's all. Hmm. 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 Hmm.
Then you notice the date, you notice on the application form, in 1/1/2013, the signature is found, you notice on the
Hmm.
form.
Hmm.
Then it is found for the petitioner.
Hmm.
No signature is there on the document. So even as per his passport records,
His signature on what date?
the mutation record.
Mutation record. Ah.
1/1/2013.
That is transfer. Mutated in favor of him. Whether he had signed the document. That's what I directed the Tahsildar to produce the document. Now, what is the document you are having that it had been signed anta ತೋರ್ಸಕ್ಕೆ? One ತಗೊಳ್ಳಿ. ಏನೇನ್ document ಇದೆ? Signature? Oh, Jayaprakash MR. Oh, you are having copy? Revana Siddhaya Ben Jayaprakash BN.
But still now, my lords, all the previous orders which has been passed by this court and what was submitted, my lords, before this court, they never had any of these records. I don't know from where, my lords, all
How
of a
you
sudden,
got this document?
all this was asked in the previous round of inquiry,
From where
disciplinary
you
inquiry.
got this document? Tahsildar.
How? So, that's very suspicious, my lords, with for the proceedings that have taken place in this court.
Was there any records are maintained in the office of Taluk, in the computer? Copy original documents ಇಲ್ಲ ಅಂತ ನೀವು ಮಗಳ ಕೇಸ್ ಅಲ್ಲ ಈಗ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ಅಂತ ಅದಕ್ಕೋಸ್ಕರ ತಾನು ಎಲ್ಲಾರ ಮೇಲೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು.
Calls for some serious inquiry, my lords.
This is Taluk 11/1/2013 ಅಂತಿದೆ.
All the disciplinary inquiry against all the officials are going on this, and suddenly this document is produced today.
ಇವನ್ 7/1/23 ಹೋಗಿ ಬಂದಿದ್ದು ಯಾವಾಗ ವಾಪಸ್ಸು?
After
He was only in 15 days?
No, my lords, I was here only for 15 days. I'll just point out. My lords, I left on 2023. 7/1 I went, I came back, my lords, on,
Bangalore to Germany and 7/1/2013.
then I came back on 7/12/2013.
Almost you are in Germany for about
1 year, close to a year.
ಬಟ್ ಇಲ್ಲೇನ 15/11 ಅಂತ ಏನೋ ತೋರಿಸ್ತಿರಲ್ಲ, ಅದೇನು ಸ್ಟಾಂಪಿಂಗ್ ಪೇಜ್ ನಂಬರ್ ಅಂತ, ಪೇಜ್ ನಂಬರ್ ಅದು.
ಅದು page number.
But you are in Germany from
7/1/2013.
7/12/2013. ಬಟ್ ಮೇಡಮ್ ಇಲ್ಲೇನ 10/1 ಇದೆ ಎಲ್ರಿ ಡೇಟು? ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ನೋಡಿ 10/1/2013 ಇದೆ. ಏನ ಮೊಕ್ಕಂ ಬೇಲೂರು 11/1/2013 ಇದೆ. ಕೊಡಿ ಅವರಿಗೆ. At that time he was not in India. Date ಇರೋದು ನೋಡಿ ಅಲ್ಲಿ.
See this relevant stamping that time where we left on stamping.
10/1/23 ಇದೆ, 11/13 ಇದೆ, and 11/1/13 ಇದೆ.
ಅದು ಅರ್ಜಿ ದಿನಾಂಕ the application date is the 10/11. 1/1/2013. 1/1/2013 is the application date. The arji dinanka, it was written here.
ಅರ್ಜಿ ದಿನಾಂಕ ಅಂದ್ರೆ ಯಾವತ್ತಿದೆ?
Andre they have whatever the application they have filed that date.
ಅರ್ಜಿ ದಿನಾಂಕ ಅದು
ಅರ್ಜಿ ಯಾವತ್ರಿ?
1/1/2013.
ಒಂದ
ಹಾ.
ಇಲ್ಲಿದೆ ಹತ್ರ 10-1 ಏನೋ ಇದೆಯಲ್ಲ ಅದೇನದು? 10-1 ಅಂತ ಇದೆ ನೋಡಿ ಕೆಳಗಡೆ.
11/1 ಅಂತಿದೆ.
11-1
11/1/2013
ಇದೆ.
ಅರ್ಜಿ ದಿನಾಂಕ 1/1/2013 ಅಂತ ಇದೆ.
ಆ ಕಡೆ ಏನದು?
ಮೇಲ್ಗಡೆ 11/1/2013.
ಅದೇನು 11
ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
11th ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಅಲ್ಲಿ 11th ಅಲ್ಲಿ on 7
7/1.
1/1/2013 he was in
humble submissions, but 1/1/2013 is the application date.
application
Further proceedings 11/1/2013.
ಮಾಡಿರೋದು ಯಾವತ್ತು ಹೇಳ್ರಿ? ನಿಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿರೋದೇನೆ 11/1ಕ್ಕೆ. 11/1 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿರೋದು.
19/11 ಅಂತ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
December 2013.
19/11
19/11
2012
ಇಲ್ಲೊಂದು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
2013,
13,
19 to 2013.
19, 12
ಇಲ್ಲಿ ಇದೆ.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
13 ಎಲ್ಲ ನಾವು ಜರ್ಮನಿಲಿ ಇದಾನ್ರಿ.
19 to 2013 ಅಂತ ಇದೆ.
19 to
2013.
he was in Germany.
ಅಂದ್ರೆ ಸೈನ್
on from 7/1/2013 ಇಂದ 7/12/2013 ವರೆಗೂ ಜರ್ಮನಿಲಿ ಇದಾನೆ.
But conspiracy will be there, my lord, completely. Rehatched conspiracy, my lord.
ಅದಕ್ಕೇನೆ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಮಾಡಿದಕ್ಕೆ ಮಿಸ್ಪ್ಲೇಸ್ಡ್ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು ಸೇರ್ಕೊಂಡು ಎಲ್ಲರೂ.
Number submission, kindly date by the time we'll secure all that.
ಡೇಟ್ ಏನ್ರಿ ಎಷ್ಟು ಸರಿ ಡೇಟ್?
One start date, by the time we'll secure everything.
When this court has summoned the original records, Tahsildar and Deputy DC comes and says that documents are misplaced. That is the reason only this court directed to register the criminal case against the officials of the district court, the Tahsildar office of Beluru.
Short date, my lord, by the time I'll get
Short
the entire documents.
ಆಯ್ತು, ಬೇರೆದೇನು ಹೇಳಿ. You know end. Yes, madam. Other than whether court can rely upon that document? ಎಸ್ ಸರಿ ಕೊಡೋದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Humble submissions, my lord.
ಆಯ್ತು,
Start
ನೆಕ್ಸ್ಟ್
date.
ನೆಕ್ಸ್ಟ್ ನೀವ್ ಹೇಳ್ರಿ, ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು? DPR ನವ್ರು ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ.
DPR under secretary is filing affidavit.
ಹಾ,
And but two aspects. The charge sheet is filed against 5 officials now.
5 officials.
Five officials.
ಯಾರ್ಯಾರು ಹೇಳಿ? ನಿಮ್ಮ ಎಂಕ್ವೈರಿನಲ್ಲಿ ಯಾರ್ಯಾರ ಮೇಲೆ ಬಂದಿದೆ? ಫಯಾಜ್ ಅಹಮದ್, ರವಿ, ನಾಗರಾಜ್ BK, ಮಂಜುನಾಥ್ BM, ನಾಗರಾಜಪ್ಪ. ಇದು ಚಾರ್ಜ್ ಶೀಟ್
ಇವ್ರ ಮೇಲೆ
ಪೊಲೀಸ್ನರ್ ಫೈಲ್ ಮಾಡಿರೋದು. ಆಯ್ತಲ್ಲ?
Complaint filed by the revenue.
ಆಯ್ತು, ಇದು ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರೋದು ಇಷ್ಟು ಜನಕ್ಕೆ, ಹೌದಾ?
Next date is Millard on 26/11/2024.
ಏನದು?
Criminal case. Date.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬಿಟ್ಬಿಡಿ.
Then as per
ನೀವು DPR ನವ್ರು ಏನ್ ಮಾಡಿದ್ರಿ?
inquiry is concerned.
ನೀವೇನೋ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತೀವಿ ಅಂದ್ರಲ್ಲ, ಏನ್ ಮಾಡಿದ್ರಿ?
Now, my lord, the DPR has placed the matter before the competent authority.
ಹಾ.
Is approved.
ಹಾ,
Once is approved, once.
ಯಾವಾಗಿಂದ ಇಟ್ಟಿದ್ದೀರಿ ನೀವು?
ನಿನ್ನೆ ಕೊಟ್ಟಿ.
ನಿನ್ನೆವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
There was.
ಇವತ್ತು ಪೋರ್ಟಲ್ ಕೇಸ್ ಬರುತ್ತೆ ಅಂತ ಇಟ್ಟಿದ್ರಾ?
Sir, ರಜಾ.
ಹಾ?
4 ದಿವಸ.
ರಜಾ ಬಿಡ್ರಿ, 6 ತಿಂಗಳಾಯ್ತು ಇದು.
ಇಲ್ಲ ಈಗ
ನಿಮ್ಮ DPR ಸೆಕ್ರೆಟರಿ ಕಾಲ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ ಒಂದು 6 ತಿಂಗಳಾಯ್ತು.
Necessary, making a submission that Millard certain particulars were not furnished by the revenue department and the deputy commissioner.
No, deputy commissioner comes and says that already papers are sent to the DPR long back.
Correct.
That is the submission recorded in the court
I
also.
only made that submission. But along with that, the details in respect of each official, 21 had not been furnished. Again, Millard, DPR had written to the revenue department, in turn, Millard, the revenue department.
Last time 23 ಜನದ ಮೇಲೆನ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ.
That's what we.
ಆ ನೋಟಿಸ್ ಗೆ ರಿಪ್ಲೈ ಏನ್ ಕೊಟ್ರು? ವಾಟ್ ಈಸ್ ದ ಡಿಸಿಷನ್ ಟೇಕನ್ ಬೈ ದಿ DPR ಹೇಳಿ. Why you have placed this charge sheet material before the court? Charge sheet material ಅವ್ರು ಕೊಡ್ಬೇಕು, ನೀವಲ್ಲ. ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
Along with the report, Millard, the copy of.
What is the decision taken by the government?
ಅದು ಹಾಗೆ ಫೈಲ್ ಮಾಡಿ.
Whether this court again summon the DPR secretary before the court?
Not necessary.
Not necessary. What action you have taken?
No, my lord,
You,
now the
you
matter-
cannot say the court, not necessary. Counsel?
Why not necessary?
Ah,
I'm making a submission that the matter is
what
now
is the progress from last 6 months?
last six
From the
months.
DPR, after the DPR secretary appeared before this court, that's what
My lord,
this court requires
kindly
the
see
details.
affidavit, my lord.
Ah.
What we have done is.
You cannot say that not required anta.
No,
Whether it is required or not, court will decide.
ultimately, my lord, it is not
Ah.
the court.
Ah,
I'm,
ಮತ್ತೆ?
I'm only,
Don't make such submission before the court.
no, I am only making a submission to
Ah.
the court.
You show me the progress done by DPR after the DPR secretary appeared before this court. Kodri, order sheet
Kindly
kodri.
see the affidavit.
Ah. ಏನ್
Kindly see
affidavit?
the- Now I have given.
ಇವತ್ತು ಹಾಕಿರೋ affidavit ಆ?
Shall I read? ಈಗ ಕೊಟ್ನಲ್ಲ ಅದು.
ಯಾವ್ದು ಕೊಟ್ರಲ್ರಿ ಇದು? ಕೆಳಗೆ ಕೊಟ್ರಲ್ಲ ಅದು 2854 ಅಲ್ಲ. Nothing but dumping of records. Huh. 6th level. ಇರ್ಬೇಕು ನೋಡಿ.
ಇದೆ.
They are the ನೋಡಿ. ಇನ್ಯಾವ್ದು ಇಲ್ವಲ್ಲ.
ಅದೇ
Sixth level. ನೋಡಿ ಅದ? ಹಾ.
ಇಲ್ಲಿ
ಅದೇ.
ಜರ್ಮನಿಯಿಂದ
Affidavit filed by whom?
Affidavit filed
ಬೆಂಗಳೂರಿಂದ
by
ಜರ್ಮನಿಗೆ
blood under secretary
ಎರಡು
DPR.
Hmm.
Blood paragraph 1. Respectfully submit that the district commissioner of Assam, the letter dated 21/9/2024 has submitted a report to the revenue department. The report states that legal action has already been taken against 4 out of 23 officers, employees who are responsible for the missing of records. Based on the defense statements and the remaining 19 officers, the district commissioner has opined to drop the charges against the said 19 employees. The report has been forwarded to DPR through an unofficial note dated 10/10/2024 along with the consent of the revenue department. A copy of the said unofficial note is produced as Annexure R1.
ಆಯ್ತು, ಅವ್ರಿಗೆ ಎಗನೆಸ್ಟ್ ಯಾರು 4 ಹೇಳಿ.
Uh,
ಹೆಸರು ತೋರಿಸಿ ಎಗನೆಸ್ಟ್ 4.
Then para 3.
ಅಲ್ಲ, ಔಟ್ ಆಫ್ 23 ನಲ್ಲಿ ನೀವು ಯಾರ ಮೇಲೆ ಈ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ರೆಕಮೆಂಡ್ ಮಾಡಿರೋದು?
That minute that illegal.
ಎಲ್ಲಿದೆ ಅದು?
But that is along with
Where is the report of the deputy commissioner?
R4 ಅಂತ ಇದೆಯಲ್ಲ flag ಅಂತ ತಗೊಳ್ಳಿ.
R4.
ಇದು revised information.
ಹಾ.
All the details in respect of
2410.
ಹೌದು.
ಹಾ.
2410 ಅಲ್ಲಿ ಇದು
ಅದೇ
revised ಇದೆ.
ಯಾರ ಮೇಲೆ ಇದೆ ಅಂತ ಕೇಳಿದೆ ನಾನು. 4 ಜನ ಅಂತ ನೀವು ಬರ್ದಿದ್ದೀರಿ.
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಇದೆ.
ಹಾ. ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ 4 ಜನ ಅಂತ.
ಕೆಳಗಡೆ
ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಶ್ರೀ ವಿ.ಕೆ. ನಾಗರಾಜ್ ಗವರ್ಮೆಂಟ್ ಲಾಸ್ಟ್ ಬಟ್ 1 page.
ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್?
ಲಾಸ್ಟ್ ಪೇಜ್ ನಂಬರ್
ನೋ ಪೇಜಿನೇಷನ್ ನಥಿಂಗ್.
ಲಾಸ್ಟ್ ಬಟ್ 1 ಇದೆ ಅದಕ್ಕಿಂತ ಹಿಂದಿನ ಪೇಜ್. ಆಫ್ಟರ್ 21 ಮೆಂಬರ್ಸ್ ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ
ಹಾ.
ಅದ್ರ ಕೆಳಗಡೆ
ವಿ.ಕೆ. ನಾಗರಾಜ್ ತಹಸೀಲ್ದಾರ್
ಕೈ ಬಿಡಬಹುದೇ ಅಂತ ಹೌದು.
ಸಿರಿಸ್ತೆದಾರ್
ನಾಗರಾಜ್
ಫಯಾಜ್
ಅಭಿ,
ಅಹಮದ್. ಹಾ.
ನಾಗರಾಜಪ್ಪ ಟೆಂಡರು ಮಂಜುನಾಥ್. ಈ 4 ನೌಕರರ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗಿರ್ತದೆ ಹಾಗೂ ಪ್ರಸ್ತುತ ಪ್ರಕರಣವು ತನಿಖೆ ಹಂತದಲ್ಲಿರುತ್ತದೆ. ಬಿ.ಕೆ. ನಾಗರಾಜು ತಹಲ್ವರೆಗೂ ಸ್ಥಿರಸ್ತಿದ್ದಾರೆ. ಅಭಿಲೇಖಾಲಯಕ್ಕೆ ಕಡತ ಸ್ವೀಕರಿಸಿದ ನಂತರ ನಿಗದಿಪಡಿಸಿದ ಬಗೆಯಲ್ಲಿ ಕಡತದ ವಿವರವನ್ನು ನಮೂದಿಸಿ ಇಂಡೆಕ್ಸಿಂಗ್ ಮತ್ತು ಕ್ಯಾಟಲಾಗಿಂಗ್ ಒಳಪಡಿಸಿ ನಿರ್ದಿಷ್ಟ ಸಂಖ್ಯೆಯ ಟ್ರ್ಯಾಕ್ನಲ್ಲಿ ಸಂರಕ್ಷಿಸಬೇಕಿತ್ತು. ಆದರೆ ಈ ಕಾರ್ಯ ಕೈಗೊಂಡಿರುವುದು 2019ರಲ್ಲಿ ಬೇಲೂರು ತಾಲೂಕು ಅಭಿಲೇಖಾಲಯ ಶಾಖೆಯ ನವೀಕರಣ ಸಮಯದಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಮಾನ್ಯರ ಅವಗಾಹನೆಗೆ ತರುತ್ತಾ ಕಡತ ಲಭ್ಯವಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ನವೀಕರಣ ಸಮಯದಲ್ಲಿ ಲಭ್ಯವಾಗುತ್ತಿತ್ತು. ಅಭಿಲೇಖಾಲಯ ಶಾಖೆ ಮೇಲ್ವಿಚಾರಣೆ ಮತ್ತು ನವೀಕರಣದಲ್ಲಿ ಶಿರಸ್ತೇದಾರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವಂತ ವಿ.ಕೆ. ನಾಗರಾಜರವರು ಸರಿಯಾಗಿ ಮೇಲ್ವಿಚಾರಣೆ ಮಾಡದೆ ಕಡತ ಕಾಣೆಯಾಗಲು ನೇರವಾಗಿ ಕಾರಣಕರ್ತರಾಗಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದ ಸದರಿಯವರ ಮೇಲೆ ಹೆಚ್ಚಿನ ವಿಚಾರಣೆ ಕೈಗೊಳ್ಳಬಹುದಾಗಿ ಅಭಿಪ್ರಾಯಿಸಿದೆ. ಅದು ದೆನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ನೆಕ್ಸ್ಟ್ ಫಯಾಜ್ ಅಹಮದ್, ಅವನು ಆಸ್ ಫಾರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ
ಆಯ್ತು, ನಿಮ್ಗೆ 1010 ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ರಿಪೋರ್ಟ್
ಎಲ್ಲ
ಹೌದಾ?
ಆಮೇಲೆ
ಆ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಏನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ?
ನಾವು
Deputy Commissioner given the details that 4 officials are responsible for the same. ಹೌದಾ? ಏನೋ ಅನ್ಅಫಿಷಿಯಲ್ ನೋಟ್ ಅಂತ ಬರೀತೀರಿ. ಏನದು ಅನ್ಅಫಿಷಿಯಲ್ ನೋಟ್?
ಟಿಪ್ಪಣಿ ಅಂತ ಅವರು ಇಂಟರ್ನಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದಾದ್ರೆ
ಆಯ್ತು. ಆಮೇಲೆ ಏನಾಯ್ತು? 2310. Therefore, in an unofficial note 2310/24, the revenue department was requested to provide the requested information in a specified format detailing all officials employees involved in the case along with the relevant details. It is respectfully submitted that District Commissioner Hassan District in a letter dated 24/10/24 submitted a report to the Revenue Department. In the report, it opened to draft the charges against the said 21 officers, employees, and to conduct a further inquiry against the Nagraj, Fayaz Ahmad, who are directly responsible for the missing records. The Revenue forwarded the report of DPR through an official note dated 28/10/24 necessary action. Official note, unofficial data. District Commissioner report dated is produced along with so and so. It is further submitted that report of the Deputy Commissioner also includes a copy of the charge sheet filed against accused number 1 to 5, so and so, so and so. Now matter is pending before whom?
Before the competent authority, Sakshama Pradhikara antive, competent authority. And yesterday the file is put up before the competent authority. Probably some decision will be taken.
Taken within
That is placed before competent authority.
third. AAG files affidavit of Under Secretary to Government DPRs that though proceedings initiated against the 23 officials, out of that 4 officers, employees who are responsible as per the report of the District Commissioner, and the same is before the competent authority to take the decision, and going to take the decision within a period of
They will go 3 to 4 weeks.
4 weeks for missing of records. The same is taken on record. Heard the arguments of the petitioner counsel and also the counsel appearing for the complainant respond number 1, and also the additional SPP for the state reserved.
Obliged.
Orders. ಯಾವ್ದು ಹೊಸ ಬಂದ್ರ ಅವರು
62 and password. 62 Latif.
ಬನ್ರಿ ಏನದು
Successive bail application.
Why it was urgent in the last occasion?
No, but it was first time last.
First time.
Last time, first time bandittu.
Directed to accept notice for the respondent and file objections if any.
Lord, kindly see the page number 100, Lord, the last order.
100.
Out.
Earlier order.
House. When the matter, when this court is about to dictate the order, this juncture learned counsel for the petition would submit that.
Liberty to the petitioner to approve this court after cross-examination of other eyewitnesses and examination of Caesar witnesses CW 7 and 8.
Please. Now, Lord, the Caesar witness has been examined. As PW 7 and 8. At page number.
Cross-examination of other witnesses.
Please.
Other eyewitnesses are cross agid amel.
Lord, the first eyewitness, my lord, is PW 2.
PW 2 na.
How? That is PW 3, PW 2.
ವಿಚಾರಣೆ ಆದ್ಮೇಲೆ ಅವ್ರು PW ಆಗ್ತಾರೆ ಮೇಡಮ್, ಯಾರು ಹೇಳಿ ಅವರು?
PW 2.
PW 2 ನಾ? ಐ-ವಿಟ್ನೆಸ್.
ಹೌದು.
ಅವ್ರು ಕ್ರಾಸ್ ಆಗಿರ್ಲಿಲ್ವ ಮೊದ್ಲು? ಅರ್ಲಿಯರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿರ್ಲಿಲ್ವಾ ಅಂತ ಕೇಳಿದೆ, ಅರ್ಲಿಯರ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡುವಾಗ.
ಆಗಿರ್ಲಿಲ್ಲ, ಫುಲ್ ಆಗಿ ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿರ್ಲಿಲ್ಲ.
ಇಲ್ಲ.
ಆಗಿದೆ ಅಲ್ರಿ, ಅವ್ರು ಬರೀ PW 2 ವಾಸ್ ಹಾಸ್ಟೈಲ್.
Please, PW, then PW 4 ಆಗಿಲ್ಲ. 3.
ಅರ್ಲಿಯರ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿರೋದು ಯಾರ ಮೇಲೆ ರೀ?
PW 4 ರವಿ.
earlier eyewitnesses, ಯಾರನ್ನ exam ಕ್ರಾಸ್ ಆಗಿಲ್ಲ ಅಂತ
PW4.
that liberty may be given to the petitioner to approach this court after the examination of witnesses CW7 and 8 who are the seizure witnesses, the SICM which is seized. The material also disclosed that other eyewitnesses who have supported the case of the prosecution before the trial court have also not been cross-examined.
PW4, 4.
Four,
ಹೌದು.
and their cross-examination was deferred at the instance of learned counsel for the petitioner. PW4,
ಹೌದು, ಹೌದು. Page number 63 ಅಲ್ಲಿ PW4, Ravi.
Ravi, you eyewitness,
ಹೌದು. There is a delay in recording the statement of
ಆರೋಪಿ ಕೆಂಡನಾಯಕ ನನ್ನ ಮಾವ ರಾಜನಾಯಕನನ್ನು ಮಚ್ಚಿನಿಂದ ಕೊಲೆ ಮಾಡುತ್ತಿದ್ದುದನ್ನು ನಾನು ನೋಡಿದೆ. ಆರೋಪಿ ಕೆಂಡನಾಯಕ ರಾಜನಾಯಕನ ಹೊಟ್ಟೆಗೆ ಮಚ್ಚಿನಿಂದ ಹಲ್ಲೆ ಮಾಡಿ ಅವನ ಕರುಳುಗಳನ್ನು ಕಿತ್ತು ಬೇಲಿಯ ಮೇಲೆ ಎಸೆಯುತ್ತಿದ್ದನು. ಆರೋಪಿ ಕೆಂಡನಾಯಕ ರಾಜನಾಯಕನ ಮುಖಕ್ಕೆ ಸಂಪೂರ್ಣವಾಗಿ ಮಚ್ಚಿನಿಂದ ಹಲ್ಲೆ ಮಾಡಿ ಗಾಯಗೊಳಿಸಿದ್ದನು. ಅಷ್ಟರಲ್ಲಿ ಪ್ರಾಸ ಒಂದು ಜವರನಾಯಕ ಸ್ಥಳಕ್ಕೆ ಬಂದಿದ್ದು ಹಾಗೂ ಗ್ರಾಮಸ್ಥರು ಸೇರಿಕೊಂಡರು. ಆಗ ಪ್ರಾಸ ಒಂದು ಜವರನಾಯಕ ಆರೋಪಿಯನ್ನು ಹೇಗೆ ಮಾಡಿದೆ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ ಆರೋಪಿ ಕೆಂಡನಾಯಕ ಏನು ಮಾಡುತ್ತೀಯೋ ಮಾಡು ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿದನು. ಆರೋಪಿ ಕೆಂಡನಾಯಕ ಮತ್ತು ಮೃತ ನಾಯಕನ ನಡುವೆ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ಇದೆ. ವಿಚಾರವಾಗಿ ಕೆಂಡನಾಯಕ ರಾಜನಾಯಕನನ್ನು ಕೊಲೆ ಮಾಡಿರುತ್ತಾನೆ. ನಂತರದಲ್ಲಿ ಆರೋಪಿ ಕೆಂಡನಾಯಕನ ಮನೆ ಮುಂದೆ ಜಗಲಿ ಮೇಲೆ ಹೋಗಿ ಕುಳಿತುಕೊಂಡನು. ಅವನ ಮನೆಯ ಮುಂದೆ ಆರೋಪಿ ಕೆಂಡನಾಯಕ ಮೈ ಮೇಲೆ ಮೃತ ನಾಯಕನ ರಕ್ತ ಬಿದ್ದಿದ್ದು ಮೈ ತುಂಬ ರಕ್ತದ ಕಲೆಗಳಾಗಿದ್ದವು. ನಾನು ಘಟನೆ ನಡೆದ ಕೊಡಗು ಜಿಲ್ಲೆಗೆ ಕೆಲಸಕ್ಕಾಗಿ ಹೋಗಿದ್ದೆ. ಸುಮಾರು ದಿನಗಳ ನಂತರ 1.5 ತಿಂಗಳ ಕೆಂಡನಾಯಕನ ಕೃತ್ಯಕ್ಕೆ ಬಳಸಿದ ಮಚ್ಚನ್ನು ನೋಡಿದ್ದೆ. ಈ ದಿನ ನೋಡಿದ್ರೆ ಗುರುಸುತ್ತೇನೆ. ಒಂದು ಸೀಲಾದ ಮಚ್ಚನ್ನು ಸೋಂಸಲಾಯಿತು. ಹೇಳಿ.
the cross examination. At page number 67 ಅಲ್ಲಿ last 3 lines.
67.
ಹೌದು. ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿದ ಹೇಳಿಕೆಯಲ್ಲಿ ರಾಜನಾಯಕ ಮತ್ತು ಆರೋಪಿ ಜಗಳವಾಡುತ್ತದನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿದ ವಿಶ್ವನಾಥನವರು ನನಗೆ ಗಲಾಟೆ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ನೀಡಿದ್ದರೊಂದು ಹೇಳಿಕೆ ನೀಡಿಲ್ಲ. ಸಾಕ್ಷಿ ಸದರಿ ಭಾಗವನ್ನು ದಿಶಾನಪಿ D1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. As per this statement of this witness, he received an information from one Vishwanath, and he is not an eyewitness. The information about the eyewitness was that's Vishwanath. He had informed this witness. And another witness for PW5. She has turned hostile.
You are relying upon only the exhibit D1.
D1.
Another witness, eyewitness?
PW5. She has turned hostile. And recovery witnesses are PW6 and 7. Both witnesses are turned hostile. Now, my lord, the petitioner is in custody from last 3 years, 2 months. PW8 also the inquest witness, and 9 also turned hostile.
What is the FSL report? Whether FSL report witness is examined?
No, not examined.
Any positive report of FSL? All are chop wound only.
ಹೌದು. Now, my lord, the petitioner is in custody for more than 3 years. And material witness I already examined. And he is the resident of same village. And he will appear below till conclusion of trial in all dates. Because of my lord, he having a agricultural farm of he growing this tobacco, my lord. Every 3 years, he is growing tobacco. Every year, 3 years, my lord, he has to renew his license. That too also it is how. And his
Tobacco license renew ಮಾಡಕ್ಕೆ ಅವ್ನು ಬಿಡ್ಬೇಕು ಅಂತಾನಾ
ಅಲ್ಲ.
argument.
Presence is also required, my lord, for renewal. And the material witness already been examined. And the tampering of witnesses does not arise at this stage. And other witnesses are official witnesses.
Yes, madam.
Your Lordships, the FSL report has shown the clothes and weapon were recovered at his instance, Your Lordships. FSL report shows that there were bloodstains detected with human blood. Also, Your Lordships, PW4, who is the eyewitness, he has supported the case of the prosecution.
PW4.
PW4. He very much says in page number 78, Your Lordship. ನಾನು ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ, ಆರೋಪಿಯು ಕೃತ್ಯವನ್ನು ನಾನು ಪ್ರತ್ಯಕ್ಷವಾಗಿ ನೋಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. He very much states that he was present in the spot.
And he is the.
ನಿಮಿಷ ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಲಿ ಆಮೇಲೆ ಹೇಳಿ.
So, Your Lordships, weapons have been recovered. Your Lordships, the overt act is also there against the present petition. There are eyewitnesses who they were eyewitnesses, Your Lordship, and in which one eyewitness has supported the case of the prosecution. Your Lordships, with regard to the FSL report also, the witnesses have to be still examined. And weapon, Your Lordships, which was detected, the medical opinion is that the injuries that are caused on the body are is due to the said weapon that is recovered, Your Lordships. The medical opinion also supports the case of the prosecution. Your Lordships, already, so witnesses have been examined during the course of the trial, Your Lordships. In between the trial, Lordships, the petitioner is seeking bail now.
Yes. ಹೇಳಿ.
Lord, only one witness, Lord, who PW4 has been examined as eyewitness. Other eyewitnesses are turned hostile. PW4, who is the close relative of the deceased, is claimed that he the deceased is the uncle of the witness. And his statement was recorded after 1.5 months. And he is specifically say that immediately after the incident, he had been to Kodagu. And he did not attend the even funeral function. And after 1.5 months, his statement was recorded. It is, Lord, one looking to this statement of this witness creates a doubt, Lord, being a relative and this is an uncle. He had not participated in the funeral function and left the place immediately and to Madikeri. And his statement was marked at Exhibit D1, indicates that he is not an eyewitness. He has received information from one Vishwanath, who has been cited as eyewitness, has been turned hostile. That is PW3.
Who are all the eyewitnesses actually?
4 and 5, Your Lordships.
3, 4 and 5.
PW3 and 4,
PW3, 4 and 5.
PW3.
Howd?
He turned hostile.
Hostile, 4 turned hostile. 5 is the PW4. He is the close relative.
Among the eyewitness, only one witness is supported according to you.
Please. That is also doubtful witness.
Heard the petitioner, counsel and also the counsel appearing for the respondent. This is a successive bail petition filed by the sole accused, filed by the accused. And this court earlier, in criminal petition number 3958 of 2022, with order dated 22nd day of June 2022, dismissed the bail petition. And once again, he had approached this court in a successive bail petition, criminal petition number 1778 of 2024, and the same was also dismissed on 27th day of March 2024. While dismissing, this court has heard the matter, and while dictating the order, at the said juncture, the counsel appearing for the petitioner requested the court to give liberty to the petitioner to approach this court after the examination of CW 7 and 8, who are the Caesar witnesses, and also the eyewitness who has not been cross-examined, and hence this court dismissed the petition as withdrawn with liberty to approach the court after the cross-examination of other eyewitnesses and examination of Caesar witnesses. The counsel appearing to the petitioner would submit that the Caesar witnesses who have been examined as PW 7 and 8 have turned hostile and not supported the case of the prosecution. The counsel also would submit that other eyewitness who has been examined as PW 4 was cross-examined, and there is a discrepancy in his evidence.
PW 5 also eyewitness, hostile.
Hostile alone.
ಹೌದು.
PW 4 was cross-examined, and there is a discrepancy in the evidence of PW 4, though he contend that he witnessed the incident of committing the murder. But when the document of his statement was recorded and confronted to him, he denied the statement in terms of D1, wherein it is stated that he got the information one through Vishwanath. And also the statement of PW 4 was recorded after 1.5 months of the incident, and he is also a close relative, and his evidence cannot be believed. The counsel also submits that this petitioner is in custody from 2021 and he may be enlarged on bail. Per contra, the counsel appearing for the respondent state would submit that even the court can convict the accused on the based on the sole witness of eyewitness PW 4 who had supported the case of the prosecution, and he specifically deposed before the court that he had witnessed the incident of overt act, inflicting the injury with the weapon. The counsel also brought to notice of this court PM report wherein 9 injuries are found, and almost all injuries are chop wound injuries. And doctor also to be examined, and also the IO has taken the opinion from the doctor that the seized article, which was sickle, could cause the nature of injuries found in the PM report. The counsel appearing for the state also would submit that FSL report is also positive, and FSL witness also to be examined, and mere examination of CW 7 and 8, and both of them turning hostile cannot be a ground to enlarge him on bail. The trial has already been commenced, and yet to examine other prosecution witnesses, and though other 2 eyewitnesses have turned hostile, and this court cannot appreciate the evidence available on record. Having heard the petitioner counsel and also the counsel appearing for the state, the factual matrix of the case is that the accused had borrowed an amount of rupees 50,000 from the complainant, and portion of the amount was repaid, and he was due for remaining amount, and with regard to the non-payment of balance amount, Galata was taken place, and that on 17/9/2021 at about 9:50 PM, when the accused came out from Baron to go to his house, he saw the victim coming backside the Baron, and he had questioned him why he came near the house and pushed him, and scuffle was taken place between them. And due to the earlier grudge against the victim, he took out the machete and inflicted the injury. As a result, he succumbed to the injuries. This court also, while considering the material on record earlier, rejected the bail petition in criminal petition number 3958 of 22, with order dated 22nd day of 2022. And considering the matter on merits, dismissed the same. No doubt petitioner also approached this court in the month of, in 2024. In criminal petition number 1778 of 24. And when this court about to dictate the order, at this juncture, the petitioner counsel requested the court to give liberty to approach the court after the examination of CW 7 and 8. No doubt CW 7 and 8 have been examined before the court and they have turned hostile. And other eyewitness is cross-examined subsequent to the petitioner sought liberty, and PW4 was cross-examined. And on perusal of evidence, he has supported in his chief evidence, and counsel appearing with the petitioner would contend that there is a discrepancy in the evidence of the PW4, who is an eyewitness, regarding coming to know about the incident. When the trial has been began and the witness examined, and this court, sitting under section 439 of CRPC, cannot appreciate the evidence available on record, and yet to trial court consider the evidence on merits. It is also not in dispute that recovery is made at the instance of the petitioner, and though two witnesses have been examined, CW 7 and 8, and those two witnesses have not supported the case of the prosecution, and other material available before the court is with regard to medical evidence, and the doctor who has examined the weapon at the request of the IO gave the opinion that the sickle which was seized at the instance of the accused could cause the injuries. And apart from that, there is a positive report of the FSL, and FSL also discloses blood stains in the weapon. And when suspecting the case, other witnesses are examined before the court, and court has to take note of the direct evidence as well as other circumstantial evidence while appreciating the material on record. Merely because this petitioner is in custody from 2021 cannot be a ground to enlarge him only after considering the examination of CW 7 and 8 evidence and eyewitnesses evidence also to be appreciated by the trial court, and also to take note of the injuries found in the PM report, and all the injuries are chop wound injuries, and Vote Act allegation is also that he inflicted injury with the sickle. And when such material available before the court, question of exercising the discretion in favor of the petitioner on only ground that evidence already been commenced and no need of further custody cannot be accepted. Court has to take note of the gravity of the offense and also the nature of injuries, as well as the material available before the court, and hence I do not find any ground to exercise the discretion in favor of the petitioner. However, this court can give direction to dispose of the matter in a time-bound period. In view of the discussions made by Pasti Palangoda, bail petition is rejected. Trial court is directed to conclude the trial and dispose of the same within a period of 6 months from today.
Lord, the observation will come in the way, Lord.
The observation made by this court while rejecting the bail petition shall not influence the trial court while considering the matter on merits. ಯಾವ್ದು ಬಂತು ಅದು ರೆಕಾರ್ಡು? ಕೊಡಿ ಅದೇನು ನೋಡ್ರಿ. ಕೊಡ್ರಿ ನೋಡ್ಯಾನ ನಾ ಕ್ರಾಬ್ ಹಾಕಿದೀನಿ ಅಂತಾರಲ್ಲ ಅದಕ್ಕೆ.
It's okay, what is the number in it?
ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಇಲ್ಲಿ ಕ್ರಾಬು?
ಆ objections ನ cross objections ಬರೆದಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ 41 rule 20 ಸುಮ್ಮನೆ ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. It is a cross objection, my lord. I have sought for
ನಂಬರ್ ಕ್ರಾಬ್ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
ನಂಬರ್
MFA ನೇ ಹಾಕಿದಿರಿ.
ಅಲ್ಲ MFA ನಲ್ಲಿ my lord.
24. ಹಾ.
Memorandum of cross objection under order 41 rule 22. Read with 43 rule 1.
ಆಯ್ತು, ನಿಮ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ತೋರಿಸ್ಬೇಡ್ವಾ ಕ್ರಾಬ್ ಅಂತ? ಹಾ?
ಇಲ್ಲ,
ಹಾ.
ಅದು CROB ಅಂತ ಹಾಕ್ಬೇಕಲ್ಲಿ. CROB in MFA.
ಕ್ರಾಬ್ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
The CROB is missing. It is missing.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಎಲ್ಲಿದೆ ಕ್ರಾಬ್ ಅಂತ?
ಅಷ್ಟು ಇದೆ, CROB ಒಂದು ಮಿಸ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಅದೇನೆ ಬೇಕಾಗಿರೋದು.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ
ಅದನ್ನ ನೀವು ತೋರಿಸ್ತವ್ರ ಆಫೀಸ್ನವ್ರ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡ್ತಾರೆ.
ಹೌದು.
ಆಯ್ತು ಹೇಳಿ.
My respectful submission, my lord.
ಎಸ್ ಹೇಳಿ.
This one. Photographs and it all started, my lord, with the OTS, which was entered between the respondent number 1 to 9 and 10 and 11, my lord. We had a running loan along with India Bulls, to the tune of about 350 to 400 crores, my lord, and they had approached the NCLT. And in NCLT, when the matter was under CIRP, my lord, we had approached the NCLT, and there a settlement was entered between both the parties, my lord. As per the OTS settlement, my lord, the India Bulls, they were not supposed to have entered into any other transactions concerning respondent number 1 to 9, my lord. Those are the terms of the OTS. Unfortunately, my lord, the OTS is presently vesting with an escrow agent, and we do not have the copies of that. That is my case even before the trial court, my lord. My respectful submission, my lord, in their preliminary objections, my lord, whether it is their preliminary objections or their appeal memo, my lord, it echoes the response by respondent number 10 and 11, rather than catalysts themselves saying on what grounds they invoke the pledge. Now, I would like to bring to my lord's kind notice. Color alla.
You can urge all these grounds before the trial court. Now only you restrict your argument with regard to the passing of an order of status quo.
Now they say in their preliminary objections that there was no OTS agreement. And based on my.
Aye, let the trial court decide whether there is a OTS agreement or not. Well, considering the matter on merits on IS.
My lord, again, they take a contention that only commercial courts have got the jurisdiction and civil courts do not have the jurisdiction to try this matter, my lord. Now, the crux of the matter again goes to the notice, which is the acceleration notice which was issued.
Whatever the objections they have raised, there is no finding by the trial court with regard to the objections what they have raised.
My lord.
Now, only the scope of this appeal is only for the limited purpose of granting of status quo. That is also an ad interim injunction.
Lord,
that has been challenged.
Please, my
You
lord.
make submission to that.
Please, my lord. My respectful submission, my lord, is regarding the acceleration notice, my lord. It starts with that. Acceleration notice. Mix ಮಾಡಿ. Acceleration. Court copy naida. ಅವ್ರಿಗೆ ಇದು acceleration. ಕೊಡ್ತೀನಿ. ಮಿಕ್ಸ್ ಮಾಡಬೇಡಿ.
ಇದು 25, 2020.
My lord, it starts with that. It starts with that. My lord may kindly see. Now, the notice itself is the crux of the matter, my lord. March 25th, 2022, it is addressed to Mantri Infrastructure Private Limited. It is addressed to only one party, my lord. Now, it says, we refer to the bond trust deed dated June 4, 2018, entered into between Mantri Infrastructure Private Limited, issuer company, Mantri Developers Private Limited, MDPL, Plaza Agencies Private Limited, PAPL, Mantri Resi Structure Private Limited, MRPL. Now, all these entities, my lord, are parties to this agreement, my lord. Not just the bond trust deed, but also to the pledge agreement, my lord.
Yes.
Now, whereby the issuer company issued and allotted 2,500 senior redeemable rated listed secured non-convertible bonds, subject bonds, on a private placement basis aggregating to so and so on the terms and conditions set forth, my lord. Now, it is irrelevant for me to go through the rest of the things, my lord. I will take, my lord, to the CC, my lord. Who are the parties? It says Mantri Developers Private Limited, rightly so. Plaza Agencies Private Limited, PAPL. Mantri Resi Structures Private Limited, which is again very crucial, my lord. Mantri Resi Structures Private Limited and Mr. Sushil Mantri. Now, subsequent to that, my lord, even they approached the NCLT and they are directed to join the COC as a CIRP had been initiated and COC was about to be formed. They were directed to join the COC, my lord. After that, they go silent. They do not do anything after June 2023, my lord. My respectful submission now, after the acceleration notice, the only intimation that I get is on the intervening night of September 28th and 29th at 1:38 a.m. issuing the invocation notices, my lord, invocation of the pledge. My respectful submission, invocation notice, my lord. Invocation item. Very quick copy. My lord, may kindly see. Now, this is dated 28th of September 2024. Two Mantri developers, then Mantri Infrastructure Private Limited, Plaza Agencies. Now, MRPL, to whom the copies were sent, who are also parties to that, who are parties to agreement, is conspicuously missing. Now, my most respectful submission, my lord, night driving and night drafting is going to be fatal to everybody, my lord. As I see, if notices are sent at 1:38 a.m. in the night, my lord, I do not know who has accepted all those things, and naturally the names goes missing. Now, what do they refer to here in this, my lord? It says reference, bond trustee defined below. 2. Acceleration notice dated March 25th, 2022. We Catalyst Trusteeship Limited issue the present communication in reference to the bond trust deed dated June 4, 2018, entered into between Mantri Infrastructure Private Limited, Mantri Developers Private Limited, Plaza Agencies Private Limited, Mantri Resi Structures Private Limited. Their names are found only in the body. It is not addressed to them. Now, when we go to the end of that invocation notice, my lord, no CC to anybody. Now, as I am a necessary party, I should be notified. There is a cascading effect, my lord. If the pledges are initially transferred and subsequently sold, and if it is sold for something of a lesser value, I'm going to lose, my lord. Under such circumstances, no notices have been issued to Mantri Resi Structure, which is a major lacuna and a defect in the notice, my lord. Now, I will take my lord to the sale notice. The learned senior counsel, my lord, with all his benevolence, he was saying, where did you find those 5 days, five business days, my lord? Now, again, this is sent to the same 3 parties or 2 parties, my lord. And here they say, unless all the common secured obligations have been irrevocably discharged in full to the satisfaction of the common trustee within 5 business days after the date of this notice for sale, the common trustee, security trustee shall be entitled to exercise its power of sale pursuant to 7.2 of the agreement anytime thereafter. Now, the 5 business days are found in the bond trust deed, my lord. 5 business days are not a Saturday, not a Sunday, and not a general holiday. Now, if we take the intervening night of 28th and 29th, it starts on 39/20/24, my lord. 39, 110, and then 210 is Gandhi Jayanti, and after that it ends on 6/10, my lord. And on the day when the suit is filed before the lower court, they come back with a NESL certificate which says it is invoked. Now, when there is no proper notice, when there is a defective notice, and they say my pledge is invoked, my lord. Now, my respectful submission regarding the commercial nature or whether it is civil in nature, my lord. Now, notices have been issued to 3 entities. The plaintiffs are 9. Now, what happens to the other 5 plaintiffs who are before the lower court, my lord? Naturally, I am aggrieved. There is a civil wrong which is committed. The reason I am saying this, my lord, is that there is a bond trust deed with one of the parties, and there is a pledge agreement. With the rest of the people, when there is no agreement, my lord, how can it even be construed as a commercial dispute, my lord? My lord, in ozone developers case, I would like to draw my lord's kind attention to ozone developers now. I had placed it before, my lord, on the previous date of hearing, but still, my lord. So the relevant paragraphs are from page 9, my lord.
I gave you 10 minutes only.
Another 5 minutes. It is my lord's judgment. I need not elaborate on that. Now, I will support that with Lady Moon's judgment, my lord. Lady Moon Towers Private Limited versus Mahendra Investment Advisors Private Limited. My lord. Now, my lord, this is totally on the nature of a dispute, whether how it is construed as a commercial dispute or how it needs to be a civil dispute. Now, again, in this case also, my lord, there have been agreements which has been interpreted by the learned court, my lord. However, when there is no agreement, what standards need to be looked into and what are the yardstick to construe whether a dispute is a commercial dispute or a civil dispute needs to be ascertained by my lord. My respectful submission is, if I'm allowed to go through, or there are no paragraph numbers mentioned in this, my lord. The entire judgment will have to be read.
Page is
My lord,
mentioned.
page 3, my lord. In order to ascertain whether the present dispute qualifies as a commercial dispute, within the purview of the Act, it is necessary to break down the classes of persons and transactions contemplated in the above clause. Since clauses 2 to 22 do not apply in this case, the construction of 2 subclause 1CI falls for consideration in the present case. Ordinary transactions of merchant bankers, financiers, and traders. My lord may kindly see respondent number 12, 13, and 14. There is no privity of contract. They are the agents of respondent number 10 and 11 who have been roped in for some shady purpose, my lord, and they have acquired certain certain bonds, certain non-convertible debentures, my lord. For what basis? I will come to that, my lord. Now, the statements in the plaint make it evident that the directors of the plaintiff.
What is
and
the conclusion in the judgment?
Please, my lord.
Instead of reading entire 11 pages.
My lord is right. It
Because
goes
now
through,
only, sir.
my lord, it goes through the kinds of persons.
What is the conclusion?
Please, please. My lord, may kindly take page 10, my lord. Last paragraph. The definition section of 2015 only contemplates the commercial disputes and not any other form of dispute where the basis of disagreement between the parties has a non-commercial cause. The gradation of the disputes in section 2(1)(c), taking into account all possible forms of agreements from which a commercial dispute may arise, makes it clear that the framers of the statute gave emphasis on the commercial flavor of the transaction as opposed to the agreements entered into between the parties without a commercial purpose. The qualification of the person being a merchant banker, trader, or financier imparts an unimpeachable commercial flavor to the transaction and the resulting dispute. The insolvency of the Bankruptcy Code 2016, for example, defines a dispute from a broader perspective as any suit or arbitration proceedings relating to an existing debt. Section 5, subclause 6, subclause A. The commercial purpose would generally mean a transaction by which a person's commercial or economic interests may be advanced and would result in an economic benefit to that person. It would not include an agreement where profit making is an incidental outcome of the transaction or may happen by accident. In this case, my lord, some of my properties are mortgaged with some of the entities, my lord, that is respondent number 10 and 11. They say in their preliminary objection, I would like to draw my lord's kind attention to their preliminary objection. It is so important, my lord.
You first conclude this judgment.
Well,
What is the
please.
finding?
It is connected
Then
with that.
harp on other issues.
Please, please,
Ah.
my lord. Please, my lord.
Now, why you are making?
I am given 10 minutes, my lord, and I need to.
Already
my-
15 minutes is over. 4, 5 you commenced.
I understand, and I understand.
That's why I said that the scope is very limited in this appeal.
My lord, since it has been found that none of the criteria mentioned in section 21CI of the Act has been met by the factual conspectus in the present case, commercial suit 99 of 2020 is directed to be delisted from the commercial division and transferred to the appropriate list governing the hearing of ordinary suits. Even in this case, my lord, there have been certain other parties who are not privy to any agreements, no privity of contract.
All this will, the trial court will decide on merits while considering the IA. That's all.
Please, my lord. Please, my lord.
Repeatedly, I am telling, but you are harping on the only on the merits of the IA. Instead of scope of this appeal.
My lord is right. As far as I'm concerned, my lord, all these things were submitted before the lower court. Considering this,
Even though they have raised that objection, let the trial court decide on the same on the main appeal. That's
please,
all.
I leave it to my lord.
Main IA. That's all.
If that is my respectful submission, my lord.
Yes.
Now there has been an order for maintaining status quo, my lord. I have filed my cross objection seeking for modification of that, my lord. And when the matter was heard in length, the learned senior counsel has addressed the argument for about 2 hours.
2 hours.
Where? Before the trial court, my lord. Well, after hearing both the parties at length, no harm or injustice is caused to them, my lord, as they were on caveat. Now, regarding the matter being res judicata, barred by res judicata, my lord, I have not argued before the lower court at all. Now, even in the office itself, my lord, by looking at my file, said that the commercial suit is not maintainable as there are no proper agreements.
Let the trial court decide whether your suit is maintainable or not.
My
Already pleadings are completed.
not completed, they filed their preliminary.
We have filed an application, Lord, to return the plaint. That application I've argued. He has to argue it. He's not arguing it. Now, Lord, with the one. Because I know my learned friend had some personal difficulty. I'm not saying anything.
That also you have.
We've anyway
considered and court also.
has considered it, my lord, and
time.
more than enough
When the
time.
request was made that
Yes.
family member was not in keeping peace well. That's all, reserved.
If I may be allowed to file my compilation of all these things, my lord.
ಇನ್ಯಾವುದು compilation?
Points, it is very important, my lord. Some of them, I need to submit.
Already you have, ಏನು statement of objections ಅಂತ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ ಒಂದು ಟೇಬಲ್ ಎಲ್ಲ ರೆಡಿ ಮಾಡುವ.
ಕೊಡ್ಬೋದು, ಕೊಡೋದೇನೋ ನಾಳೆ ಕೊಡ್ಬೋದು. ಇಬ್ರು ಕೊಡ್ಬೋದು.
ಆಗ್ಬೋದು.
ನಮ್ದು ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
550 ಕೋಟಿ ಕೊಡ್ಬೇಕು. ಅದ್ ಕೊಟ್ಬಿಡ್ಲಿ ನಾವು ಶೇರ್ಸ್
550 ಕೋಟಿ ಕೂಡ ಕರೆಕ್ಟ್ ಆಗಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ ನಾವು ಅವತ್ತೇ ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀವಿ. ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಪಾಸ್ ಅವ್ರ ಇದ್ಯಾವ್ದಾರು ಇದೆಯಾ? ಇನ್ನೊಂದ್ ಯಾವ್ದೋ ಒಂದು ಪಾರ್ಟೆಡ್ ಇರ್ಬೇಕಲ್ಲ ನೋಡಿ, ಮೊನ್ನೆದ್ ಯಾವ್ದು ಅದೇನೋ ಸಂಘದ್ದೊಂದು ಯಾವ್ದೋ ಐತಲ್ರಿ? ಪಾಸ್ ಅವ್ರ ಇದೆಯಾ ಈಗ? ಯಾವ್ದಿದೆ ಪಾಸ್ ಅವ್ರ ಫಸ್ಟ್ ಇಂದ ಇದೆಯಾ? ಕರೀರಿ.
This one, passport matter, serial number 9, it's Shivaramu.
ಇಲ್ವಾ? ಅವ್ರೇನ ಏನೋ ಬೆಳಿಗ್ಗೆ ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ರಿ ಏನೋ?
ಮಧ್ಯಾಹ್ನ ಏನೋ ತಗೊಳ್ಳಿ.
ಟೈಮ್ ಕೊಟ್ರೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀವಿ ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. ಸ್ಟೆಪ್ಸ್ ಟು ಬಿ ಟೇಕನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ R1 and R3 ಫಸ್ಟ್ ಟೈಮ್.
ಹೌದು.
ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೆಂಟ್ seeks 1 week time to take steps and hence 1 week time granted to take steps. List this matter on. ವಾರ ಬಿಟ್ಕೊಡಿ.
PF ಕೊಡ್ಬೇಕು ಇದ್ರಲ್ಲಿ.
PF ಕೊಡ್ಲಿ ಮೇಡಮ್. ಸ್ಟೆಪ್ಸ್ಗೆನೆ ಒಂದು ವಾರ.
14/11.
14/11. Next. 17
70?
ಪಾಸ್ ಓವರ್ ಆಗಿರ್ಬೇಕು.
Serial number 70.
17.
R.V. Sadashivappa.
ಹಾ. ಏನಾಯ್ತು ಅದ್ರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಾಯ್ತು ಅದರಲ್ಲಿ?
Amendment
ಮಾಡಿದ್ರಾ?
ಮಾಡಿದೆ.
Non-amendment of cast title in respect of deceased R12. The appellant counsel submits that they have carried out the amendment
Amended.
and also complied with the office objections in respect of the amended cast title in respect of deceased R12. ಎರಡು ಮಾಡಿದ್ರಲ್ಲ?
ಮಾಡಿದ್ದೀನಿ.
ಹಾ. ಅಷ್ಟೇನಾ? ಇನ್ನೇನು ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
ಕನೆಕ್ಟೆಡ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವರು ಮಾಡಿದ್ರು.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆಯಲ್ಲ? ಮಾಡಿದೀರಾ? Awaiting service of first time notice to LRs of deceased R3 na ಅದೇನ್ ಮೇಡಮ್?
R3
Notice
ಅವರು
ಹೋಗಿದೆಯಾ?
ಐ ಥಿಂಕ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಎಂಟರ್ಡ್ ಅಪಿಯರೆನ್ಸ್
ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
ಯಾರು?
ವೇಣು ಅಂತ ಏನೋ ಹಾಕಿರ್ಬೇಕು.
ಯಾರು? ವೇಣುಗೋಪಾಲ್ ಫಾರ್ ಪ್ರಪೋಸ್ಡ್ R2 A to C ಅಂತಿದೆ. ಈ IS ನೋಡಿ ಮೇಡಮ್, A to C ನ ನೋಡಿ. Deceased R3 and IA number 3 ನೋಡಿ. ಈ ಮೇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇವರೆಲ್ಲ ಬಂದಿದಾರ ರೆಕಾರ್ಡ್ಗೆ?
ಬಂದಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಬಂದಿಲ್ಲ. ಕ್ರಾಬ್ ಅಲ್ಲಿ
ಅದರಲ್ಲಿ ಕ್ರಾಪ್ ಅಲ್ಲಿ ಇದೆ. ಅದೇನು
ಕ್ರಾಬ್ದು ಅಲೋ ಮಾಡ್ಬೇಕಲ್ಲ. ಕ್ರಾಬ್ ಅಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್. A number 323 to 5 of 23. LRs of R2 na?
R3.
Huh?
LRs of R3 ಅಲ್ವಾ ಸರ್?
LRs of deceased
R3.
R3 ಅಂತಿದೆ. ಇವರು ವಕಾಲತ್ ಹಾಕಿರೋದು ಯಾರು? R2A. 3 ಯಾರಿಗೂ ಹಾಕಿಲ್ಲ.
ವೇಣುಗೋಪಾಲ್
3 ಯಾರಿಗೂ ಹಾಕಿಲ್ಲ. ಅವ್ರು R2 ಹಾಕಿರೋದು.
ಸರಿ.
ಈ ನೋಟಿಸ್ ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್. ಇದ್ರಲ್ಲಿ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂಡ್ ನಾನ್ ಅಮೆಂಡೆಡ್ ಟೈಟಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ LRs ಆಫ್ ಡಿಸೀಸ್ಡ್ R2 ಆಲ್ರೆಡಿ ಅಲೋ ಆಗಿದೆ. ನಾಗರಾಜ ಯಾರು? ನೀವಾ ಅಮೆಂಡ್ ಮಾಡಿದಿರಾ? ತಗೊಳ್ಳಿ. ಕ್ರಾಬ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ he has amended the caste title and filed amended caste title in respect of LRs of deceased R2. ಈ ನೋಟಿಸ್ ಯಾವಾಗ ಹೋಗಿದೆ ನೋಡಿ ಇವ್ರಿಗೆ.
R2 is represented by an
2004-2005
Venugopal.
R3 ನೋಟಿಸ್ ಯಾವಾಗ ಹೋಗಿದೆ?
ಇಟ್ಟಿಲ್ಲ ಸರ್ ಅದು. ಏನು ಇಟ್ಟಿಲ್ಲ ಇಲ್ಲಿ ಇದನ್ನ.
ಅವೈಟ್ ಅಂತ ಹೆಂಗ್ ಬರುತ್ತೆ? ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ ಹೋಗ್ಲಿ? A number 3 of 23 to
ಸರ್ ಇದು 1410 ಅಲ್ಲ ಆಗಿದೆ. 1410-24 ಅಲ್ಲಿ.
1410 ಅಂದ್ರೆ ಮೊನ್ನೆ ಇಶ್ಯೂ ಆಗಿರೋದು ಯಾವಾಗ?
ಅದೇ ಸರ್, ಅದಕ್ಕೆ ಅವರು ಅದನ್ನ ಇಟ್ಟಿಲ್ಲ ಇಲ್ಲಿ.
ಬಿಟ್ಟಿಲ್ಲ. ಆಯ್ತು. ಅವೈಟ್ ನೋಟಿಸ್ ಆಫ್ LRs of R3 ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. 14 ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಕೊಟ್ಟಿರಿ.
19.
14 ಮತ್ತೆ 14 ಕೊಡಿ. 1411 ಅದು ವೆರಿಫೈ ಮಾಡಕ್ ಹೇಳಿ ಏನಾಗಿದೆ ಹೋಗಿದ್ದು.
28.
ಹ್ಮ್
28 ಬಂದಿದೆ.
28. ಕೊಡ್ರಿ.
On the last occasion, when Lordship was pleased to ask us, what steps have been taken to convene, to intimate the members of the Sangha?
Complaints of condition
Yes,
number
yes.
3. Directed to produce the documents. ಕೊಡಿ ಅದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ.
Can I place it on record, madam?
ಅವ್ರೇನ್ ಕೊಡ್ತಾರೆ ಕೊಡ್ಲಿ ನೋಡಿ. ಆಮೇಲೆ ನೀವು ಕೊಡಿರೋದು.
ನಾವು ಅದನ್ನೇ ರೆಡಿ ಮಾಡ್ಕೊಂಡು.
ಅದಕ್ಕೆ ಒಯ್ಯುದು. ಮೇಡಮ್. ಮೇಡಮ್ ಪೇಜ್ 31 ಮೇಲೆ.
ಈ ಕೊಟ್ಟಿರೋ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ 31
ಹೌದು, ಈ ಕೊಟ್ಟಿರೋ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ.
ಹಾ.
Document number 8. 86 advertising to whomsoever it may concern. we AD6 advertising confirm that we have published public notice as per your requirements. The notice has been disseminated in Vijay Karnataka Kannada Daily Karnataka edition, Prajavani Kannada Daily Karnataka edition, the Times of India English Daily Karnataka edition, Deccan Herald English Daily Karnataka edition. Date of publication so and so. Rachama kindly see my lord, document number 9.
ಏನ್ ಅಡ್ವರ್ಟೈಸಿಂಗ್ ಲೆಟರ್?
Advertisement.
ಹಾ.
ಇದು 9 ಬಂದು amount paid by the respondents 1,72,000 so and so for advertisement.
For advertisement.
Yes, my lord. The next document is also my lord, payment of 1,77,000.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರಾ?
ಮಾಡಿದೀವಿ.
ಹಾ ಸರಿ. ಹಾ.
Then my lordship kindly come to document number 11. This is for videographing the proceedings of 2210. Live ತೋರಿಸ್ಲಿಕ್ಕೆ. The amount paid is 3,86,000 and so total amount paid is 4,55,480. YouTube ಮತ್ತೆ Facebook ನಲ್ಲಿ publication ಮಾಡ್ಲಿಕ್ಕೋಸ್ಕರ meeting 2210 ಅನ್ನ. Then page 36. This is Times of India dated 19/10/2024. Just I will read my middle ಅಲ್ಲಿ ಇದೆ public note page 36 ನಲ್ಲಿ public notice ಅಂತ ಇದೆಯಲ್ಲ. That the members
ಇದು ಯಾವ ದಿವಸದ ಪೇಪರ್ ಇದು? 1910.
Times 19/10/2024 ಇಸ್ವಿ ದಿವಸ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿರೋದು. Public notice that the members, general body of the Rajya Vakkaligara Sangha are hereby informed that the executive committee meeting of the Rajya Vakkaligara Sangha to discuss on the no confidence motion moved against the office bearers C.N. Balakrishna, President, Prakash, Vice President, Raghavendra, Vice President, Devraj, Hopcoms, General Secretary, Hanumantarayappa, Assistant Secretary, M.S. Umapati, Treasurer, is scheduled to be held on 22/10/2024 at 11 a.m. The same shall be live streamed in the following social media channels for the members, general body of the Sangha to enable and to facilitate the viewing of the executive committee meeting proceedings by the members of the general body. Social media links, so and so, this is social media. Publishing undertaken by the below executive committee members, Kenchegowda, Srinivas, Maregowda, Ashok, Rajashekara Gowda, Hanumantaya, Suresh, Venkatramaya Gowda, Narayan Swami.
ಇವರೆಲ್ಲ ಏನು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರು ಅಂತ?
ಇವರೆಲ್ಲ ಮಾಡಿರೋದು.
ಆಯ್ತು.
Since they did not call for the meeting. Then Deccan Herald, page 1910 to 2020, ಇದು same ಏನೆ. Then my lord, ಪ್ರಜಾವಾಣಿನಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ಸೇಮ್ ಕಂಟೆಂಟ್ಸ್ ಅಲ್ಲೂ ಸಾಮಾಜಿಕ ಮಾಧ್ಯಮದ ಲಿಂಕ್ಗಳನ್ನು ಸಹ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಇದರಲ್ಲೂ ಸಹ. Then another paper ವಿಜಯ ಕರ್ನಾಟಕ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ. Then my lord,
all dated 1910.
ಎಲ್ಲ 1910.
ಆಯ್ತು. ಹಾ.
Then it is most important, the next document. Once we have published this notification to the general public, Lashma kindly say it has been opposed by the appellants at page 40, document number 13. This is published on 21/10/2024. Just I will read this publication made by these appellants. ದಿನಾಂಕ 19/10
ರೆಫರೆನ್ಸ್ ಮಾಡಿ ಈ ತರ ಆಗಿದೆ, ಅದರಿಂದ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇವ್ರದ್ದು.
ಅಲ್ಲಲ್ಲ, ಮುಂದೆ ಓದ್ಬಿಡ್ತೀನಿ. 19/10/24 ಪ್ರಜಾವಾಣಿ ಮತ್ತು ವಿಜಯ ಕರ್ನಾಟಕ ಕನ್ನಡ ದಿನಪತ್ರಿಕೆಗಳಲ್ಲಿ ಮತ್ತು ಡೆಕ್ಕನ್ ಹೆರಾಲ್ಡ್ ಟೈಮ್ಸ್ ಆಫ್ ಇಂಡಿಯಾ ಇಂಗ್ಲಿಷ್ ದಿನಪತ್ರಿಕೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿ ಸದರಿ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಮಂಡಿಸಲಾದ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯದ ಬಗ್ಗೆ ಚರ್ಚಿಸಲು 22/10/74 ಕಾರ್ಯಕಾರಿ ಸಭೆಯನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ ಎಂಬುದನ್ನು ಪ್ರಕಟಿಸಿದ್ದು, ನೇರ ಪ್ರಸಾರವನ್ನು ವೀಕ್ಷಿಸಲು ಸಾಮಾಜಿಕ ಮಾಧ್ಯಮದ ಲಿಂಕ್ಗಳನ್ನು ಪ್ರಕಟಿಸಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ಈ ಪ್ರಕಟಣೆಯನ್ನು ಹೊರಡಿಸುವ ಅಗತ್ಯತೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಅದರನ್ವಯ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ನೀಡಲ್ಪಟ್ಟ ಕೆಲವು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸದಸ್ಯರು ಈ ರೀತಿ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ಹೊರಡಿಸುವ ಅಥವಾ ಸಭೆ ಕರೆಯುವ ಅಧಿಕಾರ ಹೊಂದಿಲ್ಲದಿರುವುದರಿಂದ ಮೇಲ್ಕಂಡಂತೆ ಹೊರಡಿಸಿರುವ ಪ್ರಕಟಣೆಯು ಅಸಿಂಧು, ಅಕ್ರಮ ಹಾಗೂ ಅನಧಿಕೃತವಾಗಿರುತ್ತದೆ. ಅಂತಹ ಪ್ರಕಟಣೆಯು ಕಾನೂನಿನ ಮಾನ್ಯತೆ ಹೊಂದಿರುವುದಿಲ್ಲ. ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕಟಣೆಯು ಸಭೆಯನ್ನು ವೀಕ್ಷಿಸುವ ಮತ್ತು ಸದರಿ ಪ್ರಕಟಣೆಯನ್ನು ಪರಿಗಣಿಸುವ ಅಗತ್ಯತೆ ಇರುವುದಿಲ್ಲ. ಈ ಪ್ರಕಟಣೆಯನ್ನು ನಿರ್ಲಕ್ಷಿಸಬೇಕಾಗಿ ಸದಸ್ಯರುಗಳಲ್ಲಿ ವಿನಂತಿ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 1/10/24 ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೊ ಆದೇಶ ಹೊರಡಿಸಿದ್ದು, ಮೇಲ್ಕಂಡ ಪ್ರಕಟಣೆಯು ಸದರಿ ಆದೇಶದ ತದ್ವಿರುದ್ಧವಾಗಿರುತ್ತದೆ ಮತ್ತು ಉಲ್ಲಂಘನೆಯಾಗಿರುತ್ತದೆ. ಅಧಿಕೃತವಾಗಿ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆ ಕರೆಯುವ ಬಗ್ಗೆ ಹಾಲಿ ಪದಾಧಿಕಾರಿಗಳು ಕರೆದಿದ್ದ 18/10/24 ಕಾರ್ಯಕಾರಿ ಸಭೆ ನಡೆದು ಸರ್ವ ಸದಸ್ಯರ ಸಭೆ ಕರೆಯುವ ಬಗ್ಗೆ ತೀರ್ಮಾನವಾಗಿರುತ್ತದೆ. ಅದರನ್ವಯ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಿ ಹಾಲಿ ಪದಾಧಿಕಾರಿಗಳು ಬೈಲ ಪ್ರಕಾರ ಅಗತ್ಯ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿ ಸಭೆಯ ದಿನಾಂಕವನ್ನು ಸರ್ವ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ತರಲಾಗುವುದು. ಆದುದರಿಂದ ಇಲ್ಲಿ the last portion which I have read, where is the decision to, where is the direction by this honorable court to call for the general body meeting? There is no such. How the members have to be notified about the proposed meeting? It is not clear about the order passed by the non-single judge. What is the findings of the non-single judge, my lord?
Let the general body witness the same.
How? Therefore, my lord, there are more than 5 lakhs members are there. According to my knowledge, my lord, so far, no general body meeting, convening the meeting of all the members in a particular place has not taken place at all. It is highly impossible to convene the meeting of 6 lakhs, around 6 lakhs in one place. It is highly impossible in Bangalore. Therefore, my lord, as per the direction of this honorable court,
ನಿಮ್ ಪ್ರಕಾರ 5-6 ಲಕ್ಷ ಜನ ಇದಾರೆ. 3 ದಿವಸ ಮುಂಚೆ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆಲ್ಲ ಕಮ್ಯುನಿಕೇಟ್.
therefore, here, my lord, it has been viewed.
Your publication is 1910. And you called the meeting on 22nd.
But it has been,
How can 6.5 lakhs general
Rashma,
body
kindly,
members
it has
can
been viewed, it has been
witness
viewed.
this, view this?
Rashma, the other, ಅದನ್ನು view ಮಾಡಿದಾರಲ್ಲ. Rashma, kindly see the other document which I have produced the other day, document number 11, page 59. And moreover, the members have no say at all in the meeting, only for viewing purpose. I can understand if they have got any right to say, ನೀನ್ ಮಾಡಬೇಡಿ ಗೀಡ್ ಮಾಡಿ ಅಥವಾ vote ಮಾಡೋ ಪವರ್ ಅವ್ರಿಗಿಲ್ಲ, only for the purpose of viewing. Page 59, madam, document number 11.
The order is also very clear. Only the executive members have to participate in voting, and other general body people have to witness the proceedings.
Plaint is otherwise, according to the plaintiff, my lord, the
That is
general
the
body
condition,
meeting
that is
has
the
to be
condition.
convened at that. That is not the direction issued by this honorable court. If so, my lord, then the learned judge who has passed this order, he has to interpret that order. Whether it is the intention in the mind of this honorable court that the general body meeting has to be called, or only issuing notice like this, then this has to be clarified by the judge who has passed the order.
Shall I place this matter also before the very same
Better,
court?
my lord, I think. It can be. Let us know what is the mind of the learned judge, my lord.
Let the very same judge decide the same.
The Honorable Supreme Court said is copy for the judge who has passed the order.
ಏನಂತಿದೆ ಏನ್ ಯಾವ್ದು ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಹಂಗಂತ
ಅಲ್ಲ ಇದರಲ್ಲಿ
ರೋಸ್ಟರ್ ಜಡ್ಜ್ ಬಿಟ್ಟು ಆ ಜಡ್ಜ್ ಮುಂದೆನೆ ಹೋಗ್ಬೇಕು ಅಂತಿದ್ಯಾ? ರಿಟ್ ಪಿಟಿಷನ್ ಮಾತ್ರ ಅವರು ರೋಸ್ಟರ್ ಅಷ್ಟೇ.
ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾತ್ರ ಅಷ್ಟೇ, ಇಂಟರ್ಪ್ರಿಟೇಷನ್ಗೆ.
ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಇದನ್ನು ಕಳ್ಸೋಣ, ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡ್ಲಿ ಅವ್ರು.
ಆಗ್ಬೋದು. ತೊಂದ್ರೆ ಇಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಏನ್ರಿ
absolutely no question of interpreting anything the order of the learned, honorable justice.
Why you have fixed the date for December?
No, my lord, that's what last occasion we said. If your lordship feels that it is unreasonable, tell us, my lord, on 30th November, we are prepared to fix the general body. Because the bylaw says.
Now date is fixed for the December.
8/12 we fixed it.
8/12.
Wanted to prepone it. On 30th, we are going to convene. Why we have fixed 8/12 is under class 17 of the bylaw of the society. After the notice is served, there must be a 21 days gap between the notice and the general body. Keeping that provision in the mind.
ನಿಮ್ ಪ್ರಕಾರ ಜನರಲ್ ಬಾಡಿ 18ಕ್ಕೆ ಆಯ್ತು.
ಜನರಲ್ ಬಾಡಿ ಅಲ್ಲ ಅದು.
ಅಲ್ಲ ಬೇಡ.
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕಮಿಟಿ
ಮೀಟಿಂಗ್ ಆಯ್ತು. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕಮಿಟಿ ಮೀಟಿಂಗ್ on 1810.
Correct.
Then why you fix the date on 8/12?
ಅದ್ರೊಳಗೆ ಅದೇನೆ ನಾವು ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಾದ್ಮೇಲೆ ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ 21 days ಗ್ಯಾಪ್ ಇರ್ಬೇಕು ಅಂತ ಬೈಲಾ ಹೇಳುತ್ತೆ. ಅದನ್ನ ಲೆಕ್ಕ ಹಾಕೊಂಡು ಮಾಡಿದ್ವಿ. ಎನಿಹೌ ಮೇಡಮ್, now we may not be imagined by your lordship that we are unreasonable. ಬೇಡ. Your lordship may kindly say 30th we are going to convene the general body. All steps will be taken within 1 week, notifying in terms of the bylaw. We will take out public notice in several newspapers. We will circulate the district head officers. We will affix the meeting notices on the head of the office of every district. Those are requirement under bylaw, we will comply with that. We are ready to file an affidavit. Impose any other riders, my lord, in terms of your lordship's order.
ಬೈಲಾ ಎಲ್ಲಿ ಯಾವ್ದಕ್ ಸಂಬಂಧಪಟ್ಟಂತ ಹೇಳ್ತದೆ? ಜನರಲ್ ಬಾಡಿ.
General body, class.
ಜನರಲ್ ಬಾಡಿಗೆ ಏನ್ ಕರಿಬೇಕು ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ.
No, no, what?
ಕೋರ್ಟ್ನವ್ರು ಜನರಲ್ ಬಾಡಿ ಕರೀರಿ ಅಂತ ಹೇಳಿಲ್ಲ.
That can.
ಹೇಳಿರೋದು ಏನಿದ್ರು ಜನರಲ್ ಬಾಡಿ ಲೆಟ್ ದಿ ಜನರಲ್ ಬಾಡಿ ವಿಟ್ನೆಸ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
May kindly see the order, my lord, how it is. If the petitioner or other members seeks to move for no confidence immediately,
ಹೌದು.
after the disposal of the writ petition, then as a special measure, notice shall be given by the secretary.
ಹೌದು.
Notice shall be given by the secretary to the general body of the respondent to witness the proceedings of the meeting and take appropriate decision bearing in mind such conduct of its members governing the society.
ಅಷ್ಟೇ.
My lord, on reading of
ಅವರು ನೋಡ್ಲಿ ಇವ್ರ ನಾಟಕ ಅಂತ ಬರ್ದವ್ರ.
ಅದೇನೆ ನೋಡ್ಲಿ ಅಂದ್ರೆ ಹೆಂಗ್ ನೋಡ್ಬೇಕು? ಇವಾಗ ಇವ್ರು ಅವ್ರು ಕೊಟ್ಟಿರೋ ಪ್ರಕಾರ
ಕಾರ್ಯಕಾರಿ ಮೆಂಬರ್ ಏನೇನ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲಾರು ನೋಡ್ಲಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
precisely the intention of the learned judge.
ಮುಂದಿನ ಎಲೆಕ್ಷನ್ಗೆ ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ, ಮುಂದಿನ ಎಲೆಕ್ಷನ್ಗೆ ಇವ್ರ ನಾಟಕ ಎಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ ಅಷ್ಟೇನೆ.
ಮುಂದಿನ ಎಲೆಕ್ಷನ್ಗಲ್ಲ, ಜನರಲ್ ಬಾಡಿ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್.
ಜನರಲ್ ಹಂಗಲ್ಲ, ಇಡೀ ಜನ ಎಲ್ಲ ನೋಡ್ಲಿ ಅಂತ.
ನಿಮ್ಮ ಅವತಾರಗಳು ಗೊತ್ತಾಗ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
ಇನ್ನೂ ವೈರಲ್ ಅವ್ರು ಇನ್ನೂ ಮ್ಯಾಗ್ನಾನಿಮಸ್.
ಈ ಒಕ್ಕಲಿಗರ ಸಂಘದಲ್ಲಿ ಮೆಂಬರ್ಸ್ ಗಳು ಏನೇನ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದು ನೋಡಿ ಗೊತ್ತಾಗ್ಲಿ ಎಲ್ಲಾರ್ಗು ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅದೇನೋ ಅವರವರಿಗೆ ಬಿಟ್ಟಿದ್ದು, ನಾನೇನು ಹೇಳೋದು.
ಇನ್ನೇನಾರಿದೆ ಹೇಳೋದು?
ಪ್ಯಾರ 8 ಅಲ್ಲಿ ಮತ್ತೆ ದೇಸೆ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ನಲ್ಲಿ ದೇರ್ ಕಂಟೆನ್ಸ್ ಮತ್ತೆ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಕರಿಬೇಕು ಅಂತ. ದಟ್ ಈಸ್ ನಾಟ್ ದಿ ಇಂಟೆನ್ಷನ್. ಬಟ್ ದೇರ್ ಕಂಟೆನ್ಷನ್ ನಾವು ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಕರಿಬೇಕು ಅನ್ನತಕ್ಕಂತ ಅವ್ರ ಇಂಟೆನ್ಷನ್. ಪ್ಯಾರಾಗ್ರಾಫ್ 8 ಆಫ್ ದಿ ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್. That is not the intention of the order passed by the Honorable Court.
General body by the secretary.
It never happens.
What happened ಅಂದ್ರೆ lordship said so. ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅವತ್ತು ಅದು ಬರಿಬೇಡಿ.
In addition to that, ಅಲ್ಲ ವಿಟ್ನೆಸ್ ಅನ್ಕೊಂಡಿದೀವಿ, ನಾವು ವಿಟ್ನೆಸ್ ಮಾಡಿದೀವಿ, ಅದೇ ರೀತಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿದೀವಿ.
ರಿಸರ್ವ್ಡ್ ಅಂಡ್ ಪಾಸ್ಟ್ ಅಂಡ್ ಆರ್ಡರ್ ಹೌದಲ್ಲ? ರಿಸರ್ವ್ ಅಲ್ಲಿ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲಲ್ಲ?
ಅಲ್ಲ, ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಸರಿ, ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಯ್ಯೇ ಹಾಕ್ಬೋದಲ್ವಾ? ಹಿಂಗ್ ಬರ್ದಿದೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇವ್ರಿವ್ರೇ ಎಲ್ಲ ಡಿಸೈಡ್ ಮಾಡಿದ್ರೆ ಎಂಟರ್ ಇನ್ ಟು ದಿ ಮೈಂಡ್ಸ್ ಆಫ್ ದ ಲಾರ್ಡ್ಶಿಪ್, ದೇ ಡಿಸೈಡೆಡ್ ಎವ್ರಿಥಿಂಗ್.
ಅವ್ರನ್ನು ಕೇಳೋಣ ಆಮೇಲೆ.
ಅವ್ರು ಕರೀತಾರೆ, ನಮ್ದೇನ್ ತಾಪತ್ರನೇ ಇರ್ಲಿಲ್ಲ, ಅವ್ರು ಕರೀಲಿಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ವಿ ಮೇಡ್ ಅ ಪಬ್ಲಿಕೇಶನ್ ಇನ್ ದಿ ನ್ಯೂಸ್ ಪೇಪರ್ಸ್.
ಇವಾಗ ಅವರು ಒಂದು
ಫಿಕ್ಸ್ ದಿ ಡೇಟ್ ಆನ್
ಅಲ್ಲ ಒಂದು ಕೆಲಸ ಮಾಡಿ ಸ್ವಾಮಿ, ನೀವೇನೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ವಿತಿನ್ ಸ್ಪ್ಯಾನ್ ಆಫ್ 10 days or 15 days ಅದ್ರೊಳಗೆ ನೋಟಿಸ್ ಮಾಡ್ಲಿ, ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರ್ಲಿ, ಇದು ಮಾಡಿ. ಯಾಕಂದ್ರೆ ಮೈನಾರಿಟಿ ಲಕ್ಷ್ಮಿ ಖಂಡಿಸಿ ದೇ ಆರ್ ಮೈನಾರಿಟಿ, ದೇ ಕೆನಾಟ್ ಟೇಕ್ ಎನಿ ಡಿಸಿಷನ್. ಲೆಟ್ ದ ಮ್ಯಾಟರ್ ಬಿ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ಲಾರ್ಡ್ಶಿಪ್. ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಫಿಕ್ಸ್ ಎ ಡೇಟ್. ವಿತಿನ್ ದಟ್ ಡೇಟ್ ನಾವ್ ಏನ್ ಮಾಡಿದೀವೋ ಅದೇ ರೀತಿ ಪಬ್ಲಿಕೇಶನ್ ಕೊಡ್ಲಿ, ಆ ದಿವಸ ವ್ಯೂ ಮಾಡ್ಲಿ ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿ ಸಂಘ.
ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಹೆಸರಿನೊಳಗೆ ಸಂಘದ ಹೆಸರಿನೊಳಗೆ
ಅಂಡರ್ ದಿ chairmanship of the
ಜನರಲ್ ಸೆಕ್ರೆಟರಿನೇ ಕೊಡ್ಲಿ ಬಿಡಿ, ಡೇಟ್ ಫಿಕ್ಸ್
ಅವರೇ ಕೊಡ್ಲಿ. ಅಂಡರ್ ದಿ chairmanship of the director of cooperative societies or any independent persons. Meeting shall be held in the under ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಾಮಿ, 15 ದಿವಸದ ಒಳಗಡೆ
ಹೇಳಿ. ನೀವೇ ಇಬ್ರು ಹೇಳಿ ಯಾವ ಡೇಟ್?
ಇವತ್ತಿಂದ 15 ದಿವಸ.
ಅವ್ರ 30th ನವೆಂಬರ್ ಅಂತಾರೆ. ಯಾವ ಡೇಟ್ ಬೇಕು?
15 days ಹೋದ್ರೆ
ಯಾವತ್ರಿ?
Let them witness either by way of media or electronic media or physical presence ಅಲ್ಲಿ ನೀವು ಹೇಗ್ರಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಮಾಡ್ತಾರಂತೆ.
ಫಿಸಿಕಲ್ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಲ್ಲೇನು ಯಾವ್ದಾದ್ರು ಆಡಿಟೋರಿಯಂ ತಗೋ
ಅಲ್ಲ ಮಾಡಿದಾರಂತೆ ಲಾಸ್ಟ್ ಟೈಮ್. ಫಿಸಿಕಲ್ ಅಲ್ಲಲ್ಲ, ಆಲ್ ಆಫ್ ದೆಮ್ ನಾಟ್ ಅಷ್ಟು ಜನ ಬರ್ಲಿಕ್ಕಿಲ್ಲ, ಎಷ್ಟು ಜನ ಬರ್ತಾರೆ ಒಂದು the whole idea is to call them
giving 21 days time
from today
with all riders whatever.
ಸ್ವಾಮಿ ಅದು 17th ಸಂಡೇ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡಿ. 17
ಬೈಲಾ ಪ್ರಕಾರ 21 ದಿವಸ.
ಅದೇನು ಬೇಕಾಗಿಲ್ಲ. ಲಕ್ಷ್ಮಿ ಕೈಂಡಿಸಿ ಹಿಯರ್ ದಿ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ ಮೈ ಲಾರ್ಡ್, ನಾಟ್ ಬೈಲಾ. ಬೈಲಾನಲ್ಲಿ ಇಲ್ಲ. ದಿಸ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ ದಿ ಲರ್ನ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಂಡ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ದಟ್ ಆರ್ಡರ್. ಬೈಲಾ ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ, ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. 17th. Last my candy fix 17th. Sunday. ಎಲ್ರು ಮನೆಯಲ್ಲಿ ಕೂತ್ಕೊಂಡು ನೋಡ್ಲಿ ಇವ್ರನ್ನ ಅವತಾರಗಳನ್ನ. 17th.
ಮೇಡಮ್ ಕ್ಲಾಸ್ 17 ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯ ನೋಟಿಸ್ ಅನ್ನು 21 ದಿವಸಗಳ ಮುಂಚೆ
ಸರ್ವ ಸದಸ್ಯರ ಸಭೆ not going to take any decision. First you understand that.
That's we have understood, madam.
Only the idea of this court to witness all the members of the general body. Alva?
That's what.
ಯಾವಾಗ 21 days ಬರುತ್ತೆ ಅಂದ್ರೆ ಜನರಲ್ ಬಾಡಿ ಟೇಕಿಂಗ್ ಆಫ್ ಎ ಡಿಸಿಷನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಎನಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಅಷ್ಟೇ. ಅದಿಲ್ಲ ಇಲ್ಲ ಹಂಗ ಆಗೋದಿಲ್ಲ. I will fix the date on 24th. You conduct on that.
Very well.
That is,
Yes, we will.
24th.
Yes.
ಮಾಡಿ.
24th 11th.
ಪೂರ ಏನಾಗಿಲ್ಲ ನೋಡಿದೆ ಇವತ್ತಾಗ್ಲೇ 6ನೇ ತಾರೀಕು.
ಹೌದು. ಇನ್ನು 18 ದಿನ.
17 ಬದಲು 24th ಮಾಡಿ. 24th ಮಾಡಿ.
Yes.
ಆಮೇಲೆ ಅಂಡರ್ ದಿ ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟರ್ ಆಫ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್
ಅದನ್ನು ಮಾಡೋಣ. Heard the matter. Heard the matter elaborately of the appellant's counsel and also the counsel appearing for the respondent. The moot point arised in this appeal is with regard to not complying of condition number 3 imposed by this court while disposing of the writ petitions. And appellants contend that they have already taken decision to discuss the issue of no confidence motion on 8/12/24. On the other hand, it is the contention of the respondents that they have already taken the decision on 22/10/2024, wherein no confidence motion was moved and also the same is accepted. Both the councils also submits that if it is not in compliance of condition number 3, this court can fix the date for the discussion of no confidence motion, fixing the date. And counsel for the respondent suggests the date for 17/11/2024. And counsel for the appellant would suggest the date as 30/11/24, contending that 21 days clear notice has to be given. This court has not accepted the contention of the appellant counsel, and general body is not going to take any decision in this regard. And only the executive committee members have to take the decision for decision of no confidence motion, and they shall vote in the said meeting. And only the indication given by this court while disposing of the earlier writ petitions that the general body members to witness this incident. One ನಿಮಿಷ ಅದೇನಿದ್ರೆ correction ಮಾಡೋಣ. Incident, witness this incident, and when such observation is made by this court and this court in the earlier disposal of earlier writ petitions, and also this court earlier granted interim order for selection of the office bearers based on the earlier decision of the respondents dated 22/10/24, and in view of the elaborate discussion and suggestion made by both the appellant's counsel and also the counsel for respondents, it is appropriate to fix the date on 24/11/2024 and fix the subject for discussion of no confidence motion already given on
3/10/2024.
3/10/24. The general secretary of the Sangha is directed to take immediate steps to publish the fixing of the date of 24/11/24 for discussion of the no confidence motion immediately in the state level papers and also the local papers. Beka?
ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಸಾಕು ಅಂತ
All these things are contemplated under bylaw 21. ಇದೆಲ್ಲ ಏನೇನ್ ಮಾಡ್ಬೇಕಂತ ಇದೆಯಲ್ಲ, ಸ್ಟೇಟ್ ಲೆವೆಲ್ ನ್ಯೂಸ್ ಪೇಪರ್ಸ್, ಲೋಕಲ್ ನ್ಯೂಸ್ ಪೇಪರ್
ಬೈಲಾದಲ್ಲಿ ಆತರ ಇದೆಯಾ?
ಇದೆ, ಎಲ್ಲ ಎಲಾಬೊರೇಟ್ ಆಗಿ ಇದೆ.
ಆಯ್ತು ಕೊಡಿ, ಲೋಕಲ್ ಪೇಪರ್ ಕೊಡಿ. ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್
ಲೋಕಲ್ ಪೇಪರ್
ಪರ್ಟಿಕ್ಯುಲರ್ ಯಾವ
ಆಮೇಲೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್
ಎಲ್ಲೆಲ್ಲಿ ಮೆಂಬರ್ಸ್ ಇದ್ದಾರೋ ಲೋಕಲ್ ಪೇಪರ್ಸ್ ಕೊಡ್ಲಿ.
ಲೋಕಲ್ ಪೇಪರ್ಸ್ ಹಾಗಾದ್ರೆ ಈಗ ಹೊರಗಡೆ ಇರಬಹುದು, ಎಲ್ಲಾ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲೂ ಇದಾರೆ.
ಹೌದೌದು.
ಇಲ್ಲ, ಒಂದು 5 ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬರ್ತಾರೆ ಅಷ್ಟೇ.
ಎಕ್ಸೆಪ್ಟ್ ಅಪ್ ಟು ಚಿತ್ರದುರ್ಗ ತನಕ ಇದ್ದಾರೆ.
ಹೌದು.
ನಾರ್ತ್ ಕರ್ನಾಟಕ ಜಾಯಿನ್ ಆದಾಗ
ನೀವೇ ಹೇಳ್ಬಿಡಿ ಇಬ್ರು, ಆಮೇಲೆ ಮತ್ ನಾನು ಅದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ,
ಓಲ್ಡ್ ಮೈಸೂರ್ ಏರಿಯಾ ಮೇಡ,
ಅದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳೋದ್ ಬೇಡ. ಎಲ್ಲ ಇಟ್ ಈಸ್
ಅಲ್ಲಿ ನನ್ನ ಪ್ರಕಾರ ಸ್ಟೇಟ್ ಎಡಿಷನ್ ಸಾಕು ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಸ್ಟೇಟ್ ಎಡಿಷನ್
publish the same in the state level paper to know the general body,
Members of the-
members of the Sangha, and they can participate through electronic media, and if those who are interested to can also participate in the
ಯೂಟ್ಯೂಬ್
huh?
ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ ಅವ್ರ ಲಿಂಕ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು.
ಅದೇ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾ ಅಂದ್ರೆ ಎಲ್ಲದು ಬಂದ್ಬಿಡುತ್ತೆ ಅದ್ರಲ್ಲಿ. ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾ ಅಷ್ಟೇನೆ. ನೀವು ಮತ್ತೆ ಆಡಿಟೋರಿಯಂ ಅವೆಲ್ಲ ಬೇಡ, ಯಾಕೆ
ಹೌದು.
ಬೇಕು? ಬೇಡ, ಬೇಕಾಗಿಲ್ಲ ಅಂದೆ.
ಬೇಕಾಗುತ್ತೆ ಅದು. ಅಕಸ್ಮಾತ್ ಬಂದ್ರೆ ಬರ್ಬೋದಲ್ಲ.
ಅಲ್ಲ,
ಇವಾಗ ನಾವು ಬೆಂಗಳೂರು
it opens a Pandora box because they cannot have any decision and they cannot discuss, and therefore it opens a Pandora box, not necessary. ಪೊಲೀಸ್ನವರೆಲ್ಲ ಕರ್ಸ್ಕೊಂಡ್ ಬರ್ಬೇಕಾಗ್ತದೆ.
ಮೀಟಿಂಗ್ ಮಾಡ್ತೀವಿ.
Unnecessary
ಬೆಂಗಳೂರು ಪ್ರೈಮರಿ ಮೆಂಬರ್ ವಾಂಟ್ ಟು ಪಾರ್ಟಿಸಿಪೇಟ್.
ಗಲಾಟೆನೂ ಆಗ್ತದೆ ಅಲ್ಲಿ, ದೊಡ್ಡ ಗಲಾಟೆ ಮಾಡೋ ಉದ್ದೇಶ
ಅಲ್ಲಿ
No.
ಇಶ್ಯೂ ಆಗೋದ್ ಬೇಡ,
ನಾವ್ ಬೇಕಾಗಿಲ್ಲ. ಗಲಾಟೆ ಆಗುತ್ತೆ.
ಇಶ್ಯೂ ಆಗೋದ್ ಬೇಡ ಅಲ್ಲಿ.
Yes.
ಗಲಾಟೆ ಯಾಕಾಗುತ್ತಲ್ಲ?
ಬೇಡ, ನಮಗ್ ಗೊತ್ತು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬೇಡಿ, ನಮಗೂ ಗೊತ್ತು.
ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾ and witness the said discussion ಆಯ್ತಾ? The discussion must be held in the presence of ಯಾರ್ ಬೇಕು ನಿಮ್ಗೆ?
ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟರ್ ಆಫ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್,
ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫ್ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಇನ್ಯಾರು ಬೇರೆ ಇದ್ರೆ ಹೇಳಿ, ನಮ್ಗೇನಿಲ್ಲ, ಅವ್ರು ಇವ್ರು ಅಂತ ಏನಿಲ್ಲ. ಬಟ್
presided by
by an impartial person, ಯಾರು ಹೇಳಿ?
Decided by impartial person.
ಅಷ್ಟೇ.
that is deputy
ಯಾರು ಅಂತ ಹೇಳ್ಬೇಕು. ಆಮೇಲೆ
deputy
ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಎನಿ ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅಡಿಷನಲ್ ರಿಜಿಸ್ಟ್ರಾರ್
ಯಾರಾದ್ರೂ ಆಗ್ಬೋದು, ನಮ್ದೇನ್ ತೊಂದ್ರೆ ಏನಿಲ್ಲ.
ಏನಾಯ್ತು ಹೇಳಿ? The
Chief Secretary ಅದ್ರ
discussion must be presided by the joint registrar of cooperative societies,
ಹೌದು,
cooperative
ಬೆಂಗಳೂರು
societies and
Bengaluru.
of the Bengaluru, and the Sangha also to take this decision immediately, communicate this order to the concerned joint registrar to present and preside in the meeting. ಆಯ್ತಲ್ಲ,
till then no decision will be taken.
Your honor, before 12th, I think it is better, your lordship is already decided.
ಆ ನೋಟಿಸ್ ಒಂದು
ಇಮಿಡಿಯೇಟ್ ಅಂತ ಹೇಳಿದೀವಲ್ಲ. ಯಾವ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಕೊಡ್ತೀರಿ? ನಾಳೆ ನಡೆದ್ರೆ
ನಾಳೆನೆ ಕೊಡ್ಬೋದು. ಮೆಟೀರಿಯಲ್ಸ್ ನಮ್ಮ ಹತ್ರಲ್ಲೇ ಇದೆ.
ನಾಡಿದ್ ಕೊಡಿ, ಇವತ್ತಾಗಲ್ಲ, ಈಗ ಹೋಗಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಇವತ್ತು ಬೇಡ.
8th ಕೊಡಿ.
Even 11th ಒಳಗಡೆ ಕೊಟ್ರು
ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ.
ಆಯ್ತು.
24th ಆಚೆ ಸುಮಾರು ಇನ್ನು 13 ದಿವಸ ಉಳಿಯುತ್ತೆ.
ಆಯ್ತು.
till then my lord, no.
ಆನರ್ ಬಿಫೋರ್
Secretary of the Sangha is directed to take out the publication in the state level papers on or before 11th,
Please.
November.
11/11/24.
2020.
ಆಗ್ಬೋದಾ?
Till then my lord, no financial decision any decision shall be taken by the present appellants. Appointments ಏನೇನು ಇದೆ. Now they have reduced minority.
24.
They have been reduced to
There are
minority.
several organizations we are sponsoring. Hospitals are we are running. ಆಮೇಲೆ ಅವ್ರು injection
15 ದಿವಸದಲ್ಲಿ ಏನ್ ಆಗೋದಿಲ್ಲ.
Medicines
ಅಲ್ಲ, ಅವರು ಸ್ಪೆಸಿಫೈ ಮಾಡ್ಲಿ ಏನೇನ್ ತಗೋಬಾರ್ದು ಅಂತ ನಾವ್ ಬೇಕಾದ್ರೆ ನಮ್ ಕ್ಲೈಂಟ್ ಅಡ್ವೈಸ್ ಮಾಡಿ ಐ ವಿಲ್ ಟೇಕ್ ಎ ರಿಸ್ಕ್.
Appointment ಏನೇನ್ ಮಾಡ್ಬೇಕು?
ಡೋಂಟ್ ಡೂ ದಟ್. ನೋ ಕೋರ್ಟ್
Appointment, contract ಈ ರೀತಿ ಏನೋ ಮಾಡೋದು ಬೇಡಿ.
Appointment,
Contracts.
ಹಾ.
And major financial decisions are not taken.
ಮೇಜರ್ ಫೈನಾನ್ಸ್
ಫೈನಾನ್ಸಿಯಲ್ ಡಿಸಿಷನ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Contract and tender and appointment.
Let them not take any decision regarding appointment
Tender.
and interesting the contract work.
Yes.
Interesting the contract work. ಹಾ.
ಅಲ್ಲ ಇರ್ಲಿ ಬೇಡ.
ಮಾಡದವಲ್ಲಿ ಬೇಡ. ಆಮೇಲೆ ಆಂಟಿಡೇಟ್ ಹಾಕ್ ಮಾಡೋದು ಬೇಡ.
ಹೌದು, ಅದೊಂದು ಅಬ್ಸರ್ವೇಷನ್.
It is made it clear that the Sangha not to take not to process any appointment and also interest any contract work during this period. List this matter on
25th or 26th.
24th ಬೇಡ, ಅವತ್ತೇ ಮತ್ತೆ
ಅಲ್ಲ, 25th or 26th.
27th ಹಾಕಿರ್ತೀವಿ.
ಆಮೇಲೆ
3 days
ಏನ್ ಪರ್ಚೇಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎನಿ ಪರ್ಚೇಸ್
ಅಂದ್ರೆ ಎಲ್ಲ ಬಂತು. ಆಮೇಲೆ ಸಂಘ ಹತ್ರನು ಹೋಗ್ಬೇಡಿ.
ಇರುತ್ತೆ. ಹಾಸ್ಪಿಟಲ್ ರನ್ ಮಾಡ್ಬೇಕು, ನೀವೇನೋ ಹಾಸ್ಪಿಟಲ್ ರನ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕಲ್ಲ, ಯಾವ್ದೋ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಕಿಮ್ಸ್ ಇರ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಅವೆಲ್ಲ ಸಣ್ಣ ಪುಟ್ಟದ್ ಇರುತ್ತೆ ಸಣ್ಣ ಪುಟ್ಟದ್ ಇರುತ್ತೆ ಅಷ್ಟು
Yes, madam. Grateful.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್
You are grateful.
ಇದೊಂದು ಟೈಪ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡೋಣ ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲೋಡ್ ಆಗ್ತದೆ 4:55 ಆಯ್ತು ಟೈಮ್ ನೆಕ್ಸ್ಟ್ ಯಾವ್ದ್ರಿ ಇವ್ರು ಜಯಲಕ್ಷ್ಮಿ ಏನ್ ಮಾಡಿರಿ ಹೇಳಿ
Delayed is.
ಹಾ
Citation ಕೊಡ್ತಾರೆ.
ತಗೊಳ್ಳಿ heard the appellant counsel in part the appellant counsel seeks time to file better affidavit ಅದೇನೋ
Better affidavit
ಆ affidavit ಮೇಲೆ ನಾನು
Please,
ಮಾಡೋದಿಲ್ಲ ಈಗೇನು affidavit ಹಾಕ್ತಾ ಇದೀರಾ
Affidavit ಅಲ್ಲ ಇದು, citations ಇದೆ.
citations ಆಮೇಲೆ ನೋಡೋಣ you file first better
Agriculture.
affidavit
I will file, madam.
better affidavit ತಗೊಳ್ಳಿ counsel seeks time to file better affidavit the counsel also placed the citations along with memo but ಇದ್ರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಇದೆ ಏನ್ರಿ ಗೌರ್ಮೆಂಟ್ ಇದ್ರಲ್ಲಿ ಆ ಪಟ್ಟಿನ ನೀವು ಕಾಪಿ ಸರ್ ಮಾಡಿಲ್ವಾ ಯಾಕೆ
ಅಡ್ಮಿಷನ್ ಬಂದಿದ್ದು ಇವಾಗ.
ಅಡ್ಮಿಷನ್ ಆಗ್ಲಿ
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಇನ್ನು.
ನೀವು ಫಸ್ಟ್ ಸರ್ಕಾರದ ಮೇಲೆ ಯಾವುದೇ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ನೀವು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
ಎಲ್ ಮಾಡಿದಿರಿ ಮಾಡಿಲ್ಲಲ್ಲ ತೋರ್ಸಿಲ್ಲಲ್ಲ ಇಲ್ಲಿ AGA ಹೋಗ್ಬಿಟ್ರ AGA is directed to take notice on behalf of the respondent state ಇರ್ಬೇಕು ನೋಡಿ and appellant counsel is directed to serve the copy of this appeal memo on the AGA forthwith. This matter on ಯಾವ್ದಾರ ಒಂದು ವಾರ ಬಿಟ್ಕೊಡಿ ಮೇಡಮ್ ಆಚೆಗೆ ಕೊಡಿ 15-11 ಬಟ್ ಇಮಿಡಿಯೇಟ್ ಕೊಡಿ ನೀವು ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ ಹಾಕುವ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು AG ಆಫೀಸ್ಗೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ
ಪ್ಲೀಸ್.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಮೇಡಮ್ 37
HC ಶಿವರಾಮು
ಇದೇನಕ್ಕಿದೆ ನೋಡಿ ಇದು ಮೋಸ್ಟ್ಲಿ RF ಕ್ರಾಬ್ ಅಂತಿದೆ ನೋಡಿ
ಇದು ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ ಇದ್ದಿದ್ದು ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಸರ್ ಇದು
ಇದಾ
ಟಾಸ್ಕ್ ಮ್ಯಾಟರ್
ಸರಿ ಇದಾಗಿದೆಯಾ ಅದು ಮೊದ್ಲಿನ RFA ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆಯಾ RFA 1071 of 2018
DD ಫೈಲ್ ಬಿಲ್ ಆಗಿದೆ
ಆಗ್ಲೇ DD ಆಗೋಗಿದೆ ಅದು ಮತ್ತೆ ಎಲ್ಲೋದ್ರು ಅವರು
ನಮಸ್ಕಾರ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಸರ್
ಹಾ
ಕೇಸ್ ನಮ್ಮ ಸಂಬಂಧ
ನೀವ್ ಯಾರು ಅಪಲೆಂಟಾ
1071 ನಲ್ಲಿ petition
ನೀವೇನ್ರಿ ಶಿವಕುಮಾರ್ ಏನ್ರಿ
ಅಲ್ಲ ಸರ್
ಮತ್ತೆ
ಮ್ಯಾರೇಜ್
ನಾರಾಯಣ ಮೂರ್ತಿ ನಿಮ್ ಲಾಯರ್ ಅಲ್ಲಿ
ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ಯಾರು ನಾರಾಯಣ ಮೂರ್ತಿ ಅವರ
ಹೌದು ಸರ್.
ಮತ್ ನೀವು ಬೇರೆ ಲಾಯರ್ ಇಟ್ಕೋಬೇಕಲ್ಲ
ಅದೇ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅದು ಈಗ ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿದ್ದಕ್ಕೆ ಒಂದ್ ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಂಡು ಬೇರೆ
ಆಯ್ತು ತಗೊಳ್ಳಿ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ಯಾರಾಜಾನ್ appears before the court and submits that the counsel SV Narayana Murthy is no more and seeks time to engage the counsel. Then madam ಇಲ್ಲಿ notice to R1 to R6 ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ ಇವ್ರು R1 ಇರ್ಬೇಕೇನ ಮೋಸ್ಟ್ ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ಟಿರ್ಬೇಕೇನ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಟು R1 to R6 ಅಂತ ಬರ್ದಾರೆ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಆಗಿದೆಯಾ
ಅದಕ್ಕೆ ಅವ್ರು ಅದಾದ್ಮೇಲಿಂದ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ
ಆಯ್ತು ಅಂಡ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ಎಂಗೇಜ್ ದಿ ಕೌನ್ಸಿಲ್ ಎಷ್ಟು ದಿವಸ ಬೇಕಪ್ಪ ಲಾಯರ್ ಇಟ್ಕೊಳಕ್ಕೆ 10 ದಿವಸ ತಗೊಳ್ಳಿ ಅಂಡ್ ಹೆನ್ಸ್ 10 days ಟೈಮ್ ಗಿವನ್ ಟು ಎಂಗೇಜ್ ದಿ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 19/11 19ನೇ ತಾರೀಕು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ ಅಂತ ಹಾಕಿ ಅಲ್ಲ ಇವರು ಕ್ರಾಬ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ 38 ಆಗೋಯ್ತಾ 39 ಆಗೋಯ್ತಾ ಇಲ್ಲ 39 ಆಗಿದೆ ಮೇಡಮ್ 29/11 ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಯಾರೋ ಏನೋ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ರಿ ಗೀತಾದೇವಿ MP ಅಂತ ಬೆಳಗ್ಗೆ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಫೈನಲ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳಿರಲ್ಲ 39 ಅರ್ಜೆಂಟ್ ಆಯ್ತು 38 ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಮಂಜುನಾಥ್ 38 ಆಗಿಲ್ಲ ನೀವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ಪಾರ್ಟ್ ಇನ್ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತಿದೆ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಅಲ್ರಿ ಏನಿದು
My lord, in this matter, as per direction of this honorable court, the respondents have sold the property. But the purchaser has obtained.
ರಾಧಾನಂದನ್ ಇದಾರಲ್ಲ ಆ ಕೇಸ್ ಆಯ್ತು
The
ಏನಾಯ್ತು
purchaser has obtained loan. Now registration is stopped. Due to.
who availed the loan?
My lord, purchaser has availed the loan. He issued DD. But registration is stopped.
ಏನ್ರಿ ಪರ್ಚೇಸರ್ ಯಾರು
Process is going.
Purchaser some software engineer.
ನೀವಿಬ್ರು ಸೇಲ್ ಮಾಡಿದ್ರಾ
ಹೌದು
ವಿತ್ ಕನ್ಸೆಂಟ್ ಅವ್ರ ಲೋನ್ ತಗೊಂಡ್ರಾ
ಅವ್ರ ಲೋನ್ ತಗೊಂಡ್ರು
ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅದ್ರ ಮೇಲೆ
ಒಂದು ಪ್ಲಾಟ್ ಮೇಲೆ
ಆಯ್ತು
ಈಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಸ್ಟಾಪ್ ಆಗಿದೆ
ಯಾಕೆ
ಈ ಖಾತಾ ಇಲ್ಲ
ರಿಜಿಸ್ಟ್ರೇಷನ್
ಹೌದು
ಯಾವ ರಿಜಿಸ್ಟ್ರೇಷನ್
ಈ ಪ್ಲಾಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಸ್ಟಾಪ್ ದಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಈ ಖಾತೆ
ಪರ್ಚೇಸರ್ ಅಗ್ರಿಮೆಂಟ್ ಹೋಲ್ಡರ್ ಅವ್ರಿಗಿನ್ನ ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ.
ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ, ಡಿ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು, ಬ್ಯಾಂಕ್ ಇಂದ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, SBI ಇಂದ. ಈ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಇಸ್ ನಾಟ್ ರಿಜಿಸ್ಟರಿಂಗ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಬಿಕಾಸ್ ಈ ಖಾತಾ ಇಲ್ಲ.
Khata is mandatory.
ಮತ್ತೆ ಈಗ ಮಾಡ್ಬೇಕಲ್ಲ, ಈ ಖಾತಾ ಇಲ್ದವ್ರು ಯಾವ್ದು ರಿಜಿಸ್ಟರ್ ಆಗ.
ಯಾವ್ದು ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ.
ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ ಈಗ ಬೇಗ?
ಒಂದು 4 weeks ಟೈಮ್
ತಗೊಳ್ಳಿ. ರೆಸ್ಪೆಕ್ಟಿವ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ 4 weeks ಟೈಮ್. ಇದು ಬಹಳ ದಿವಸದಿಂದ ಇದೀರಿ. And hence, and this is the matter of the year 2018 and hence this is matter. 4 weeks ಬೇಡ. 29 ಕೊಟ್ಟಿರ್ತೀನಿ. 29 almost 3 weeks ಆಗುತ್ತೆ. 29/11. 40 ಆಗ್ಲಿಲ್ಲ ಮೇಡಮ್. For want of time, list this matter on ಯಾವಾಗ ನೋಡಿ. 19/11. ಆಯ್ತು.
41 and 42.
42 ತನ್ವೀರ್ ಪಾಷಾ, ಅಭಿನಯ್ ವೈಟಿ, ಯಾವ್ದು RCT ಮ್ಯಾಟರ್ ಇದು. Both counsels are absent, list this matter on
2011.
43. ಯಾವಾಗ? 19/11. Want of time, list this matter on 19/11 ಅಂತ ಹಾಕ್ಬೋದು. 44. 19/11. 45. Want of time 19/11. 46. 20/11.
47.
47. 21/11. 48. 21/11. 28. 48. 21/11.
21/11. Obliged.
49.
59.
21/11.
50.
50. 21/11. 51 ಆಲ್ರೆಡಿ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. 52. 21/11. 53, 54 ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. 55 ಆಲ್ಸೋ ಅರ್ಜೆಂಟ್. ಅಷ್ಟೇ ಅಲ್ಲ, ಎಲ್ಲ ಅರ್ಜೆಂಟ್.
My lord, one submission, my lord.
ಹೇಳಿ.
My lord, Gulbarga matter, my lord, serial number 2 WP, my lord. Some technical issue, we are not able to attend at time, my lord. May please consider my presence, my lord.
Date already given, Gulbarga matter and
ಇದು serial number 1 date ಕೊಟ್ಟಿದೆ, my lord. ಅದು serial number 2
13/11 ಕೊಟ್ಟಿದೆ.
13. Thank you, my lord.
ಗುಲ್ಬರ್ಗದ 13/11 ಕೊಟ್ಟಿದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್, ಇದು WP ನಂಬರ್ 201604 ಮ್ಯಾಮ್. ಇದೆ ಗುಲ್ಬರ್ಗಾ ಮ್ಯಾಟರ್ ಮ್ಯಾಮ್.
13/11
13/11. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್.
ಹೇಳಿ.
ಮ್ಯಾಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 55 ರೀಚ್ ಆಗಿಲ್ವಲ್ಲ, ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರಾ?
21/11.
21/11. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಮ್ಯಾಮ್.
Date 44. It reached, twice it reached. Morning it was passed over. Then I called now at 4.